Good morning.
Good morning. Mr. Ott or Mr. Whitney, can you please tell me who's appearing from the panelists listed as SAO Director's conference room?
Mr. Gator, I'm not exactly sure who would be testifying from that location.
Okay, will it be used for witnesses?
It probably is going to
Okay.
be, but I'm not positive honestly, because I know the director was interested, but I think also they mentioned that there might be witnesses testifying from that location.
Good morning. I'm in the theater director's office. I was setting this up in case anyone came to the primary office.
Okay.
The majority of people are going to be on individual computers. This is more of a just in case for now.
Oh, okay, thank you. I'll just move this back to an attendee instead of a panelist, and then if needed, we'll bring you back in.
Beautiful. Thank you very much.
Thank you. Mr. Ott, Mr. Whitney, will you please start your video? Thank you. Just as a reminder, anybody testifying to the court needs to be within just a few feet of the camera. I noticed the conference room was pretty far away. So if there's a way to have that zoomed in, if anybody will be using it to testify today.
Robert, you're still on mute. Mr. Gaynor, is Mr. Whitney okay where he's at?
If there's a way to bring him in a little bit closer, that would be helpful.
Hey, Robert, maybe see if there's any Zoom capability. I don't know how much closer you can get.
I'll check and see.
Okay, thank you.
Mr. Gaynor, also, we've had our witnesses to join in. I know there's some talk about sequestration, but we figured that the judge may want to issue some sort of instruction to them at the beginning of the hearing. So they're, I believe, logging in.
Okay. All right. Thank you.
Mr. Gaynor?
Yes.
This was about as close as we could, the staff didn't have a Zoom capability. They pushed the camera closer.
Okay. All right. The court is aware, and the court is actually going to be coming on in just a few seconds. So we'll be getting started here shortly.
Thank you.
Thank you.
Okay, good morning, everyone. We're on the record in case number civil 20-755, Payne versus Detr. Before we state appearances, I'm glancing around the Zoom camera. I don't see counsel for petitioners. Ms. Gaynor, do we know what their status is, please?
No, Your Honor, I don't know what their status is. I do have an email pending, but I don't show them in as attendees just yet.
All right, we'll go off the record for approximately 10 minutes and find out if they're having any technical difficulties connecting, because I want to get the show on the road. We have a lot of ground to cover today, and I would like to start as close to 9 o'clock as we can. So I'll go off the record, and please, Mr. Gaynor, email, call, do whatever you need to inspire them to join, or at least get some information, please, for the court. We'll be in recess for approximately 10 minutes. Thank you, everyone.
and unmute. Okay, so this one, let me see if I.
Thank you. Mr. Thierman, I'm going to go ahead and change your name. And that was the confusion. For some reason, we're not coming under your names here. So I will let the court know, and we should be ready to go here shortly.
Thank you, Amanda.
Thank you.
Okay, let's go back on the record. All right, once again, good morning. We are on the record in the case of Amethyst Payne and others versus State of Nevada, Department of Employment Training and Rehabilitation et al., as we have been referring to it as the Detr case. This hearing today is occurring consistent with Nevada Supreme Court Rule Subpart 9 on hearings being conducted via simultaneous audiovisual transmission and various administrative orders of Nevada 2nd Judicial District Court, which have essentially closed the courthouse to in-person hearings on account of the global COVID-19 pandemic. We have previously had hearings in this manner, and I don't anticipate any logistics issues that would interfere. I'm Judge Breslow, presiding judge in Department 8, and I am actually appearing from the Washoe County Courthouse from Chambers. At this time, I ask counsel for petitioners to please identify themselves and confirm they can hear the court, starting with Ms. Jones. Good morning, Ms. Jones.
Good morning, Your Honor. This is Leah Jones for plaintiffs petitioners, and I am in Washoe County, Nevada.
Thank you very much.
And I can hear you.
Very good. Thank you. Co-plaintiff counsel, Mr. Thierman. Good morning.
Good morning, Your Honor. This is Mark Thierman, and I am also in Reno, Nevada.
All right, very good. Thank you. For State of Nevada, let's start with Mr. Ott. Would you please identify your name, where you are calling in from, and who your client is?
Greg Ott for the State of Nevada, and Detr calling in from Washoe County, Nevada today. I can hear all parties very well so far.
Very good. Thank you. Mr. Whitney, good morning.
Good morning, Your Honor. Good morning, everyone. This is Robert Whitney, State of Nevada in Clark County, Nevada. I can hear everyone fine. Thank you.
All right, very good. Thank you. And then who would like to identify the administrator of Detr, or actually ask the court would ask her if she wouldn't mind to please turn on her camera and identify herself.
Good morning. This is Elisa Caffaretta, and I am the director of Detr. I am in Reno, Nevada, and I can hear all parties. Thank you.
Very good. Thank you so much. All right, let's go over a few things preliminarily, because as everyone is aware, this is the time and date set for a hearing on petitioner's motion seeking the court to hold the state in contempt of the court's prior order of mandate directing that payments resume consistent with the prior order of the court. The court wants to mention a few things with respect to how the hearing will go this morning and a few related matters. Let's start with the related matters. For those of you watching at home who are not directly parties to this case, I encourage you, notwithstanding your very close and understandable interest in what happens here. But please refrain from emailing the court directly or any of the court's staff. Department 8, my department, has been receiving numerous direct communications from people who would like the court to know of their experience and their story. And while generally that type of information may have relevance to what we're doing here, it cannot be done in the manner in which people are doing it, which is to communicate directly with me or any of my staff. So I encourage you to stop sending emails and information to the court, because we do not review and consider that. We glance quickly to see what it is, and once we recognize that it's a document that ought not to be sent directly to the court does not consider it, does not impact the court's decision, and in fact, the court usually will either return it if it's mailed, or if it's emailed, it will be stricken. So please do not communicate directly with the court. Also, the court clerk's office has received at least one what's identified as an amicus curiae brief, a friend of the court brief with respect to these proceedings. Again, although the motive and intent of having the court understand better what's happening with that particular person, it's not the type of document that can be considered by the court. Indeed, amicus briefs generally are not proper to be filed in district court actions. They are for appellate actions, and even then only with court permission or agreement by the parties. Indeed, the court is aware that an amicus brief has recently been filed by Nevada Legal Services with the permission and consent of both sides here in a matter before the Nevada Supreme Court. That's how you do it. You don't file amicus briefs in district court. So to the extent that any have been filed in this matter, the court strikes those as improperly filed. Again, I'm not commenting on the substance. I'm not suggesting that the person or persons who are filing them don't have issues that need to be understood and possibly addressed. But this is the wrong form, the wrong time, and the completely wrong procedure. So please do not file or attempt to file any more amicus briefs in this case directly. All right, that's 2. 3. What is the status, please, Mr. Ott or Mr. Whitney, of payment of the first tranche of the special master's professional billings that the court directed to be paid on or about November 15th? Who would like to address that? Okay, I'm going to call on Mr. Ott. Do you have an understanding of the status, please?
I do not have a current understanding. I did have contact with the special master and asked him to get a vendor account established so that he could get that processed. My understanding is that everything has gone forward. I have not heard otherwise from the special master, but I will work on getting confirmation from that so that I can relay it to the court later on during the hearing, if that's acceptable.
I would appreciate that. And as well, if you would please file a notice with the court indicating that the first billings of the special master have been paid once you receive confirmation that payment has been made and received by him. I'm hoping that that can be filed this week because he's been paid. Directed he be paid on or about November 15th. But if there are reasons that it's in process that have delayed the process, I can be notified of that as well. But I'd really like there to be a filing by the state that says something like notice to the court that the special master's first billings payment has been made and received. And then the second one, as I recall, was ordered to be made no later than on or about December 30, 2020. So again, once that payment is made and received, Mr. Ott, if you would please file notice of that with respect to that matter. If the court believes that there's undue delay or delay without good cause, then the court will have a hearing and we'll get to the bottom of it. But Mr. Guanasso and his team greatly assisted the court in understanding the issues and providing background information and facts that assisted the court in its determinations in this case. So I want to get that buttoned up, and please make it happen. All right, next. It's come to the court's attention that either one or both sides here would like to exercise invoke the rule of exclusion, so that witnesses that have not yet testified today will not be reviewing, listening, or monitoring testimony before them, so it does not indirectly color their recollection or testimony. So let me start first with petitioners. Will the petitioners be invoking the rule of exclusion?
Yes, Your Honor. The one question I do have about that is if there's going to be any cross-examination and calling a witness back. I'd like to let our witnesses go after they have testified. So I just wanted to find out from the court and from defense counsel what their preference is so that our witnesses can be aware.
All right, well, that's a good question, and we'll talk about that in a moment, but I want to take the crossing one bridge at a time. So right now, rule of exclusion, if either side invokes it, the court orders it. So, but just for the record, Mr. Ott, Mr. Whitney, with the state otherwise being invoking the right, the rule of exclusion with respect to the petitioner's witnesses.
Your Honor, this is Robert Whitney. Yes, we would please invoke that rule.
All right, so let's talk about how logistically that happens in a Zoom hearing like this. So first of all, let's remind ourselves how it works if we were in the courthouse. If we were in the courthouse, witnesses who were expected to be called or otherwise under subpoena in the event of a party invoking the rule of exclusion would be directed to wait outside in the hall. And the court bailiff would call them in as their term came up. And after they were done testifying, and if counsel agreed, they could be free to go and not be subject to be recalled. They could leave or they could stay in the back of the courtroom and watch from that point forward. It's more difficult to monitor that in a remote hearing like this. What we have is potential witnesses for the petitioner, potential witnesses for the state. They're logged into this Zoom hearing, presumably. They're watching, and when it's their turn to testify, I will direct my court clerk to bring them forward to be sworn and to respond to questions from both sides and maybe from the court. And then if we agree to release them and not subject to be recalled for rebuttal or other purposes, then they're free to go. But it's very difficult to monitor them as being virtually out in the hall because they can be linked in and watching. And that, of course, subverts the rule of exclusion in the first place, which is designed to prevent people from observing other people's testimony with the goal of having them testify as to their own recollection, memory, and experience, and not piggyback on somebody else. So the way we've been doing it is this, and it's a bit unwieldy, but I cannot think of a better, more effective way. And that's this, counsel. The witnesses that you expect to call need to not be observing this court hearing until they are summoned to log on and then be called to testify. So what that means is, Ms. Jones and Mr. Thierman, because petitioners will be going first, is by your emailing to them or texting to them or this court's directive right now here in open court, they're all to log off this hearing. And I want to get the names of all the witnesses. I know you've each filed a notice of expected witnesses. but I want to make sure that my court clerk has that handy. And so she can tell if any of them are logged on and watching this hearing, because if they're expected witnesses, they should not be. Then when an attorney calls their witness, they won't know they're being called because they're not watching. So Ms. Jones or Mr. Thierman, one of you or your staff has to reach out to them quickly and say to witness number one, okay, it's your turn. Please log back on to the Zoom hearing. Once my court clerk sees that they are on the Zoom hearing, we bring them into the panel discussion and they testify. But until and unless they receive a communication from their lawyer that it's their turn to log on, they don't watch what's happening. They don't watch what's happening. And then same with the state's witnesses. They don't watch this hearing at all until and unless it's their turn to testify, in which case somebody from the state communicates with the witness logs on, they're called to testify, and when they're done testifying and they're released, then they can be in the background watching like everybody else. That's how we do effective sequestering of witnesses in the virtual courtroom situation that we're experiencing. So with that knowledge now, Ms. Jones and Mr. Thierman, let's start with you. Do you still want to invoke the rule of exclusion if you understand how it's going to work?
Your Honor, thank you. This is Leah Jones for plaintiffs. I'm not concerned about the state's witnesses listening to each other. It might be a good idea so that they can hear what their colleagues have talked about in case.
Ms. Jones, I'm not trying to be rude, but I got to move this along.
Sure.
Based on what you just heard, yes or no, do you still want to invoke the rule of exclusion? Because I've just told you how it's going to go. How it's going to go is all 16 or 12 or 20 of your witnesses cannot be logged on, and you or Mr. Thierman or your staff is going to have to reach out to them one by one and bring them in. Do you want to do it that way? Do you not want to, or do you want to think about it a little more? And I'll ask the state.
I have 3 witnesses. If the state wants to exclude them, we will have them log off and we'll have our assistant call as they are ready to testify and have them log back in. I don't need to, I'll waive the exclusion for the state's witnesses.
Okay, well then let's talk to Mr. Ott and Mr. Whitney. Now that you've heard that the petitioners will waive the rule of exclusion, and it sounds like they're politely asking the state to reconsider on account of, number one, they only have 3. Number 2, they're willing to waive it as to your witnesses. And number 3, you've just heard from the court how the approach would have to be for each of your witnesses or each of the petitioner's witnesses. So having heard all that, let's start with you, Mr. Ott. Would you like to reconsider your invocation of the rule of exclusion or stand by it? It doesn't matter to the court either way.
Thank you, Your Honor. Mr. Whitney will have the lead in presenting the case today, so I'll defer to his judgment on this.
Thank you. Mr. Whitney.
Your Honor, I'm sorry, I thought I was muted for a moment. I think based on what the court has said, the minimum amount of witnesses, what they're going to testify to, I don't think we will not invoke the exclusionary rule.
Perfect. You've made it much easier than on the logistics for the court, and I appreciate that. And please understand that, I'm not trying to back anybody off of their view, their position, their strategy. But the reality is how I've just said, because unlike in the courtroom, we can't tell if somebody's walked into the courtroom, and like we could if we were here in person. All right. So the rule of exclusion is not invoked by either side. All right, let's move on. Okay. Who can apprise the court? So we have, each side has taken an appeal. The appeal was dismissed. Then the court understands that each side has now re-appealed, and there is expedited briefing, or is that on a writ petition that the petitioner has filed and in which the amicus brief has been filed as well? Mr. Thierman, what's the status, please? So I believe you're still on mute.
Let me. We filed our opening briefs. I believe their state's briefs are due in about 2.5 weeks or so. And That's basically, it's not a writ petition itself. It is a appellate appeal from your order, or your denial and grant in part writ.
Got it. And that's what the Nevada Legal Services has filed its amicus brief in. Is that
Yes,
right?
Your Honor.
All right, thank you. Mr. Otter, Mr. Whitney, do you know any differently?
Your Honor, I do not. It's actually a different unit in our office is handling that appeal. Mr. Ott may have more knowledge on it than I do. But
No, Your Honor, nothing to add to what Mr. Thurman said.
All right, thank you. And the reason I ask is because as we've covered this ground before, while the initial appeal was pending and cross appeal and before it was dismissed and refiled, the court is divested of jurisdiction on substantive matters. The court has previously determined that it has the authority as part of its ancillary jurisdiction that remains, notwithstanding the appeal, to both monitor fee applications like those submitted by the special master, as well as to enforce its prior order of mandate, which is why we're having this hearing today. But in all other regards, all other material regards, substantive regards, the court believes it is divested of jurisdiction, and that's why this case will not currently be proceeding other than with respect to matters the court has retained jurisdiction on. Does anybody believe it's other than that? Ms. Jones or Mr. Thurman? Seeing shaking of the head. All right, Mr. Ott.
We agree with you.
Thank you, Mr. Ott. Mr. Whitney, any comments in that respect? No. All right, then let's get to the hearing. The petitioner is asking the court to find the state in contempt of the prior order of mandate. The briefing, the initial briefing and some supplemental briefing by the petitioners indicate that they believe there has been some level of compliance, but not complete unbridled compliance with the court order. And they're asking the court to hold the state today to answer to that concern and to, in the mind of petitioner, demonstrate to the court's satisfaction that there has not been compliance, substantial compliance, or failure to comply with justifiable excuse, and thereafter to hold the state in contempt. So the order of proceedings will be, I'll hear from each side, starting with petitioner, then the state, a very hopefully condensed summary of what they believe the evidence will show today, and then as well advise the court in their opening what they're asking the court to do. Obviously, the court is aware that the state is going to ask the court to deny the order to hold the state in contempt. That's an easy one. But with respect to Mr. Thurman and Ms. Jones, in the event they've convinced the court that the state is willfully violating the court's order of mandate, I want to know what exactly the remedy is that you are asking for and which statute or rule of procedure you believe entitles or authorizes the court to make such a determination. So let's start with petitioner. What will the evidence show today? What are you asking the court to do? And what authority do you base your request on? Who will speak first, please?
Good morning, Your Honor. This is Leah Jones for plaintiffs. Detr has already made multiple admissions that it has not complied with your July 22nd order. Your order was quite clear in that any applicant who had received a payment could not have payments withheld unless A, they did not file a weekly claim, B, the applicant had earnings in excess of what would have otherwise qualified the applicant for benefits, C, there was clear and convincing evidence of fraud, or until such time that the applicant was afforded an opportunity to be heard. Payments to these applicants was supposed to commence on or before Tuesday, the 28th of July. No applicants were actually paid by that date. An order from the court is not optional. Partial, even significant compliance is not actual compliance. A full month after the deadline of July 28th passed, on 8/31, Detr made the admission in their opposition to plaintiff's motion for contempt that full compliance of the July 22nd order and the time allotted was not possible, and it actually resulted in harm to the applicants. This harm continues for a universe of applicants who are subject to the order of between 11,741 to 22,036 people. During this hearing, plaintiffs will provide testimony from 3 separate witnesses that meet the court's requirements. And they have provided their portal documents as partial exhibits or exhibits for the court and Detr to look at to see that they do meet those requirements. These witnesses, these 3 witnesses, represent 11,000 to 22,000 real people who in many cases have not received any benefits for over 6 months. They should have been paid. They must be paid pursuant to the court's order. Plaintiffs request that Detr be held in contempt, and under NRS 34.290, that Detr is fined $1,000 per occurrence, and that if the court seems or feels that it's just, that a civil or criminal penalties should also issue. That is what plaintiffs are requesting today.
Thank you. Before I hear from the state, Ms. Jones, the $1,000 fine contemplated by Nevada Revised Statute 34.290, you mentioned per occurrence. So first of all, are you certain the law envisions per occurrence? And second, what's your definition under the unique facts of this case of what per occurrence means? Do you mean per person? Do you mean per week? Do you mean per day? Do you mean what? How exactly do you define per occurrence, please?
I apologize, Your Honor. That was an ambiguous term. It is our understanding under the statute that each person held responsible, each person, for instance, the director of Detr, the administrators are fined. We do not believe that Detr should be fined $1,000 per, for instance, if it is indeed 11,000 people, that they should be fined $1,000 for each of those people. I do not believe that that's what the NRS contemplates in that case.
All right, thank you. Then with respect to a further penalty, if the court finds justification, what are you suggesting the court invoke its authority under civil contempt, criminal contempt, or both? And if so, what remedy would that be? Because as the court understands, usually, even if the court is convinced after today's hearing that plaintiffs have proven that the state without just cause has failed to abide the court's order of mandate, the penalty would be a $1,000 fine, and then further orders of the court to recheck at some time in the very near future to see if there's continued failure, and only then for the court to take it to the next step. Because as I think we're all aware, the court has authority to put somebody in jail if there's willful noncompliance with a court order, if the person has the ability to comply and is failing to do so. And that's the classic case of giving the incarcerated person the key to their own jail cell. But that seems to the court to be an extreme remedy only in the event the court finds today that there's been a failure to abide the court's order without a legal excuse, and then B, given additional time to comply, and then an abject failure, that would be a possible remedy. Do you agree, Ms. Jones, or is that, do you disagree?
No, Your Honor, I do agree. I don't believe that the statute allows for the $1,000 per person, per occurrence, I guess, if you could say. But we had asked in our motion for contempt for you to publicly admonish Detr for their failure to comply with the court's order. As far as the jail term, I believe that that is part of a criminal contempt motion. And one of the cases that defendant cites to the Falstaff case talks about whether it's a civil contempt or a criminal contempt, and it turns on whether the contempt or has the actual ability to comply with the order. We believe they have, and so I think that if the court decides that it would be possible to have a criminal contempt and place somebody in jail. Again, you mentioned the willfulness, and I think that goes to the fact of whether they have the ability to. If they have the ability to comply with the order after you hear the evidence today, not just that it's taking them too much time or they don't have enough staff or some other excuse that isn't actual inability to comply with the order for some reason. I think that a criminal contempt and jail time would be warranted here. But at least if after the evidence is heard, if the court, in addition to the $1,000 fine, would also admonish Detr and let the people out there know that the court is willing to hold Detr's feet to the fire, so to speak.
Okay, thank you. All right, who would like to address the court from the state as to what they believe the evidence will show here? And then, although I am well aware that they strongly disagree that an order of contempt should issue, what they believe an appropriate response from the court should be in the event the court believes there's been a willful failure to abide its prior order. Mr. Ott, will you be speaking to that, or Mr. Whitney? Mr. Whitney.
Thank you, Your Honor. One thing, just really quickly, we do want to put on the record, I don't know if this is the time, we do object to the 3 witnesses testifying. Again, it's kind of a standing objection. I believe the court's aware of it because, again, there's these people are not the listed witnesses. It's proceeding as a class action, but there's been no class that's been certified. Moving to your specific question, Your Honor, we're here today to show that there was no way that Detr could comply with the court's order of mandate by the date set, which was July 28th of 2020.
Hold on one second. Sorry to interrupt you before I forget. Where was the motion for a stay? Where was a motion to reconsider? Where was a motion by the state for the court to amend its order to change the date? I don't remember having that motion brought before the court, briefed and decided. And if there wasn't such a motion, Mr. Whitney, why wasn't there?
Your Honor, I don't believe that there was such a motion that was brought before the court.
Let me get real here. If in a civil action, if there's a court order directing someone or some entity to do something, and the entity intends to comply, but then finds that they're unable through no fault of their own to comply with a court order, they don't ignore it. What they do is they ask the court to stay its enforcement of it, or they ask the court to amend it, or they ask the court to modify it, or they ask for a hearing to explain the efforts they've made and to get the court to agree that they will not be held in violation of the order if they fail to do it. But, right now I see the the plaintiffs saying, none of that happened, Judge. And so here we are months later. And so we have an order that hasn't been followed. I mean, Mr. Whitney, if you show to the court satisfaction that for reasons beyond Detr's own doing or own making, it was unable, as opposed to unwilling, but unable to abide the court's order, it seems to the court, this is asking for forgiveness rather than permission, which is really not the best approach. But anyway, so there's an objection to the 3 witnesses because they're not named plaintiffs. The case has not yet been certified as a class. There's been no motion filed to the court's understanding asking the court to amend or change its prior order, although the court is aware the order is on appeal. What else do you believe the evidence will show today?
Your Honor, I believe the evidence will show that Detr is in substantial compliance with the court's order. Can we say that it's in full compliance with the court's order? Probably not, but we are asking the court to hear the reasons why claimants that started to get paid by the payment was stopped in those cases. We believe that the evidence is going to show it's a really combination of reasons. It took Detr a while to get staffing going. Again, the claims were overwhelming in number. And also the fact that, again, as the court recalls, there was an agreement to implement PUA benefits that was signed some time ago by Administrator Kimberly Daugherty at the end of March. Again, Detr agreed to follow USDOL guidance, and USDOL guidance in some cases is going to result in Detr not paying claimants where the payments has started, but then stopped. Again, I think the biggest example that the court has probably seen or is familiar with is the situation, because it's been presented at least once before. I can't remember exactly when, but where, for example, U 1620, if you have a claimant that's being paid in PUA, but then becomes eligible for unemployment insurance, extended benefits, the pandemic emergency unemployment, then payments there have to be stopped. And there's other situations too where that guidance says that Detr has to stop paying people. And those would be reasons other than what the court's order mandates. So we'd ask the court to hear those reasons out. We also are prepared to respond. The court had mentioned that, of course, it's heard the three witnesses. We do have someone that's prepared to respond to their allegations here today. And we would ask that the court deny the petitioner's request here to find Detr in contempt, not only because Detr is in substantial compliance, but the court probably recalls defendant's argument that 34.290 calls for personal service. It doesn't call for service by electronic means. Notice is not personal service. There's case law citing that. We've cited to the Avro case. So it would be appropriate for the court to deny the motion for contempt in this case.
Okay, and again, I don't want to get too much into what the evidence showed and what the ultimate decision of the court should be. That's going to be for argument at the end of the evidence. But just to frame some of the issues the court has been considering, I've already mentioned a few, but Mr. Whitney, you heard Ms. Jones indicate that the plaintiffs believe that the evidence will show that between 11,741 people up to, at the low end, up to the high end of 22,036 people who otherwise should have been paid pursuant to the order of mandate have not yet been paid. Do you, with respect to those numbers, are those numbers you've heard before, seen before, or are you hearing them for the first time? And because does the state agree that that's the range of people, and then you have an explanation as to why they haven't been paid, or does the state have a different range of people?
Your Honor, we do have a different range of people. That's actually going to be presented in the testimony here today.
Well, what do you think the range is? What do you think the evidence will show in that regard?
Your Honor, from the documentation I have, it appears that it's the range might be a little bit larger than that amount, than the 10,000. But again, we are prepared to show why these people have not been paid.
Okay. Well, I appreciate your candor. All right. Well, I'll save my additional thoughts for later after I hear the evidence and hear further argument. All right. At this time, Ms. Jones, Would the plaintiff please call their first witness, identify their name, and then I'll ask my court clerk to bring them onto this meeting and be sworn.
Thank you, Your Honor. Plaintiffs would like to call Heather Boyd, B-O-Y-D.
Thank you. Ms. Clerk, if you see her in the waiting room, please bring her in.
She has been promoted to panelist.
Say that again.
She's been promoted to panelist.
Okay.
Should be.
All right, Ms. Boyd, if you can hear the court, if you would please unmute yourself and turn on your video. Ms. Boyd, if you can hear the court, please turn on your video and unmute your microphone. While we're waiting for that, Mr. Thierman and Ms. Jones, you've heard, again, from Mr. Whitney and from the state, their objection to the court hearing evidence from people that are not named plaintiffs from the, I'm going to use the phrase, putative class. And this is ground we've covered before as to why the court issued, a writ that had statewide reach, and the thoughts of the court on that this is one of those unique cases where the alleged harm is capable of repetition, yet evading review. But, I want to make sure, Ms. Jones and Mr. Thierman, nothing has changed from the plaintiff's view that the court is authorized to continue, thusly, because we can spend all this time and you might get the relief you're seeking today or later. But if 4 out of 7 justices, if they all hear it, or 2 out of 3, if they hear it, decide that this court lacked the jurisdiction to proceed as though this case was a putative class or had other exceptional circumstances to allow this type of relief, then this has been an interesting intellectual exercise, but didn't actually accomplish anything for plaintiffs. So, have you reconsidered? Are you doubling down? Do you stand by the position you've previously taken? Because, I want to make sure that your belief and the record are clear as to why the court has authority to go forward in this manner, notwithstanding the objection from the state. So, Mr. Thierman.
Yes, Your Honor. And in the normal case, if the writ was brought to invalidate a statute and it was granted, it would invalidate the statute for everybody. The same thing applies here. That you ordered Detr to do something. It's not just these 6 or 9 named plaintiffs. It's to do this for a group of people. And therefore, we think your order is just fine. And I suppose if it's within the scope of this court's ancillary jurisdiction, we could do the motion for class certification, but I don't know if it's even necessary because we're asking for an injunctive relief on behalf of the people of the state of Nevada. And therefore, you've issued your order accordingly. It doesn't really require similarity, commonality, or anything like that. That's determined later if and when the injunction is not obeyed. And a writ is just an affirmative injunction. It really just is a mandamus. It's do something instead of not do something. But it's the same thing as if you had a statute and you declared it unconstitutional and they kept enforcing it. That's a violation of your order, whether it's the same people or different people. It's not unconstitutional for some and constitutional for others. It is unconstitutional. So yes, we're doubling down. I guess we can move for class certification, which I don't know how they could oppose it, but that's where we're at on that issue.
Okay, thank you. And I'm not inviting an oral motion for class certification, nor am I prepared to state now whether the court believes it would have even jurisdiction at this point, not because of the cross appeals, to even decide that. But I understand plaintiff's position. And I'll deem that to be the response to Mr. Whitney's objection to non-party witnesses even testifying at a hearing like this. But before I make a decision on that, Mr. Whitney, is there anything else you would like to add at this time?
Nothing else at this time, Your Honor. Thank you.
All right, thank you. The objection to the testimony of the three witnesses, assuming they're all non-named plaintiff witnesses that the plaintiffs believe will be informative to the court as to their entitlement to be paid benefits, but yet have not received benefits, allegedly in violation of the writ of mandate. Based on that, the objection is overruled. The witnesses may testify. Ms. Boyd, I appreciate you listening to us. At this time, I'm going to have you raise your right hand and take the oath of witness, which my court clerk will administer to you, and then you'll be answering questions under oath. Ms. Clerk.
You solemnly swear or affirm the testimony you're about to give in this case shall be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Thank you. Ms. Boyd, before I let counsel for the plaintiffs ask you questions, I want to ask you a few preliminary questions. First of all, is your last name Boyd, B-O-Y-D, ma'am?
Yes.
All right. And what county and state are you calling in from?
Washoe.
Okay.
West
And,
Washoe.
all right. And can you hear everything the court has said?
Yes.
All right. Thank you very much. Ms. Jones, you may proceed.
Your Honor, might be heard briefly?
Yes. One moment.
I think I'm going to take care of what you're going to ask, Greg.
Okay, never mind. Go ahead. If you're going to take care of it, Leah, I just wanted to make sure that somebody was taking care of it.
I think I know where you're going. So thank you for testifying today, Ms. Boyd. During the course of your testimony today, we're going to talk about your claim with Detr. Detr has a confidentiality agreement with claimants. And in order to testify today, do you waive that confidentiality agreement?
Yes.
Is that what you were going after, Greg?
Yeah, I just wanted to make sure that either she was going to voluntarily waive the protections under Chapter 612 or the court was going to find that it had been waived. And I wanted to make sure that happened at the outset before she kind of got too deep. So thank you, Ms. Jones, for taking care of that.
Yeah. And Ms. Jones, let's please be a little more formal. Please proceed.
Thank you. Is Mr. Gaynor able to do the screen sharing for exhibits?
Apologize for the delay. No, I'm unable to do that. Usually that's handled by counsel when you are presenting an exhibit.
Oh, no. I have screen share capability. Okay. That was my question. I apologize.
Well, don't start screen sharing until you tell the court what you plan to do and get the court's authority to do it after I give the state an opportunity to be heard.
Thank you. Ms. Boyd, can you tell us why you're here today, why you're testifying?
I got a little bit of my unemployment and then it just stopped. And I've never got any explanation of why. And I'm hoping to get them to continue to go back and pay me like they should have done all along. I'm just really confused on what happened.
Did you provide counsel with any of your portal documents?
All of them.
Your Honor, I would like to ask that Exhibit 1, which has been previously provided, be entered as an exhibit so that Ms. Boyd can talk about the documents that are part of her portal.
Thank you. Mr. Whitney, any objection to the publication of Exhibit 1?
Your Honor, no, those look like those documents all came from.
All right. Any objection to their being admitted?
No, Your Honor.
All right. Exhibit 1 may be published and admitted. You may proceed.
I have pulled out what has been marked as Plaintiff's Petitioner's Exhibit 1. Ms. Boyd, can you see that?
Yes.
Your Honor, can you see that?
Yes, thank you.
And Mr. Whitney, can you see that?
I can see that. Thank you.
Could you explain how you first applied for benefits?
I applied over the web for my unemployment in June.
When did you receive your first payment?
I also received it in June. But after that, I didn't receive any other payments or no explanation about anything. They sent me one payment of $9,400, I believe is what it was. It was given to me on a debit card.
Okay, some preliminary questions. Miss Boyd, what do you do for work?
I clean.
And do you receive a W-2 or are you what's called a private contractor?
1099 private contractor. And
did you, oh, I apologize.
Go ahead.
Did you receive any W-2 income from January 1, 2020 to the present?
No.
Did you receive any W-2 income between January 1, 2019 and December 31st, 2019?
No.
So when you say you're a private contractor, I'm going to assume you mean that you only receive 1099 income. Is that correct?
Correct.
When you provided your portal documents, did you provide all the documents that you had access to on your portal?
Yes.
I believe you said that you received your first payment in June. Is that correct?
Yes.
When did you apply?
I applied in June, probably about a week prior to that.
When did you stop working?
I stopped working in end of January, beginning of February of 2020.
I'd like to draw everybody's attention to the document that I have on screen here. It seems like, Miss Boyd, do you recognize this document?
Yes.
And what is this document?
I believe it's where there's this claim summary of my payment.
Okay. Right here it says 1. Do you know what that is referring to?
Oh, it's, I guess, the first payment that my first claim and the first payment they were paying me from.
Have you continued, you said you didn't apply until June. Do you know why it says February 8th?
They backdated it, I believe, because it asked me when was the last time I worked.
Okay. I'm going to.
So to my understanding, they backdated it and then they paid me all at once for week 1 through, I believe it's 21 or 22 was the payment I received in June for those weeks that I made claims for.
It's difficult to see with these screenshots, but Ms. Boyd, can you see the page that I have up on the screen there as payment summary?
Yeah, I can see it.
It seems to have these headings here that shows the week number, the week ending. Do you know what WBA means?
It's part of my unemployment benefits.
Okay. Do you know what earnings claimed means?
Yes, I believe I know what it means.
And what do you believe it means?
It means that anything that I might have claimed during that time of eligibility, I believe.
And do you know what total deductions means?
Yes, that's usually my taxes and stuff that are taken out.
How about stimulus amount?
That's the special thing they gave people because of the situation. They were giving extra money for certain weeks for the COVID.
Okay, and here it says payment amount. Do you know what that means?
That would mean a total of everything put together would be the total payment that I'm supposed to receive.
Do you know what this payment type means?
It meant you get paid by check. I believe is what the other one said, partial check or.
And how about the transaction number?
That was the transaction number of their, like when they paid me all at once, it was the same transaction number on all of them because it was in one payment.
Okay. It's difficult because we can't see those headings anymore, but we talked about that first one is as your week claimed, the date, your amount, whether you had any work in that week, your taxes withheld, if you received any of the $600 stimulus, the actual amount you were paid. It says your taxes were withheld. And then do you know if this number is the check number you received or the transaction number?
It could be the debit card number that they put it on to.
And you indicated that you received a lump sum, correct?
Correct. And it was weeks, I believe 1 through 21 or 22 that they paid me for all at once.
So this has weeks 1 through 7, and then we have 8 through 14, all the way up to 20, which I believe you said that's when you got your first your payment, correct?
Correct.
And those all have that payment number of 21126.
Correct. Yes.
Have you received any payments since that June 20th?
No.
Number?
Nope, just the one payment.
Have you continued to file weekly claims?
Yes, I'm up to, I think, 42 claims now, or 43. One or the other.
Okay. Has Detr ever sent you any information about requesting additional information or anything like that?
No, actually, I kept calling the assistant line from the phone number I'd seen that we were supposed to call, and I spent thousands of hours calling them. When I did get a hold of somebody, they gave me different things I needed to give, like the front and back of my driver's license, social security card. Then they asked for me to write a statement that I didn't leave the country. And then when I still didn't get it, I kept calling. And when I was able to get hold of them, I was like, okay, what is it you're going to ask for next? And one of the girls got a laugh. She goes, they haven't told us what to say for this week yet. I mean, it was kind of offending to me because it was like they were just telling people whatever Detr was telling them to tell us, but we are never really given any information of why we're not getting it, or it was just, it's been extremely frustrating.
Were you ever contacted by an adjudicator or referee before your payment stopped?
Nope. Sorry about that.
I have no further questions, Your Honor.
Thank you. Mr. Whitney, cross-exam.
Just really briefly, Your Honor. Ms. Boyd, do you remember applying? This is Robert Whitney, and good morning. Do you remember when you applied for the PUA benefits?
Do I remember when?
Yes.
Yeah, that was in June.
And do you remember filling out the form, the self-certification form?
I believe so, yes. It's been a while, but yeah, I believe so. I filled out anything that I was asked to fill out. I complied by giving them all the documents that they said we were going to need for it to apply.
Well, hold 1 second. Mr. Whitney, do you need the screen share during your examination, or can I have that pulled down. All right, thank you, Ms. Jones. All right, please continue.
Thank you. Do you remember Ms. Boyd being asked the last date you performed work on that form that you filled out for the benefits?
At this, right now, I'm not sure what the form said. It's been too long.
Would it surprise you if you had reported your last day of work on that form as April of 2019?
It only wouldn't surprise. I mean, that's the last time I worked, and I got a 1099 because I was working as a janitor for a church, but I was working past that, so I probably didn't quite understand the question. I thought it was asking me about the 1099, the last date that I worked, because that's the last income tax that I filed. The other jobs was just private people that I worked for over the years.
And the private people you worked for over the years, did you have any proof that you actually worked for those people?
I could get it if you would like me to, but no one's ever asked me for it.
But it wasn't submitted as part of you didn't submit that as part of the application process?
I didn't believe I had to ask because I was getting minimum. That's what they determined in the determination letter that you had sent me with, I guess, what information I had given you.
Well, thank you, Ms. Boyd. Those are all the questions I have.
Okay.
Redirect.
I don't have anything further, Your Honor.
All right, well, before we thank and excuse Ms. Boyd, because sometimes it's better to do it while it's fresh, while the witness is still on the stand. The court's getting the sense from the questions. Well, let me back up. Here's what the court thinks Ms. Boyd just said: that she works in the cleaning industry, that she submitted an application for benefits in June, that she was paid in June. She was paid about $9,400. The $9,400 appears to be the sum total of the amounts from February all the way to June. Some of them $181 a week, some of them $700. But anyway, it ended up $9,400. Then she received benefits in the form of a debit card. That was the singular receipt of any benefits that she acquired. She has continued to weekly submit applications for payment. She has, there's been no testimony about this, but I haven't heard that anybody believed that her situation involved clear and convincing evidence of fraud. I'm not understanding that anyone is suggesting she had excess earnings that would otherwise disqualify her from receiving continued benefits. And she has not appealed, apparently, or had an appeal set, much less heard. So I'm getting from the state that there might be issues with her initial application, which when somebody took a closer look, believed that she might not have provided all the necessary documentation to justify payments to be made. What I'm hearing from the plaintiff is she received payments and she checks all the boxes in the court's order of mandate. So she should have continued to be paid until and unless she was advised that it was going to stop, and then she could have availed herself of an appeal. So let me start with you, Ms. Jones. Is that what you're asking the court to take away from Ms. Boyd's testimony?
Yes, I did want to ask, thank you, Your Honor. I did want to ask Ms. Boyd, did you try to appeal at all, Ms. Boyd?
I didn't, because my claim, I kept putting it in, I kept accepting it. And I thought appeals was once they denied you, then you appeal it, but I was never denied.
Okay, thank you. Yes, Your Honor, I do agree with what you said.
All right. Well, what I said was what the court's to take away from this. So, Mr. Whitney, what would you like the court to know? I mean, it sounds like, based on your questions, that there were some there might have been some errors or confusion or other information that might have rendered her ineligible or ineligible for the amounts or at the times and so do I have that right so far?
Your Honor, yes, I agree with you. You do have that right so far. We do have a witness that's coming up to testify about this, and we also have an exhibit to go with it that we submitted. One thing, Your Honor, I don't know if I should bring this up now. I'm going to have to get somebody we're going to have to maybe break for a little bit when the state presents its evidence, because I'm not quite sure how to set up a screen. This is a little bit different system, how to set up a screen share on this particular system.
Okay.
I know all my witnesses have the exhibits. I know petitioners have the exhibits. So perhaps maybe I could get away. Maybe it might not be necessary to use the screen share.
Well, yeah, so here's the answer to that. Yes, we'll take a break, and I want to make sure everybody is that nobody's held back by technology challenges. So I want to make sure anything you want the court to review and consider, you have the opportunity to present. But let's assume for a moment that the evidence will show that Ms. Boyd, with respect to her application, the application was either incomplete or on closer inspection reveals she wasn't entitled to the 9,400 she got in June, or that there was missing information, or that she hasn't explained why it looks like she may not have worked since April of 2019 and therefore might not have a COVID-related reduction in income. One of several different reasons why she might otherwise not be qualified to receive benefits. With respect to the court order that if somebody began to receive them, is continuing to make the weekly application for payments, is not making too much money to price them out of the pandemic unemployment assistance payments, and there's no clear and convincing evidence of fraud. What should I know with respect to Ms. Boyd? I mean, did the state have any evidence that her application was fraudulent?
Your Honor, it depends on. Well, no, I'm sorry. I'm going to say there's no evidence that it's fraudulent. The court did hit on one of the points that our witness will expand on later on this afternoon, and that is, as the court is aware, to get PUA, your employment's you're going to have to stop working, or substantial impairment to your employment to be eligible for PUA.
Yes.
It's saying that they haven't worked since April of 2019. That's well before PUA.
Well, no, but again, we're not here. I'm not an appeals officer or a hearing officer where somebody is challenging the denial of benefits. If I'm an appeals officer and if somebody says I deserve benefits and the state says no, you don't, or you don't deserve them in that amount, or you don't deserve them for that period of time, that's an apple. But what we're here to do today is an orange. And the orange is to decide if somebody who began to receive payments and then had them stopped, it was stopped for one of the reasons that the court believed would justify them being stopped. But failing one of the reasons that the court's order of mandate addresses, the payments should have begun again until and unless there was a hearing where all this could be, reviewed and considered. But all right, I think so. Before we thank and excuse Ms. Boyd, Mr. Whitney, do you have any other questions for her in light of the fact that I just gave Ms. Jones an opportunity to ask another question regarding an appeal?
No, Your Honor, thank you.
All right, and Ms. Jones, based on any of the court's comments, any further questions?
No, thank you, Your Honor.
Okay, Ms. Boyd, I want to thank you for being here this morning. In a moment, we're going to de-promote you, and so you can observe and watch if you want to, or go do other things and learn what happens at a later time. So thank you very much for being here, and wish you good health during this holiday season.
You too. Thank you.
Thank you. Ms. Jones, please call the plaintiff's next witness.
Thank you, Your Honor. I would like to call Steve Kolznick as plaintiff's second witness.
Thank you. Ms. DeGaynor, when you see him in the waiting room, please promote him to a panelist.
Mr. Kolznick has been promoted, and I've asked him to start video.
All right, thank you. All right, Mr. Kolznick, when you can hear the court, please come online. And then please unmute your microphone.
Okay.
And would you please state your name?
Stephen Paul Kolznick.
All right, thank you very much. Ms. Clerk, would you please administer oath of witness to Mr. Kolznick?
Please raise your right hand. Do you solemnly swear or affirm the testimony you're about to give in this case shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. You may put your hand down. Mr. Kolznick, at this time, I'm going to invite Ms. Jones to ask you some questions. Ms. Jones, please proceed.
Thank you. Mr. Kolznick, during the course of your testimony today, we're going to be talking about your claim with Detr. Detr has a confidentiality agreement with claimants. Are you willing to waive that confidentiality so we can speak freely and openly about your claim?
Yes.
Thank you. When did you first apply for benefits, Mr. Kolznick?
I applied for UI benefits the end of March, and that claim was denied March 31st.
And how did you apply?
On the Detr UI website.
Did you provide counsel with documents from your portal to be used in the hearing today?
Yes.
Can you please explain to the court why you're here, why you had to apply for benefits?
After I was denied for that, I waited for the PUA program to become available at the end of May, and I applied for the PUA program at that time and was approved 2 days later on June 2nd.
You indicated that you applied for UI first. What is your profession, Mr. Kolznick?
Sports official.
A sports officiant, like a referee?
Yes, umpire referee, yes.
Between January 1, 2020 and the present, have you done any work as a sports officiant?
No, official.
Official, sorry.
Yes.
Between January 1, 2019 and December 31st, 2020, did you do any work as a sports officiant?
Yes.
And were you paid with a W-2, like a paycheck, or were you paid 1099 wages?
1099s.
During the period of time between January 1, 2020 and the present, did you have any jobs where you actually received a W-2, meaning that you had a paycheck from an employer?
Yes.
When did that happen?
I was employed by Empire Restoration from December 2019 until March 13th, 2020.
And why did you leave Empire?
I caught the flu really bad from someone in the office and I was out for 2 weeks, and by that time they had replaced me.
Okay. And in January 1, 2019 through December 31st, 2019, did you have any other jobs besides Empire where you actually received a W-2 or a paycheck from an employer?
Yes.
And when was that?
October to early December.
And where were you working?
Walmart Distribution Center.
Did you provide your W-2 income to Detr when you first applied?
Yes, I did.
And did you provide your 1099 income to Detr when you applied?
To the PUA, yes.
So just to be clear, you first applied for UI based on the fact that you had W-2 income.
Yes.
And why did you end up then changing over to PUA?
Because most of my income from 2019 was from sports officiating, and I qualified for that program based on their guidelines.
Did you ever receive any payments under the UI program?
No.
Do you know why?
I was denied. My claim was denied.
And that's when you applied for PUA?
That was a couple months later when the program actually finally became available in the state of Nevada.
Okay. And did you ever receive a PUA payment?
Yes.
When did you receive a payment?
June 16th.
And how many payments did you receive?
That one and 3 more.
Did you provide, can you see that on your portal when you go on your claim?
Yes, there's a summary of all my weekly certifications and when I was paid and what I was paid.
Your Honor, I would like to offer into the record what has been previously marked as plaintiff's exhibit number 2, Mr. Kolznick's portal documents. May we go ahead and share those now?
Not just yet. Mr. Whitney, any objection from the state?
No, Your Honor.
All right, they may be, they're admitted and you may publish them. Go right ahead.
Mr. Kolznick, can you see the screen I am sharing?
Yes.
Your Honor, can you see the screen?
Yes.
And Mr. Whitney, can you see the screen?
Yes.
Thank you. I'm going to try and get this so we can see it a little bit better. Mr. Kolznick, is that what you were talking about? About you made a motion with your hand that you could see your claims? Is this the document you were speaking of?
Yes, it is.
I'm going to scroll down a bit for everyone to see. It says the last week there, it says 37, dated 11/21/20. The other page includes, so we go from 28, scrolling down to 3, scrolling down to 1. When did you apply for PUA benefits?
May 31st.
It says here, number 1, 3/14/20. Do you know why your first week is indicated as 3/14/20?
I had W-2 earnings that week.
Okay. And then how about the next week is 3/21? That was before you applied for PUA. Is that correct?
Yes.
Do you know if your claim was backdated?
Pardon me?
Was your claim backdated that you know of?
Yes, it was backdated to the first week I was eligible for that program.
And was that something you did yourself or something Detr did?
When I filed my PUA claim, it prompted me to go back all the weeks that I was eligible, which I did. So I filed a weekly certification claim each week back to that date, 3/21.
Okay. And since that date, have you continued to file weekly claims?
Yes.
Have you ever received anything from Detr saying that they needed additional information or any fraud determinations or anything like that?
Not by a document, but yes, over the phone.
And explain to us what happened.
Well, I called the PUA 800 number and I finally talked to somebody and I was told I'm just referring to my dates here, that I may have been denied and I needed to upload my UI denial letter, which I did on 9/9. Then I spoke to another rep on 9/16, or excuse me, on or about 9/24, and she said, now you have to upload your driver's license, social security card, and proof of residence, which I did at that time.
Did your payment start back up?
No.
Did you appeal the fact that you weren't able to get any payments?
Yes, I appealed on 8/5/20, and as of this morning, that appeal has not had an initial review.
Okay, let me hit the pause button because I'm confused on the dates, Mr. Kolznick. Here's what I am led to understand. You applied either May 31st or June 2nd when your understanding is Nevada had then stood up its website to allow PUA applications to be submitted. Do I have that right?
So far about May 31st, yes.
On or about May 31st?
Yes, and approved on June 2nd.
Approved on June 2nd. And
Yes.
so on your May 31st application, your application was to go back in time to the date in March where you stopped receiving W-2 income. Is that
Yes,
right?
that's correct.
All right. So again, the June 2nd date is when you received a payment?
June 2nd is when I was approved for the PUA program. June 16th, I received the first payment.
All right, hold on.
Okay.
And was that a fairly large amount? In other words, like Ms. Boyd, did it include, several weeks worth all at once? So backdated amount, or was it just a week or two?
It was a large amount, including all the backdated weeks.
All right, so what to your memory, about what amount was that you received on or about June 16th?
A little bit over $11,000.
All right. So then I stopped you. So I'm going to unpause. So then what happened? When did you continue to apply weekly after that?
Yes.
And at some point you got through to the PUA helpline and were told to load your UI denial letter and then thereafter to download your driver's license, social security, other identifying information?
Yes, this is after the payment stopped.
Okay. Then when did you, sorry to hijack your examination, Ms. Jones, but I want to make sure I got what he said already. Did you say then that what happened on August 5th? I thought
August 5th, I filed an appeal for my PUA disqualification determination.
All right. So when did you receive a PUA disqualification determination?
August 3rd.
And what did they tell you was the reason?
I may have other program eligibility.
And what did you understand that to mean? UI eligibility or something else or what?
UI eligibility, yes.
And you believed, I guess, that they were wrong because you'd already received the UI disqualification letter?
Denial letter, yes.
Denial letter? All right.
Yes.
So you appealed that on August 5th?
Yes,
right?
Correct.
Has a hearing date been set?
No, it's still awaiting initial review.
All right. So then what happened on 10/16? Because I thought you indicated you received some more money October 16th and then three payments thereafter.
No, my first payment was June 16, and I received 3 more payments each subsequent week after that up until July 5th.
Okay, so the June 16th was the big payment of
Yes.
about $11,000, and the 3 payments after that, were they weekly?
Weekly, yes.
And about how much were those each?
$934.
All right, then they stopped
Yes.
because you received a notice that you were ineligible for PUA.
I received that notice about a month later on 8/3. Yes,
All right, and then you appealed that and you're waiting to have that appeal heard.
that's correct.
All right, have you continued to file the weekly applications for benefits even though you've been told you're no longer eligible?
Yes, up until and including that last Sunday, 11/28.
All right, I think so I'm up to speed now. Ms. Jones, you can continue and ask the witness any additional questions. Thank you for indulging me.
Thank you. Have you ever been able to talk to an adjudicator or any referee of any sort since your payments have stopped?
No,
Did you ever receive a letter saying that you had any fraud questions or anything like that?
no.
That's all I have, Your Honor.
Thank you. Mr. Whitney, cross-exam.
Just really briefly, Your Honor. So, Mr. Kolznick, your testimony is your payments were stopped and you did receive a letter from Detr telling you that you had other program eligibility?
Yes,
And it's you're saying that you've never been advised by Detr to file in UI anytime after you receive that denial of proof of benefits?
I did file another claim with UI right after that, yes.
Thank you, Your Honor. No further questions.
Well, okay, thank you. And Mr. Kolznick, you did that even though you had been denied because why? You wanted to make sure out of an abundance of caution that was not what was holding things up?
Yes, sir.
And was that denied also?
It wasn't directly denied, but I got a message on my portal website that said, your claim, you need to discuss your claim with the Detr representative. You need to call in to the office and talk to someone before we can proceed with your claim.
All right, did you do that?
I did that every day for 2 straight weeks, almost 500 calls a day. I never got through.
And
And at that time, oh, go ahead.
Was that in the July timeframe?
That was, let's see here. That was right after I filed my, let's see. Looking at my notes here for timing. It was in August, right after I filed my appeal. And then 2 weeks after I filed that claim with UI, it disappeared off my portal dashboard. Without being denied or approved.
Okay. Let me think for a moment here. You received payment, the big payment, 6/16, and 3 more after that. So end of June, and then early July. Is that fair?
That's correct.
So the order of mandate from the court was July 23rd, Mr. Whitney. So again, before we thank and excuse Mr. Kolznick for his time this morning, again, because I'm gonna ask about this during the summary here after all the evidence is taken. What is your understanding of the reason that Mr. Kolznick hasn't been paid, assuming the court finds credible his testimony, that he hasn't been paid, notwithstanding the court's order of mandate, which came out after he had received some payments, but then they stopped? Why then, if the court accepts that factually to have occurred, what's the state's explanation for why his payments would have stopped?
Your Honor, this is one, again, it's April 1620. The court's probably remembers that when a person is being paid in PUA, their eligibility is contingent upon the person not being eligible for one of the other 3 programs. And so if the EUPLs also say payments to stop if that claimant becomes eligible for one of the other programs. So I guess the overall big picture here, my understanding is that's what happened in this case.
Okay, well that might explain why he wouldn't be eligible, but I guess I want to be more pointed here, because this might be a reoccurring theme, or it might not. But why did payments not resume to him, notwithstanding what you just said? That he might not otherwise be eligible, that he might have UI benefits, why did payments not resume to Mr. Kolznick these many months after the court specifically ordered them to begin again on July 23rd? I mean, this is not a mystery question. This is why we're having this hearing. Obviously, the state, both sides have given this a lot of thought in anticipation of this hearing, because these are the tough questions that the court was going to ask to make a decision whether there has been a willful failure to abide the court's order, or there's been substantial or complete compliance. Nobody is suggesting there's been complete compliance, which is the gold standard, but I'm looking for at least the silver standard, which is substantial compliance. So again, Mr. Whitney, if the court ordered it to be restarted again, notwithstanding these concerns of his eligibility, why did that, to your best of your knowledge, not happen?
The best of my knowledge, Your Honor, that it puts Detr in direct conflict with U.S. Department of Labor guidance, which it is required to follow. I do if my understanding is correct also, and our witness will testify to this, Mr. Kolznick can apply for UI benefits there, but I'm sorry, to address your question.
That may well be true. He might have UI benefits available, and in the ordinary course of things, he's not eligible for PUA benefits until and unless he fully exhausts the UI. But that's a bridge that we've already crossed. And right now we're in the, has the state complied with the order or gotten the order modified, state or otherwise held in abeyance? Okay.
Your Honor, may
Go ahead.
I add one point on this thing?
Well,
just so
only
the
if we agree that I'll allow both counsel for the state also to address the court in the middle of a witness. But so go ahead, Mr. Thierman.
Just so you know, there's a CFR regulation, 20 CFR 625.10A, which applies to PUA as well as it applies to disaster unemployment insurance. And it says any decision of a DUI first stage appeal must be made and issued within 30 days after receipt of the appeal by the state. They received an appeal, 30 days went by. They haven't responded. I don't think that the fact whether or not he's their objection to his not, his eligibility or dual eligibility or whatever has been waived by not offering him and not issuing a written decision within 30 days of his.
Well, I'm not here to decide that. That's a different issue for a different time. We all know, I mean, it's not lost on the court that it took a while to get people trained to handle these appeals, that the state is, from what the court understands, can take judicial notice. They're trying to move that forward as quickly as possible. As a matter of law, if somebody has waived the right to decline benefits because the appeal didn't happen timely, that's another decision for another judge at another time. What I want to, again, let's all keep our eye on the ball here. And the ball is, has the state willfully and knowingly violated the court's order? And again, the reoccurring theme here is, and again, we just started, but it seems to the court so far, the theme is these people are not eligible for benefits, or we have concerns that they're eligible, or they might be eligible for something else. And that may well be true. And that may be the ultimate determination. But the court order was very specific. The fact that they may later be eligible or not eligible was no moment because the court ordered certain things to be done by a certain date. So that's what I'm here to decide. All right. With that, Mr. Whitney or Mr. Ott, anything else from the state before we thank and excuse Mr. Kolznick?
I just have one or two more questions, Your Honor.
Go ahead.
If I could.
You may go right ahead.
Mr. Kolznick, Greg Ott for the state. Couple questions about your the second UI application that you said that you filed. Can you tell me the date that you filed that?
Right after I filed the appeal for the PUA, so on or about August 5th.
And you never received a denial or a approval of that? Was that your testimony?
That's correct. A little pop-up message popped up and said, you must call the DETR office and speak to a representative.
And then it just disappeared? Was that your testimony?
After about 2 weeks, that claim disappeared off my dashboard. Yes.
So have you ever had that happen with a Detr claim before, where it just disappeared with no sort of
no
disposition?
No.
Did you ever try to refile it?
I did. The next day after it disappeared, and the same thing happened.
What was that day? What was that day that you tried to refile?
That was about the middle of August.
So sometime 15 to 20, somewhere in there?
Somewhere in there, yes.
Okay. What happened that time?
Same thing happened. Told me to call in and speak to a representative. Could never get through. And then after about 2 weeks, that one disappeared off my dashboard.
And did you try a third time or no?
No.
Did you get any sort of confirmation that your claim had been submitted from Detr or accepted either of these second two times, the August 3rd or the August 15th?
So we're talking about the UI application, correct?
No,
Correct.
I never received anything from them.
Are you saying that you did see it on your dashboard after you filed it, though?
Yes.
How long did it appear?
Approximately 2 weeks.
Is that true in both cases, the August 3 and the August 15 to 20?
That's correct.
Okay. Is it possible that you didn't hit submit and it never got sent in?
On my end, I filed it and I submitted it, and that's the message I got. So I'm not sure what happened on DETR's end.
Okay. And sorry if I asked you this. Did you file a third? You said you did not file a third time, correct?
Third time, yes.
You did file a third time. What happened the third time?
The first initial time back in March, and then the 2 additional times in August.
Yeah, thank you for clarifying. I apologize for the loose language. So you filed the initial time, then August 3, and then August 15 to 20. But when the August 15 to 21 disappeared, you did not file again, correct?
I gave up on it.
I don't have anything further, Your Honor.
Thank you. Anything else, Ms. Jones or Mr. Thierman?
No, thank you, Your Honor.
All right, thank you very much. Mr. Kolznick, the court thanks you for your time. You're excused. You can observe the rest of the hearing if you'd like, and to you and your family, a safe and healthy holiday.
Thank you, Your
Ms.
Honor.
Jones, please call the plaintiff's next witness.
Thank you, Your Honor. I'd like to call Greg Daugherty as plaintiff's third witness.
Okay, Ms. Clerk, if you would please promote Mr. Daugherty. All right, I just need a moment here. I got a little bit of technology challenge. Okay, Mr. Daugherty, good morning. Can you hear the court?
Yes, I can.
All right, thank you very much. Ms. Clerk, would you please administer the oath of witness to Mr. Daugherty?
Please raise your right hand. Do you solemnly swear or affirm the testimony you're about to give in this case shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Thank you. And then just for everyone's information, after Mr. Daugherty's examination, the court will take a short recess. All right, Ms. Jones, please proceed. And if you're going to ask Mr. Daugherty to talk about his experience, please ask him to waive his right to confidentiality as well.
Thank you. Thank you, Mr. Daugherty. During the course of your testimony today, we're going to be talking about your claim with Detr. Detr has confidentiality clauses regarding people's claimants. In order to freely speak about your claim today, are you willing to waive that confidentiality?
Yes, I am.
Can you explain to the court why you're here today?
I filed for an appeal for unemployment back in May and haven't received the payment since then. And it's been on an appeal status since July the 23rd.
Mr. Daugherty, did you ever receive any payments?
I received one payment of $1,069, which was $469 plus a $600 FPUC payment. I received one payment. Currently, I'm still owed about $12,570.
Let me back up here a little bit. What is your profession, Mr. Daugherty?
A rideshare driver and a photographer.
Are we to understand that both as a rideshare driver and a photographer, you're a 1099 employee as opposed to somebody who would receive a W-2 income and a paycheck from an employer?
No, correct. Yeah, I just received 1099s.
So between January 1, 2020 and the present, have you had any jobs where you actually received a W-2?
No, I haven't.
From January 1, 2019 through December 31st, 2019, did you receive any income from W-2s?
No.
have you always, you have a bit of an accent. Have you been working in Nevada since January 1, 2020 and the present?
Yeah, I moved here last year.
Okay. And whenabouts did you move to Nevada?
I've been coming out here for work for the last 4 or 5 years, but then I actually officially moved in September of last year.
And is that when you became a rideshare driver?
Yeah, I mean, I was already a rideshare driver back in California and a photographer there. But when I moved out here, when you move as a rideshare driver, you can only drive in one geographic location. So, I was required to move everything, change your registration, your insurance, your driving license, get everything kind of changed on the apps. And then they only allow you to drive in one location. So I did all of that. And that was all official back in October. And so then and then I've been driving since then, and then a photographer.
When did you stop driving for, was it Uber or Lyft?
Both, March the 19th.
And did you take any photographs? Were you paid for any photographs in 2020?
Yes. Yeah, up until the 18th.
Up until the 18th. And why did you stop working on the 18th?
Just because of the shutdown order and the suggestion that, everybody start scaling back. I'd already had a number of jobs canceled. I was meant to shoot the NFL draft, which was on April the 23rd here in Nevada. That had been canceled. The Latin Billboard Awards, that had been canceled. So all the jobs that, I'd been slated to shoot had already been canceled. And, so at that point, there wasn't any kind of photography work. I mean, I've had over 60 different jobs canceled from the photography side, because it's all event related in Nevada.
When did you first apply for benefits?
May the 16th, finalized the claim on May the 17th, worked overnight on it, got it, and all the documents and everything finally submitted on May the 17th. That was the weekend the portal went live, for under employeenv.gov, so that, all of us 1099 and, contractors could actually apply.
Did you provide your portal documents to counsel to use today?
Yeah, I've provided a number of screen shares, both documents and various screen shares of my claim.
Your Honor, I would like to ask that exhibit number 3, Mr. Daugherty's portal documents be offered into the record.
Thank you. Any objection from the state?
Your Honor, no objection.
Thank you very much. Exhibit 3 is admitted. You may publish.
Mr. Daugherty, can you see the document that I have on the screen? It says unemployment insurance claim at the top.
Yes, I can.
Your Honor, can you see this document?
Can you make it a little bit bigger, please?
Sure. How's that?
Much better. Thank you.
And Mr. Whitney, can you see the document as well?
I can, thank you.
Mr. Daugherty, you said you applied for benefits in May when it first went live. Is that correct?
That's correct.
How many weeks were you out of work?
It's been it was a total, I think, of 20 weeks, by the time I finished filing my weekly certifications. But when we first filed back on May the 16th, 17th, the portal gave us the opportunity to backdate because you initially state what was the last day you worked, and then, it asked you to submit your claims for each of the individual weekly certifications up to the weekend that we got the file, which was the 5/16, 5/17. So I filed multiple weeks that same weekend, and then I continued to file weekly certifications on schedule, and right up until I was told not to file anymore.
And why did you stop filing?
August the 2nd, I went back to work. I had continued to file after that, 3 weeks after that, but I went back, started driving again on August the 2nd. And so I filed for 3 weekly certifications. And at that point, I actually I'd managed to get through to somebody at Detr. And they said that if you know that your weekly earnings are going to be excessive and, obviously you're not going to be eligible for unemployment, you don't need to keep filing weekly claims. So after those 3 weekly claims where I showed excessive earnings, I just stopped filing.
I'm going to blow this up just a tad here. So down here at the bottom, that's that 3/21 date that you're speaking about, correct?
Yes.
And then you only filed for 23 weeks and you went back to work after that August 22nd date. Is that correct?
No, I went back to work on August the 2nd. I filed, my last claim was filed through August the 1st, which was a Saturday. And then I went back to work Sunday, August the 2nd. The first week's claim that you see there, I didn't get any benefits because that was the last week I worked and my earnings were excessive that first week as well. So I filed that week, but then obviously it doesn't pay out because I had earnings that exceeded the minimum. And then the last 3 weeks, as I said, I actually went back to work on the 2nd of August, but I continued to file for 3 more weeks until I was told I didn't have to keep filing.
Okay. How many payments did you receive again?
I received one payment on 7/22.
Do you recall what that amount was?
Yeah, it was $1,069, the $469 at the time, and then the $600 payment. You know, that was a combined payment of $1,069.
I'm going to go down one more document here. Do you recognize this payment summary?
Yes, I do.
Is that something that you provided from your portal?
That's one of my portal document screens I gave you.
So we just talked about some payments. Did you, and you talked about that those last 3 weeks, you actually claimed, you actually provided your portal with the earnings that you claimed. Is this what you're speaking about there?
Yeah, so those are the 3 weeks. You know, I didn't want to stop filing weekly certifications because at this point we still hadn't been paid and nothing was, you know, just didn't know what was kind of going on with the portal site. So I just continued to file for those 3 weeks just to make sure that, you know, everything was just being consistent. But you can see by the excessive earnings, obviously I wasn't going to be getting paid. And it was only then, as I said, once I finally got through to somebody, they said that you don't actually have to keep claiming if you know that you're going to exceed the excessive earnings.
So you don't expect to get paid for those 3 weeks, is that correct?
No, absolutely not.
Okay. I'm going to move down here a little bit. I'm pulling up the next document. It says overpayment summary. Do you recognize that document?
No, yes, I do.
And did you provide this document to counsel?
Yep, I provided the screenshot as well.
Can you tell me what it says?
Yeah, this is a recent update to the website. That little box there on the screen says that I have an overpayment issue, and because of that, any kind of benefits will be stopped. And below it tells me that I owe Detr $17,573 for money that they sent me that they actually never sent me.
So, to be clear, you received approximately $1,000.
$1,069, yes.
But it seems here on this overpayment summary that they indicated that you were paid $17,573. Is that your understanding?
That's what they think.
Okay. Did you appeal? Have you appealed that overpayment decision?
I have recently, I'd originally appealed the first problem because I'd been denied after that $1,069 payment on the 7/22. I received a denial letter on 7/23 telling me I was now disqualified because I have other payment eligibility. And so I've been under appeal since that time. I then recently filed another appeal for one of the 2 overpayment claims because there's an overpayment claim for the FPUC and then for the PUA. So I appealed one of them. The other one you couldn't appeal because the website won't allow you to actually appeal it, saying it's part of a pending appeal. Yeah, well, so I've only been able to appeal one of the 2 documents, but I have added documents to my other appeal to let them know that, you know, I protest that because, you know, that both of those documents are wrong.
Okay, so I want to be clear. You never received $17,000. Is that correct?
Correct.
Did you talk to somebody at Detr and ask him about that $17,000 you were supposedly paid?
No.
Why not?
No, I mean, let me take that back. When I was expecting to be paid, yes, we spoke. I did speak to people as late as September. Haven't been able to get through again since the phone switched over to Detr, but I have not appealed. I've appealed this, but I haven't been able to speak to anybody because I haven't been able to get through to anybody. And I have been told, you know, as we hear from, you know, both from the Facebook group and from various places of communication, that if you're in an appeal status, Detr can't do anything. The phone services that you contact can't do anything with your claim. You just have to simply wait for your appeal to be adjudicated. Well, it's been sitting there for now 5 months and it hasn't been touched.
Did you, how did you receive your payments? Was it a check or direct deposit or something like that?
Direct deposit into my bank account.
Did you check with your bank to see if you received $17,000?
Yeah, I checked. Definitely not there. And here's the thing though, is I mean, on the, it was kind of a running joke for a long time because they did some update before around 7:10, 7:11, that they did some type of update to the website that all of a sudden many claims, including mine, got populated with our transaction numbers and our payment numbers and a payment date. That initial payment date was 7/11. And then subsequently after that, that payment date, every time that you wake up in the morning of 7/11, suddenly the payment date's 7/12. Then you wake up the next day and it's 7/13. So it was a rolling pay date. So that date changed multiple times, 7 times, before they then started changing the payment dates weekly instead of daily. So, you know, that was kind of the running joke that, you know, I wonder if today's the day we get paid. I never was. And, you know, the site for a long time reflected that. Then when the strike force took over in, you know, middle, late of October, middle of late August, they obviously updated the website and then they removed all references to the payment numbers of the transaction or to the payment number that they said that they'd paid us, you know, and then they just now on my portal and the documents that you have there reflect it, show a single payment number and a single transaction number that, you know, reflect the $1,069 payment. And even though the website, you know, shows all these multiple payments, you can see they removed the payment number because they never actually paid it. So it wasn't an issue with the bank or getting rejected or anything like that. It just was never paid.
And I'm going back to that payment screen. Can you, is this what you were talking about, your payment numbers?
Yeah. But go to.
Can you see
it's not the payment summary screen. You go to, yeah, if you go up to the other one, yeah, the one above that.
Okay.
And just go up. Because it's the main claim summary. Oh, sorry, it's the previous document. It's not that, yeah, it's the actual claim document. So you can see there under payment number, you can see there's the payment number that references the only payment I received, and that was the date that I received it. Prior to that, there was another payment number, which was payment number, I think 295346 is the one that was paid. The one previous was 263311. And that was the one that they then cleaned up and removed from the website, you know, in late August, early September, to reflect that, you know, obviously we had not been, or I had not been paid that money. But I still got the letter stating that I was overpaid and I needed to repay the document, repay the amount.
Have you ever been able to speak to an adjudicator or referee about the fact that you never received any of your payments besides this one?
No, because I've been in appeal status, and every time I've called and spoken to anybody, the last time was in September, they said, oh, I see your claim's under appeal. You'll just have to wait until the appeal's heard. There's nothing we can do for you right now. So, you know, it's just been sitting there. And then since I received the, you know, the overpayment letter, you know, this is, you know, where I'd submitted all these documents to you and, you know, uploaded my, you know, my appeals and things like that, but I haven't been able to get hold of anybody on Detr. But again, I'm told every time that I've spoken to them that it doesn't matter because you have to wait for the appeal.
Did you ever receive any information from Detr saying that that you had a fraud or that they needed additional information or documentation?
No, I mean, from the very beginning, I've had, I think, a very clean claim. I've always had all of the documents provided from the outset. I filed my tax returns, you know, as part of my initial documents. The only kind of change that, you know, that I received was that, you know, originally I filed under gross income. They then, you know, from what I understand, that was incorrect. And so they adjusted, you know, they gave me a redetermination letter to take me from the 469 payment a week to 181 a week. And I didn't appeal that because if that's actually the way it's meant to be calculated, then I agree with them. So I've left that alone, but then they haven't, I haven't had any other chance to kind of do anything. There hasn't ever been an issue. And it's one of the reasons I received that payment. I've never had an ID verify issue. I've not got multiple addresses or multiple claimants to my address. I mean, again, all the things that I keep hearing people getting denied for or claims being denied didn't seem to apply to me because I provided them with every document I've ever, needed to from the very outset. And then and then once I had this appeal, then I provided copies of my Nevada business license from last year. And then I recently updated it to include the refiled business license because I'm still living here and still working here. So, there didn't seem to be any reason why. But as I said, every time I've spoken to anybody, they just keep telling me I can't do anything because I have to wait for an appeal, but it's now been 5 months.
Okay, I have no further questions at this point, Your Honor.
All right, thank you. Before I give Mr. Whitney an opportunity to examine Mr. Daugherty, I have a few questions because the timeline is a little confusing to the court. You stopped driving about March 19th.
Correct.
You stopped working as a photographer about March 18th. Do I have that right, Mr. Daugherty?
Yep, that week. That was all the same week.
All right. You started to apply as soon as the PUA portal went live. You started the process about May 16 and you finished it and hit the send submit button on or about May 17. Do I have that right?
That's correct.
All right. You received your first and what turns out to be only payment from the state of Nevada on or about July 22nd, 2020 in the amount of $1,069, representing $469 of benefits plus $600 of the pandemic unemployment assistance for a grand total $1,069. Does that sound right?
That's correct.
All right. Now, you went back to work about August 2nd.
Mm-hmm.
And was that as a driver? Was that as a photographer or something different?
No, that was just as a driver. There hasn't been any new photography business.
Got it. And then have you worked continuously or was that only till about August 23rd? What's the August 23rd date?
No, I've been, once I went back to work on August the 2nd, I've been working, since then, right up until now. I mean, business has dropped off massively again, with obviously as things have now scaled back in Nevada, especially for this year. But I've been working, consistently since the 2nd of August.
All right. Now, the overpayment amount of 17,000, you've testified under oath. You never received that money. That's a mistake somewhere. Fair?
That's absolutely. I mean, there's a paper trail, screenshots of all the website that shows that is absolutely an error.
All right. Now, so let's go back. Then the amount of time that you believe you are entitled to benefits, which you have not received for, is what period of time? In other words, what period of time do you believe the $1,069 payment went for? Was that just the first week, March 19th to March 26th, or was it something else?
No, this is the timeline. Is that we received those transaction numbers and payment numbers on all those previous weeks that I was owed. And that was the one that hasn't been paid. But then the week of, I think it was like the 7/18 was when I did my weekly certification. That was the first time at this point they'd populated all the transaction numbers, payment numbers, and payment dates. When I filed that weekly claim the week of the 7/18, that was the first time that my claim actually showed that you will be paid. And sure enough, on that Tuesday, I was paid that 7/22 or whatever.
Okay, but and that all may be true, but you still have confused me. So answer this question, Mr. Daugherty. In your mind, as you sit here right now, how many weeks have you been paid for and how many are you still owed?
They paid me for the week of 7/18. That has been paid and it shows on the document that that's the week they paid me. And then they owe me 19 weeks of the weekly benefit, the 181, and then they owe me 18 weeks of the PUA 600.
Okay, so I got it. So the payment in your mind on July 22nd went for essentially the week immediately prior to July 22nd, but you haven't been paid in your mind for any time from March 19th up through that date in July, nor any time past that date in July that you would otherwise qualify. Is that
Correct.
your position as you sit here right now?
Yeah, that's right.
And of course, again, reiterating what you've already emphasized, you never got the 17,000. So to the extent anybody thinks otherwise, they're wrong.
Mm-hmm.
Fair?
Right.
All right. And so again, before I turn to Mr. Whitney, Ms. Jones, let's assume the court finds persuasive everything that Mr. Daugherty just said and finds factually that's been demonstrated. How is he encompassed by the court order? Because his first payment was received the day before the court order went live, the order of mandate. So is he captured for the months before?
I believe so, yes, Your Honor.
Why?
I don't think that, and I could be wrong, that your order just ended on the 28th, that people that weren't paid as of the 28th, anybody after that who had a payment start and stop should be encompassed on the court's order. Now, if that's not what the court meant, we're operating under the incorrect assumption. But
well, I want to know why you think. Well, so that's a rhetorical question right now.
Sure.
What I want to know is why you think Mr. Daugherty is captured by the court's order, and if your answer is because on July 23rd he had received a payment and then it stopped. No, let me back up. As of the date of the court's order of July 23rd, he had already received a payment the day before. So then his payments had begun. So then they somehow stopped. The question is, does the court's order, is it retroactive to the date in March that he believes that he should have been paid as well up until the July timeframe? So that's a little bit more nuanced, but I understand the plaintiff maintains that he would be eligible to be paid from March to July when he hasn't been, and then anytime after July 22nd payment that he would be eligible for, not eligible for, but that he applied, that he otherwise fits within the parameters of the court's order. At least that's where I understand plaintiff is coming from, Ms. Jones. Do I have it right?
yes,
All right. Mr. Whitney, please feel free to question Mr. Daugherty.
Thank you, Your Honor. Mr. Daugherty, have you ever held employment in the state of California?
Yeah.
And
Well,
when-
we say held employment. I mean, I've worked in California, but not actually been kind of 2012. I mean, that's when I was last actually an employee.
And so you're saying that not since 2012, you haven't worked in California since 2012?
No, I've worked in there, but I haven't actually been an employee. I've been an independent contractor. Yeah, I mean, I only moved to Nevada. I mean, as a photographer, I work in many states. I mean, I'm an independent freelance photographer who travels for work to wherever is the jobs are required. Sometimes it's California, sometimes Arizona. It's been overseas as well.
And do you ever recall working for an employer called ABS from California?
ABS, I mean, it doesn't, I don't have any employer by ADS. I mean, I don't know, are they a like payment service or something? I don't remember.
Actually, it's ABS, Mr. Daugherty, not ADS, I'm not sure. Does that make a difference?
Again, not familiar with that company now.
And you applied for PUA, and I think you kind of touched on this. Initially, you certified that you had around $20,000 in earnings, didn't you?
20,000 earnings per quarter.
Per quarter. But as you kind of alluded to, your Schedule C actually showed that you had around $2,700 in earnings, correct?
From what I understand, I mean, I didn't go back and look at it, but once I understood, from communication that, when you have to apply for the benefits, you kind of, it has to not be gross. It's, it's that Schedule C and that particular line you referenced. And that's why they reduced my benefit from 469 to 181. And that's why I didn't appeal it, because if I was wrong when I first filed that, then certainly understand. And, that's why I wasn't appealing it.
Thank you, Mr. Daugherty. Those are all the questions I have.
All right, thank you. Ms. Jones, anything else?
No, thank you, Your Honor.
All right, Mr. Daugherty, with the court's thanks, you're excused. You can drop off this call. You're certainly free to monitor the hearing for as long as you like. And to you and your family, a safe holiday. Ladies and gentlemen, the court will be in recess for approximately 15 minutes. We'll get back at it at approximately 11:30. But before we break, Ms. Jones, do the plaintiffs have any other witnesses that you intend to call this morning?
No, Your Honor.
All right, thank you. Then, Mr. Whitney, Mr. Ott, please have the state's first witness ready to go, and we'll bring him or her in, and we'll hear from them. The court will be in recess for approximately 15 minutes.
Thank you, Your Honor.
Thank you.
Mr. Whitney, can you tell me who your first witness will be so I can go ahead and bring them in?
Hi, Mr. Gaynor, can you hear me?
Yes.
Our first witness is going to be Miss Patricia Allender.
Okay. Was that, did you say Allender with an A or?
Yeah.
Okay, thank you.
Thank you.
All right, welcome back, everyone. Let's go back on the record. Okay, we're back on the record. At this time, I invite the state to call its first witness. Mr. Whitney or Mr. Ott, please proceed.
Thank you, Your Honor. The state would call Miss Patricia Allender as its first witness.
Thank you very much. Ms. Allender, I see you've already been brought into the meeting. Good morning. If you would please raise your right hand to be sworn.
Do you solemnly swear or affirm the testimony you're about to give in this case shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you very much. Mr. Whitney, you may proceed.
Thank you, Your Honor. Ms. Allender, could you please spell your last name for the record?
Sure. First name is Patricia, last name is Allender, Allander.
And Ms. Allender, where are you employed?
I work for the Employment Security Division of Detr.
And how long have you been employed there?
11 years.
What is your current position with the Employment Security Division?
I am currently a business process analyst.
How long have you been in that position?
For 3 years.
Now, as a business process analyst, what are your main job duties and responsibilities?
Currently, I am the lead analyst for the Pandemic Unemployment Assistance Program. I'm also a supervisor in the Unemployment Insurance Support Services Unit. I test and monitor the PUA web-based application. I report problems in the system to the third-party vendor who developed and operate the system. I assist in development of internal policy and procedure for the PUA program based on guidelines from DOL along with state and federal law.
Are you aware of the Amethyst Payne case with Detr as the defendant that was filed in Washoe County?
Yes.
Now, as part of your job, do you happen to be aware if a Detr ever received claims from for PUA benefits from claimants from the time period before March 17th, 2020?
Yes.
And did Detr actually review those claims?
Some were reviewed, but not all.
Okay. Did Detr award PUA benefits to any claimants making a claim for PUA benefits? Actually award somebody claimants PUA benefits for someone that was making a claim prior to March 17th? For claim
Yes, for anybody who filed a PUA claim with an effective date prior to 3/17, there are just over 35,000 claims. Of those, 32,120 have been paid benefits from that date at the tune of approximately $24.9 million.
Did Detr make any blanket denials of PUA benefits if a claimant made a claim then for the period prior to March 17th?
No.
And do you know when Detr set up its appeal process system, when that began?
The appeals module went live on July 17th of 2020.
So theoretically, on July 22nd, when the court entered its order of mandate, were PUA applicants able to appeal any adverse determinations on July 22nd?
Yes, as of July 17th, anybody with a determination that they disagreed with could file that appeal.
Now, how long, when the appeals, a PUA appeals process was set up on July 17th, how long did PUA applicants have to appeal their determinations?
So all PUA appeals are accepted if they are not filed within the 11-day period for standard timeliness. We are offering great latitude by the appeals division for accepting late appeals since this is a new program and the functionality was not available until July. They are allowing all valid appeals to be heard.
Okay. Now, do you happen to be aware of, like, around the July 18th, if that 11-day appeal period also applied, or if it was a different time frame?
According to the determination letter, there's an 11-day period to file a timely claim. The system does allow a claimant to file without having to enter a reason for filing a late claim. So they are always allowed to click that link and file that appeal.
Do you know if appeals have started to be heard yet by Detr of PUA appeals?
Yes, they have.
Do you happen to know when the first appeal was heard?
The first appeal was heard on November 5th.
So as we sit here today, a PUA applicant that receives an adverse determination, they're able to appeal that appeal. Appeal that adverse determination, correct?
Absolutely, yes.
And that appeal will be scheduled, correct, in its turn?
Yes, scheduling started as of the last week of October 2020.
Do you happen to know how long it's estimated between the time an appeal is filed and when it is heard by a Detr? Again, appeal of PUA determination, adverse determination.
It will be several months due to the backlog, but all valid appeals will be heard. I do not have the exact timeline.
I want to shift gears a little bit, Ms. Allender, and ask you a little bit about the PUA application process. Is a PUA applicant required to identify themselves on the PUA applications?
In the application itself, they're required to provide their name, social security number, date of birth, address, phone number, and email address. In addition, they are asked to upload personal identification documentation, which can include a driver's license, social security card, etc.
Now, if a person doesn't adequately identify themselves, are they given the opportunity to provide identifying information?
Yes.
Do you happen to know how many opportunities the claimants are given to provide that information?
And they are asked to upload, again, like I said, upload these documents when filing an initial claim. There are drop downs on the menu to upload these particular photos and various documents that they may have. They can return to their portal at any time to upload these documents. If a claim is actually being reviewed, an adjudicator does notice that identification documents may not be uploaded. Before any decision or determination is made, the adjudication team will message the claimant through the portal, asking them to provide this information within 48 hours before a determination is made.
Can you tell us, is the applicant then just messaged once, or is there more than one message sent?
There is only one message sent, but inside the application, it does advise someone to upload those documents. On their initial monetary determination letter, it does describe an eligibility review process, which also asks for these identification documents. But if they, we also had what's called a message blast, where we blanketed the majority of claims, asking them to provide these documents if they hadn't already done so. If that message is not already in their portal, the adjudication team will make that extra effort to give them a 48-hour notice. Through the portal, it will message them either through email or a text message that they do have something in their portal that they need to review.
You mentioned a message blast. Does that go out to all claimants, or just the claimants? I'm sorry, all PUA claimants, or just the PUA claimants that Detr that did not provide sufficient identification to Detr?
At the beginning of the program, we did go live in mid-May. There wasn't a requirement at that time to upload identification documentation. In June, we asked the vendor for the program to message the majority of claimants, as many as possible, to provide this information. I am aware that not every claimant did receive this message. So that's why we ensure that the adjudication staff review the claim for that message. If they do not see it, they must message the claimant themselves and ask for that information within 48 hours.
When a claimant applies for PUA, Is the claimant also required to provide proof of his or her income?
No, proof of income is not required. The only time proof of income would be required is if a claimant was requesting a higher weekly benefit amount.
Okay. So at some point then the PUA claimant, the deeders with so can you explain if and so how would for example, if someone provided, say, their I think W-9 form, how would an overpayment actually come out of that? If that makes sense.
I think you might be referring to the determination of the weekly benefit amount. Claimants self-certify their net income for 2019 on a quarterly basis. The weekly benefit amount is determined based on that self-certification. Per the DOL guideline, they have up to 21 days to provide proof of that income. If proof is not provided, the department can reduce that benefit amount to the minimum. Or if the financial documentation that they do provide does not support their self-certification, it can be reduced. If a claimant is receiving a reduced amount, at any time they can provide additional supporting documentation, and that weekly benefit amount can be raised as well. And any raised weekly amount is retroactive to the beginning of their claim. When anytime a weekly benefit amount is increased or decreased, a new monetary determination notice is generated, sent to their portal, and all documentation have appeal rights. So if they disagree with that amount, they can go through the appeals process.
Do you happen to recall what authority states that the person has the 21 days to provide proof of his or her income that they self-certified to?
UPL 1620, the monetary determination for self-employed individuals must be based on proof of net income. If the state is unable to determine net income based on the proof provided, the individual will receive the minimum PUA benefit, and that currently in the state of Nevada is $181.
So what then would happen if a PUA claimant certified that they had perhaps $100,000 in income, but then didn't provide any type of proof after the application, and the 21 days elapsed? What would happen then in a case like that?
When the claim is reviewed and no documentation is provided to support the self-certification, then the division will reduce that benefit amount. If the claimant had been paid at the higher weekly benefit amount and then reduced, that will create an overpayment.
I'm going to try and try this and put this screen up here. To show you exhibit number 18.
Before you put it up there, Mr. Whitney, tell me please what exhibit that the state has previously identified it intends to ask this witness about. Then I'm going to ask the plaintiffs if they have any objection to its admission and publication.
Thank you, Your Honor. We are going to start with exhibit number exhibit number 18. It's
and what is it generally?
It's the application snapshot for one of the previous witnesses that testified earlier today.
Okay. Ms. Jones, Mr. Thierman, any objection to the admission of Exhibit 18 from the state and its publication at this time?
None.
Okay, it's admitted. You may proceed, Mr. Whitney.
Thank you, Your Honor. Now kind of comes the challenging part. I'm going to try and.
Okay.
Miss Attorney Jones and Judge Breslow are able to see Exhibit 18.
Not yet. I see you're about to click on it. It looks like it would be a file with respect to the second witness of the plaintiffs, Mr. Steve Kolznick, who was the sports official who is claiming benefits here.
Correct, Your Honor. Oh, there it is.
While you're putting that up on the screen, Mr. Whitney, let me just ask, please, a few questions of Ms. Allender. First of all, Ms. Allender, excuse me, I certainly am going to state the obvious here that I don't envy you and the job that you have at this particular time. I'm sure it's been quite a challenge in light of everything that's going on. Is that a fair statement?
That is a fair statement.
All right. So, whatever happens with this case, whatever happens with this hearing, you have the court's thanks for the effort that you and I'm sure your colleagues are putting in to attempt to address, as the court has used the phrase earlier, a crushing load of claims for benefits. All right. That having been said, a couple questions. First of all, were you made aware of the court's order of mandate with respect to the court's order for payments to be, resumed or at least not stopped that came out on July 22nd?
Yes.
All right. And were you made to understand that, other than for the certain areas which would allow the state to stop payments once begun, that payments were to continue? Was that explained to you?
Yes, absolutely.
All right. And again, I'm looking at the order of mandate from July 22nd. It indicates, and the court ordered, that once payments have started, payments cannot be withheld. It must be restarted unless the applicant did not file a weekly claim or the applicant had earnings in excess of that which would otherwise qualify the applicant for benefits, or the state had in its possession clear and convincing evidence of fraud, or the applicant had an opportunity to be heard on a dispute or appeal. Those were the four bases upon which the state could stop payments once begun. Was that made clear to you?
Yes, absolutely.
All right. Were you watching the hearing to this point in time when Ms. Boyd, Mr. Kolznick, whose application apparently we'll be looking at shortly, and Mr. Daugherty testified?
Yes.
Right. And so let's just start with Ms. Boyd. You heard her indicate she received a single payment in June, aggregate payment of about $9,400, but has not received anything since then. Do you remember that testimony?
Yes.
All right. The implication to the court, based on her responses to questions from Ms. Jones, was that she should have been receiving payments since then and otherwise would have been captured by the court's order of mandate. Do you have a different view, or do you know factually that there's some other reason why she has not been continued receiving payments?
For Ms. Boyd, she did receive 20 weeks of benefits. That is correct. The actual dollar amount is $9,740 issued to her on June 24th. Her benefits did stop week ending June 27th. The reason that the benefits stopped is there was an eligibility review hold, and Ms. Boyd self-certified in her PUA application that she could not reach her place of employment due to COVID-19. But in the same application, she also self-certified that she had not worked since April of 2019. That is a contradictory statement. She also acknowledged that the statement in the PUA application that reads, "I acknowledge that I understand that making the certification is under penalty of perjury and intentional misrepresentation in self-certifying, that I may fall in one or more of these categories is fraud. Yes, I understand." And while with my experience in unemployment insurance and as a previous fraud investigator for the division's integrity unit, I do not think that Ms. Boyd was trying to defraud the division. However, her statements do fall under misrepresentation. And so the integrity of the program is at stake, and her claim was held on an eligibility review based on those statements.
All right. So if the court were to say which of the four items contained in the writ of mandate the state believes she would fall under, justifying a discontinuation of her payments, you would agree clearly it's not because she did not file a weekly claim. That wasn't the reason, right?
Correct.
We would agree it wasn't because she had earnings in excess of that which would otherwise qualify her for benefits. Is that fair?
Yes.
Right. And also, she had not yet been afforded an opportunity to be heard on any appeal of any declining of benefits, right?
Right. There would be nothing to appeal at that point.
The one is, as I'm understanding you, Ms. Allender, the one that you believe the state would justify her discontinuation of payments is that the state believed that there was clear and convincing evidence of fraud by the applicant.
That is correct. It would be misrepresentation to receive benefits in which she otherwise would not be entitled.
Okay. And, you know, there's a difference under the law, of course, in the type of a misrepresentation. One is negligent, like overlooking something or failing to do something, but then there's intentional, and that's fraud, intentional misrepresentation, knowingly. And so
Correct.
Again, based on your experience, the state withheld payments and is at this time withholding payments because it believes it has clear and convincing evidence of a knowing misrepresentation by her with respect to her eligibility?
Intentional misrepresentation, self-certifying that she could not reach her place of employment due to COVID, but also stating she hasn't worked since 2019.
All right, thank you. Let's turn to Mr. Kolznick. You were present when he testified. I'm assuming you've had a chance to listen to his testimony and possibly look into his status as well. Is that fair?
Yes.
All right. So in respect to his belief that he has not received benefits he would otherwise be entitled to, and that the plaintiff's counsel believes that would otherwise entitle him under the writ of mandate, what's the position, please, Ms. Allender, at least to the extent of your area of understanding and knowledge, as to why he is not currently receiving benefits?
He is not currently receiving benefits because he is eligible for regular unemployment insurance effective April 5th of 2020.
All right. So again, not to beat a dead horse here, but let's go over the court's writ of mandate again. That's not indicating that the applicant failed to file a weekly claim, is it?
No.
It's not suggesting that the applicant has earnings in excess of that which would otherwise qualify the applicant for benefits, is it?
No.
There's no clear and convincing evidence of fraud with respect to his application for benefits, is there?
No.
And this applicant has not yet had an opportunity to be heard in any appeal he has filed in this matter, has he?
And he has filed an appeal, but no, he has not been heard at this point.
All right. So then if we know that the order of mandate identified those as being the four possible bases to withhold benefits, and if you agree with the court that the reason you've identified doesn't fit in any of those four, what is your understanding as to why benefits have not either resumed or otherwise stopped with respect to Mr. Kolznick?
Mr. Kolznick was advised to contact Detr for his unemployment insurance claim. He did testify that he made several attempts to contact them. Detr was aware when they made this disqualification on the PUA claim of his UI eligibility. Detr could have done a better job by completing the request to convert the PUA claim to a UI claim and assist Mr. Kolznick a lot sooner. Fortunately, when a claimant does file an appeal, there is a second review process. When this process, when the staff that do this process get to Mr. Kolznick's claim, they will at that time do the claim conversion and make sure that his any eligible benefits will be released. But unfortunately, that process has not yet occurred.
All right. And that's informative, and I appreciate that. But you're answering a question that the court didn't exactly ask. Let me ask you this. Who at Detr would have the authority to either order payments to be made, notwithstanding the concern by the department that he might be eligible for UI benefits? Who has the authority to order payments notwithstanding that? Or alternatively, Ms. Allender, who has the authority to direct Detr not to release payments? In other words, is it your responsibility to make that determination? Is it Ms. Caffaretta's? Is it somebody else? And if so, who is it and what is their job title, please?
Management and administration would make those directives.
Okay, so who specifically? Who do you mean by management and who do you mean by administration? In other words, if I were to say to you, who made the decision not to pay Mr. Kolznick, even though the reason that he's not being paid does not fit neatly in any of the four bases that are encompassed by the court's order of mandate? What person or group of people made that decision?
The The disqualifying determination was issued by an adjudicator.
And the adjudicators are aware of the court's writ of mandate and that the decision whether to disqualify or not, unless it's under one of those 4 reasons, has already been made. Is that fair?
I would have to say that would be an assumption. I do not offer that authority or that mandate, but administration and management do.
All right, but you were aware of the court's order of mandate, you said, at about the time it was issued. Is that right?
Yes.
All right, and so the people that act as adjudicators, is it fair to say that you believe they were advised as well?
Yes, that would be fair.
All right. Thank you. I appreciate this. I may have additional questions. Mr. Whitney, I appreciate your indulgence. You may proceed. And at this point, I don't see Mr. Kolznick's Exhibit 18. If you're able to bring it up at this time, that would be great. If not, if you can just summarize what you believe it reflects and perhaps ask Ms. Allender some questions.
Thank you, Your Honor. Are you, Ms. Allender, then, do you recall reviewing Mr. Kolznick's application for PUA benefits?
And hold on, Mr. Whitney, if we're not going to be opening this exhibit, if you would do me a favor and close down the screen share so that we can all see each other again. Awesome. Thank you very much.
Thank you. Sorry about that, Your Honor. I don't know if it's me or the technology, but I'm having problems getting the document itself up.
Well, here's some information. You know, I mean, I want to power through as long as we can, but nevertheless, my staff and everyone else here is entitled to a reasonable lunch break, leg stretch, clear your head. So we're gonna stop around 12:30 until 1 o'clock anyway. And if there's an opportunity to work on any issue like this, please use that opportunity to do so. All right, but go ahead, Ms. Allender, did you hear the question?
Yes, I was able to review Mr. Kolznick's claim.
So again, why did Detr stop paying PUA benefits to Mr. Kolznick?
The system recognized that the claimant had potential UI eligibility.
Okay. And are you able to tell us when the system recognized that Mr. Kolznick had UI eligibility?
Yes, it was at quarter change, and it was the week ending July 11th.
Was there anything special about the fact that there was a quarter change and the fact that Mr. Kolznick was receiving PUA benefits at that time?
Yes, per UPL 1620, change 1, question 51 asks, how often are states required to check whether an individual remains ineligible for regular unemployment or EUC, which is the extension? The answer is because an individual receiving PUA cannot be eligible for regular UI, states are required to confirm an individual is still ineligible every quarter. If the individual becomes eligible for regular unemployment extended benefits, then payment on PUA must stop and the individual may file a regular unemployment claim.
So in this case, did Detr file the U.S. DOL's guidance in the UPL?
Yes, we did.
Thank you. Salary, those are all the questions I had on Mr. Kolznick's claim. I'd like to ask you about Mr. Daugherty's claim, and that is exhibit number 22. And exhibit, Ms. Allender, actually, are you able to see, do you have the different exhibits with you?
I have the exhibits available.
And exhibit 22, that's, should I apologize, that's actually,
Excuse me one second, Mr. Gaynor. What was the date? What was the timestamp of the OneDrive email that you sent the court yesterday, please?
One moment, Your Honor, and I'll find that for you. Your Honor, that email comes from the OneDrive program and not as a sent email from my outbox. So I don't have a timestamp, but I'm trying to send it again right now so you can access it.
Thank you very much. Mr. Whitney, you may proceed.
thank you, Your Honor.
Your Honor, I think I can bring that up, Robert. If you need me to share exhibit 22, I think I can do that.
Thank you, Chief. That would be great. I think it'd be best.
Your Honor, do you want to discuss with opposing counsel? You're on mute, I'm sorry.
Thank you. Let me think where we are. Okay. Ms. Jones, any objection to the state's publication and admission of what we're going to call exhibit, what's the number, Mr. Ott?
22.
22.
And
Admitted and may be published.
So, Ms. Allender, you recognize exhibit 22?
Yes.
And who does exhibit 22 concern?
The claimant Greg Daugherty.
Now, are you able to tell us, was Mr. Daugherty paid PUA benefits by Detr at some point?
Yes, he was.
And did Detr stop paying Mr. Daugherty PUA benefits at some point?
Yes.
And are you able to tell us when the payments, actually, first let's back up. When did Detr make the payments to Mr. Daugherty?
I believe a payment of $1,069 went out on July 20th.
And which is, you testified, you heard the testimony that is consistent with what Mr. Daugherty reported before, correct?
Yes.
And you testified that when did Detr stop the payments then?
It looks like they stopped the payments on or around July 21st or 22nd. Just within a few days of releasing that initial payment.
And why did Detr stop the benefit payments to Mr. Daugherty?
Mr. Daugherty at that time had potential eligibility for a regular unemployment claim in the state of California.
So does the US DOL guidance address a situation where a PUA claimant has potential eligibility for other program benefits?
Yes.
And could you just briefly summarize what the US DOL guidance says if a person is a PUA beneficiary becomes eligible for another program?
Sure. That's again, UPOL 1620. Section C is the operating instructions. Part 1 is eligibility, and it states that Section 2102 of the Act provides for payment of PUA to covered individual. Covered individual is defined as those individuals not qualified for regular unemployment compensation, extended benefits under state and federal law, or the Pandemic Emergency Unemployment Compensation, which is the PEUC extension. Under eligibility, he would be considered eligible for regular unemployment compensation based on the information that we have, and therefore would not be PUA eligible.
Was Detr required to follow the US DOL guidance in the UPOLs with respect to PUA applicants?
Yes.
Your Honor, thank you. I believe those are all the questions I have for Ms. Allender.
Thank you very much. The state may proceed to examine Ms. Allender. Excuse me, the petitioners.
Thank you, Your Honor. Ms. Allender, I have several questions for you. I'm going to try and go in chronological order regarding your first testimony. I believe you said that the appeal module went live on July 17th, 2020. Is that correct?
That is correct.
People with claims that are in process, are they able to appeal?
Can you be more specific to
Sure.
In process?
Sure. If I could do a screen share, that would be great.
What do you plan to share?
I would like to go back to Ms. Boyd's documents.
Go right ahead.
Previously? Okay. Ms. Allender, can you see that document that is Plaintiff Petitioner Exhibit 1?
It's showing a cursor spinning.
I'm sorry, what was that?
The document has not
Populated yet.
Populated. Oh, let's see here. Let me try it one more time. I apologize. There, I have a green box now. Do you see it now, Ms. Allender?
Yes, I see it now.
And Your Honor, do you see it?
Yeah, right now I just see the title.
Okay.
Plaintiff Petitioners Exhibit 1.
And Mr. Whitney, can you see it?
Yes, I can. Thank you.
Okay. I'm gonna, there we go. So in Ms. Allender's document here, it's page 4. The top line here is 21. The claim here, it says in progress. It went from partial check to in progress. If a claim is in progress, can the claimant appeal any decisions?
No, there is no determination on any issue if it says in progress. The only appeal rights that the claimant would have at this particular point in a claim would be the actual monetary determination letter.
Okay, I'm going to stop sharing that for a second. You indicated that all PUA appeals need to be initiated within 11 days. But that also the Detr is extending that. Have you notified any claimants that they have more than 11 days to file?
I believe the state has put out press releases to indicate that. I don't have specific information other than that.
So,
sorry, go ahead.
I apologize. I didn't mean to cut you off. I'm going to ask to pull up another document here. I would like to pull up another document, Your Honor. It's Mr. Kolznick's documents. It was exhibit number 2. May I put that up?
Go right ahead. Yes.
In Mr. Kolznick's document, Ms. Allender, can you see this? It has a pandemic unemployment disqualifying determination at the top. Do you see that document?
Yes.
Your Honor, can you see that document?
Yes.
And Mr. Whitney, can you see that document?
Yes, thank you.
So when a person receives this letter, it says that, I believe on here, one moment, that your appeal, hold on, your appeal must be received by 8/14/20. So the official document, is this an official document from Detr?
Yes, it is.
It is indicating that he only has appeal rights until the 14th. Does a press release supersede these documents?
Well, hold on. That's argument in the form of a question.
I apologize.
I mean, factually, what Ms. Allender has testified is to a couple things. One, it's 11 days. 2, she concedes that this letter says what it says. 3, her understanding is there's been an effort by the state to communicate in other medium that there might be additional time. And 4, I'm assuming you're going to make argument to the court at a later time that not everybody got the message and people believed that they were cut off, and that's why they didn't bother after that, I guess. But anyway, don't ask her if a press release trumps that. That's a legal question, and it's really argument in the form of a question.
Thank you, Your Honor.
You're welcome.
I'm going to go ahead and take that document down. Are you familiar with section 625.10 of the U.S. Code?
Not offhand.
Okay. In that, it requires that except that the period for appealing shall be 60 days from the date of determination or redetermination is issued or mailed instead of the appeal period provided by state law. Are you familiar that the CFR specific to the CARES Act actually provides a 60-day appeal window? I'm just asking if you're aware of that.
No.
Okay.
Your Honor?
Go ahead.
Thank you. This is Robert Whitney. I'm going to have to check here with respect to the 60-day time frame. I'm not sure how that's really relevant with to.
Well, if the objection is the question is not relevant to what we're here to decide, it's in the court's estimation borderline. So I'm going to overrule the objection, let the question be asked, and the witness responded she was not aware.
Thank you.
Thank you.
Thank you.
Ms. Allender, you specific to the claimants that we've talked about, we'll talk about Ms. Boyd first. I seem to recall that you testified in your experience, you didn't feel Ms. Boyd was fraudulent, that she might have just made a mistake. And then I think you testified that you did believe that there was clear and convincing evidence of fraud. Can you clear that up for me?
Sure. I guess it was just in my personal opinion, with my experience with unemployment insurance and as a former fraud investigator. From my own personal perspective, I did not believe that her intent was to defraud the division, but I do acknowledge that there could have been intentional misrepresentation to receive benefits in which she otherwise would not be entitled. And according to the application that she filled out, she did acknowledge and that she understood that making intentional misrepresentation is a category of fraud.
Okay. I think you, let me make sure I got your testimony straight. You, for Ms. Boyd specifically, you agreed that she was paid at least one payment. Is that correct?
Yeah, I have here that she was paid $99,740.
And I think you testified that she did not have any excess earnings that would otherwise disqualify her for benefits. Is that correct?
No, I believe she did not report any earnings.
Okay. Was she ever, and regarding the fraud issue, I'd like to pull up, it hasn't been entered into the record yet, UIPL 01-0116. It's plaintiff's exhibit number 8.
Any objection from the state?
No, Your Honor, just a U-pull.
All right, admitted. What exhibit number is it, you said?
It's exhibit number 8, Your Honor.
All right, it's admitted. You can pull it up.
Miss Allender, can you see that cover sheet that says exhibit 8?
Yes.
And Your Honor, can you see that?
Yes, thank you.
And Mr. Whitney, can you see that?
Yes, thank you.
This is the cover page is UIPL 01-16 dated October 1st. I am going to make it a little bit smaller so we can see a whole page here. I'm going to draw your attention to page 6, the highlighted area. It says section I, requirements for making determinations of fraud. Specifically says where there is a factual conflict between the information received from an individual and other information received by the agency from any source, it is incumbent upon the state to make further contact with the individual, inform him or her of the conflict, and allow an opportunity for rebuttal. Because such factual conflicts require the state agency to make determinations of credibility and intent, determinations of fraud must be made by agency staff. The determination may not be made by an automated system. Did I read that correctly?
Is that, oh, if that question is to me, yes, you did.
Was Miss Boyd provided with an opportunity for rebuttal prior to her benefits being stopped?
No, because she was not issued a fraud determination.
So I'm a little bit confused. If you believe when you testified that she was paid, she didn't have any, at least once the $9,000. She had no excess additional earnings. She hasn't had an opportunity to be heard, but you think that there might be some sort of fraud on her account. And here the UIPL unequivocally states that she needs to be contacted, not by an automated system, but by an actual person that can make a credibility determination. And so my question to you is, was she afforded that opportunity before her payment stopped?
Well, she already answered the question, Ms. Jones. She said no.
Okay.
But then she, then she went on and said, Ms. Allender said, is because I'm understanding, Ms. Allender, it's because she didn't qualify for the provision here that allows for her to be contacted and to make a rebuttal, because the reason identified to Ms. Boyd was not because she had been flagged for fraud. Do I have that right? Ms. Allender, do I have that right?
I believe so.
All right. So what was she actually notified of that was the reasons that her benefits were stopped, please?
Her benefits were stopped because of the conflict in her application. There was no disqualification issued. I am not too sure why. I do not have that answer. Typically, when a claim is reviewed and if there's going to be a stop, typically that's followed up immediately by a disqualification, or benefits are allowed to continue. In this case, her claim is still in a pending status. And I believe it's just oversight due to the volume of work.
Fair enough. Thank you. Ms. Jones, please proceed. I think we understand Ms. Boyd's situation.
Sure. So let's move on to Mr. Kolznick.
The court understands his situation. So
okay.
Why don't we just drop down to Mr. Daugherty, because I'm still a little unclear as to him.
Okay. For Mr. Daugherty, I believe you said that he was paid at least one payment, that payments were stopped. He did not have excessive earnings, and he didn't have any indices of fraud.
No, let's streamline this. Ms. Allender clearly said, yes, he's received $1,069 in July. Yes, he hasn't received any more money. And the basis was, it appeared he had available unemployment benefits from the state of California, and she's identified the guidance from the Department of Labor that says you're not eligible for PUA if you have eligible UI benefits from somewhere else. Now, that's what I'm taking, Ms. Allender, from what you've identified. If I'm wrong, please straighten me out. Or tell me I'm right. Ms. Allender?
Oh, you are correct. Sorry, I didn't know that was
All right.
geared towards
So then let's get down to the nitty and the gritty, because you and I have already spent some time going over the four bases that the court's order envisioned the state withholding benefits once begun. And so, I'm looking here in the court's order for if the applicant had benefits available from UI, whether from the state of Nevada or from any other state. And that's not on here. So, but you've identified that's the reason his benefits were stopped. So I guess my question would be, who has the ultimate determination whether to abide in the Detr's mind, the Department of Labor guidance versus the court order? What's your understanding of who makes that call? Is it you? Is it somebody in administration? Is it senior? Is it the director? Is it general counsel? I mean, who actually is, to your best of your knowledge and understanding, Ms. Allender, makes the determination as to which one to follow?
I believe that would be fall under the administrative level.
Right. But was it made known to you then that for yourself and those that you supervise, that the benefits could be stopped, not in violation of the court's order, if UI benefits were available somewhere else?
You're asking if that was a directive to staff?
Yeah. Was that communicated to you and possibly those that you supervise?
In the unit that I work in, yes, it was made clear. However, we don't oversee the entirety of the adjudication staff. That would be a different division. So I don't have the direct knowledge of how that was communicated to them.
Fair enough. All right, thank you. Ms. Jones, please continue.
I have no further questions for Ms. Allender.
Thank you. Mr. Whitney, any follow-up?
Thank you, Your Honor. Just one brief one question. Ms. Allender, actually, never mind. Your Honor, I'll withdraw the question.
Fair enough. Ms. Allender, with the court's thanks, you're excused. Very much appreciate your testimony. To you and your family, a safe, healthy holiday season. You can drop off the call. All right, it's 12:30. The court's going to take a 30-minute lunch recess. Usually it's longer, but I want to get right to it so we don't run out of daylight here. If the state would please have their next witness ready to go promptly at 1 o'clock, we'll go from there. With respect to technology and sharing of the screens, I think a combination of the court having access now through the OneDrive to all the exhibits and Mr. Ott being able to screen share, I think we've moved past that, but of course, do whatever you want to do to improve that if there's a way to do it. Absent that, we'll be in recess until 1 o'clock. I wish everybody a pleasant lunch.
Thank you.
Mr. Whitney, are you able to hear me?
Yes, Mr. Gaynor, I can. Thank you.
Thank you. Can you tell me who your next witness is?
Yes, certainly. It will be Josh Marhevka.
Thank you.
You're welcome.
Bring him in. Okay, counsel, we're ready to go. Please start your videos. Thank you.
All right, welcome back, everyone. We're back on the record. Again, I apologize for the shortened lunch break, but we have ground to cover and I want to make sure we get done today. All right, at this point, the court invites the state to call its next witness. Mr. Whitney, please proceed.
Certainly, Your Honor. Is Attorney Jones with us? I don't see her on the screen.
Yes, everyone's on.
Thank you, Your Honor. It would call as this next witness, Josh Marhevka.
Thank you very much. Good afternoon, sir. Can you hear the court?
Yes, Your Honor, I can hear.
Very good. Thank you. Ms. Clerk, would you please administer the oath of witness?
Please raise your right hand. Do you solemnly swear or affirm the testimony you're about to give in this case shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do swear.
Thank you very much, Mr. Marhevka. At this time, I invite the attorney for the state of Nevada to ask you some questions. Please proceed, Mr. Whitney or Mr. Ott.
Thank you, Your Honor. Mr. Marhevka, could you please state and then spell your last name for the record?
For the record, my name is Joshua Marhevka, Joshua Marhevka.
Thank you very much.
Thank you. Mr. Marhevka, where are you employed?
Currently, I work for the Employment Security Division.
And how long have you worked for the Employment Security Division?
18 months.
And what is your position with the division?
Management analyst.
And have you held that same position for 18 months?
Yes.
As management analyst, can you please just briefly tell us what your main job duties and responsibilities are?
I'm directly responsible for supporting the ESD administrator in the division. I'm involved in budget, fiscal, grant management, procurement, contracts, personnel tracking, inventory, regulation, legislation.
I would like to take a moment and show you what's been marked as Exhibit 16.
And Mr. Ott, are you able to pull that up?
Your Honor, I'm going to object to this exhibit.
What's the basis of the objection?
It is purported to be a statement regarding staffing at Detr, which I don't know why that is relevant to whether or not Detr actually paid people when they had an eligibility determination and fall under the court's order.
Well, remember, it's a two-part analysis for the court. One is whether there's been a failure to follow the court's order, and then the second is if the failure is legally justifiable, or if there's been substantial compliance. So to the extent that staffing levels may bear on one or more of those issues, the court finds it has relevance. So under the circumstances, the objection is overruled. Mr. Whitney, are you offering Exhibit 16 into evidence and to be published?
Yes, Your Honor.
Admitted. Go right ahead.
Thank you, Your Honor. Are you able to tell us then how many staff members that Detr had processing PUA claims between July 20th and July 28th of this year?
I'm sorry, Your Honor. Did you want me to share my screen as well?
Yes, please.
Thank you.
Yes, and is the exhibit coming up or?
It will be.
Okay, thank you. All right, this is an exhibit pertaining to overtime, specifically. It doesn't have a pertinent correlation to your question of how many staff that we've had employed in July.
Okay, did Detr hire additional, do you know if Detr hired additional staff after July 22nd, 2000?
Yes, we did.
And was that additional staff to assist with processing PUA claims in order to comply with the court's order?
Yes, a significant amount was definitely dedicated to process PUA claims.
Are you able to tell us how much additional staff Detr hired after July 22nd, 2020 to?
Yes, this is a number from July through my most current tally of who we've brought on, but we've brought on an additional 102 staff from the 378 we had employed in July, bringing the total to 480. And just for clarity, this does also include part-time employees and employees or contractors that are working both UI and PUA. So it is not 480 full-time employees dedicated only to PUA. There is some part-time and mixture between UI and PUA.
Okay, thank you for that clarification. Can Detr just go out and hire extra staff on its own?
That's a yes and no question. If we have budgeted vacant PCNs, then yes, we can start the hiring process. If not, we must first obtain approval from the governor's finance office to release new PCNs for us to use. This can take some time as we need an approved staffing plan in place to be able to do that. These positions also must have a funding source, and they then would need to be built into the budget. So it's not necessarily a very timely process in a lot of cases.
Okay. Do you have an estimate of how much overtime was generated in order to comply with the court's order mandate?
Directly related to the mandate, I do not.
Okay. Are you able to tell us then how much overtime was generated with just by Detr and processing PUA and UI claims?
Yeah, absolutely. So actually the exhibit that's up right now, if you look into the top section, total hours overtime worked in agency 902, which is ESD since the beginning of COVID. So that's roughly, I believe the time frame is like March, very beginning, like second week of March is where we began to tally that based on our pay periods. That is 71,361 hours of overtime worked through the end of November.
And then how much did it cost to pay that overtime? Does the chart also show that?
The chart shows it broken down by month, but the total would be $2.8 million to fund that roughly 71,000 hours of overtime.
Thank you, Mr. Marhevka. Those are all the questions I have. Thank you.
Thank you. Examination by plaintiff. And Mr. Ott, go ahead and pull that exhibit down unless.
Could you leave it up? Could we leave it up?
Okay, beg your pardon. Please leave it up, Mr. Ott.
Mr. Marhevka, do you know how many full-time equivalent employees are working on CARES Act administration? I believe you said there was part-time and full-time, but how many full-time employees you would have specific to the CARES Act?
I would have to look to get you an exact number of for that, but we can definitely provide that.
I guess here, let me ask you this question. You know, we don't want witnesses generally to speculate. You know, the best example of that is what's the weight of Mars in kilograms? Nobody knows. But if you can estimate based on your experience, knowledge, training, and common sense, could you give us a best estimate?
And I'm sorry, that wasn't including part-time employees. You only wanted full-time employees?
Well, full-time equivalent. So for instance, in the employment law context, you have part-time and full-time employees, but based on a 40-hour a week, 50 hours or 50 weeks per year, you have what's called a full-time equivalent. So you may have 20 full-time employees and 10 part-time, but that means you have 25 full-time equivalent. Does that make sense, the question I'm asking you?
Yeah, and actually, that actually makes a lot of sense. And the way that we've been tracking, and a lot of times we don't run into that unless it's somebody that we've contracted with, such as Maximus or some of the other state agency employees, such as the DWIS group that is working with us. We haven't necessarily factored in, you know, these five employees working 20 hours a week equals 100 hours. We haven't broken down the approximation that way.
Okay, I appreciate that. So my next question is that looking at this exhibit, and it shows the number of people here, and And I asked you if that's just CARES Act people, but am I to assume that's just Detr employees in general that work on regular UI, any other, not just the CARES Act, or is this exhibit show specifically for CARES Act people?
So actually, I can give a little bit more insight and actually get back to the previous question as well with this. So in the last sample that we ran, this is Detr employed employees. So this is not counting contractors or people from other agencies that are also helping us. But ESD has, roughly 546 employees, and those would be FTEs that are either permanent or intermittent positions. And of that, 441 have worked overtime. Now, that sample also demonstrates that you could have had somebody in March, April, or May work overtime and they haven't worked it recently. So across the board, roughly, I don't know what that is, 85% of our employees have worked overtime of our entire pool.
Okay, since I'm not on screen share, I'm gonna point to, in March you had, is that 470 or 4,745, is that hours?
Yes.
And then in April, it shot up to 8,549.95. Thank you. And so I'm assuming that's because the PUA site went live. Is that correct?
Well, a couple combinations. Obviously, the first roughly 2 weeks of March, we were not in pandemic, so the overtime was definitely not occurring. And then overtime would then be ramping up because of the start of pandemic through March, and getting up to the higher rates that you see between 8,000 and 12,000 ongoing. And yes, PUA definitely has an impact on that number.
And then we're circled there, we have May, it jumped up to 10,000. Why do you believe it jumped up to 10,000 there?
There could be several reasons, but just the amount of claims, also us trying to get these other funding sources enacted and in place and start paying people out. Just because that we were awarded the CARES Act funding doesn't mean that we could immediately deploy that to the claimant's bank accounts. So there does take some time with programming, development, requirements gathering, testing. These factors are all needed to basically launch the CARES Act money into production and pay people out. And
so, I apologize, I didn't mean to interrupt.
Oh no, that's fine.
Right underneath the circle there, then it dropped about 3,000 hours. So if we look at June and July, they're roughly similar. And that was a drop. And I believe he testified because that May period was getting everything updated. So would you say June and July were a normal CARES Act pandemic staffing level?
Yeah, as far as normal a crisis can be, yes.
And then in August, it jumps up to 12,000. Do you have any information on why it jumped up to 12,000 there?
I know that we still continue to have a high need of resources needed to continue to pay people out and to work and do programming. I'm not entirely sure when the lost wages went into effect, but I believe it was somewhere around the end of August that we started planning for that, and that could be a potential reasoning for the spike.
You said something about you had payment issues. How many people does it take to pay out claims, to actually process the claim, process the check, so to speak?
I don't know. I don't have that information.
Okay.
I'm more on the administration side more than I am the actual claims processing side.
Okay, and we see here in September, they dropped down about 5,000. Do you know why there was such a large drop there?
The only thing I can think of is that the bulk of planning for lost wages had maybe been done. It definitely is leveled out there. I don't really have any other further insight of what would have caused that.
And then in October, we dropped down about another 500. And now we're at November, we're about at 55,000, which seems to be, less than 1,000 hours to pre-pandemic level. Would you concur?
Yeah, yes, I do concur. And, at this point we have processed, tens of thousands of claims. And so things are seemingly leveling out. I'm not saying that they're quieting down, but we should see this trend to continue.
Does this figure include the people that are conducting appeals?
If there was appeal staff coding time and working overtime, then yes, it would. But I don't have that breakdown in front of me. Okay.
I'd like to enter into or talk about I'm done with that exhibit. One moment, please. I don't believe we've had exhibit number 9 entered into the record yet, which is plaintiff's exhibit 9, which is UIPL letter number 2820. I would like to chat about that.
All right. Plaintiff has offered exhibit 9. Does the state have any objection?
Your Honor, no objection to the exhibit 9. Thank you.
Thank you. It's admitted. You may publish and proceed.
Hold on a second. One moment, please. I was doing so good. Okay, here we go. Okay, Mr. Marhevka, can you see that it says plaintiff's petitioner's exhibit 9, just a cover sheet?
Yes, I can.
And Mr. Whitney, can you see it? And your Honor's giving me a thumbs up.
I can, thank you.
I would like to direct your attention to page 6.
Well, let's identify what the document.
I apologize. Yes.
That's
so
right.
This is plaintiff's exhibit number 9. It's UIPL number 2820, and it's dated August 31st, 2020. I'd like to draw your attention to, I'm going to get this a little bit smaller here for us. We're going to go to page 6. I've highlighted some sections here, particularly number 5, funding for states to address fraud in the PUA and PEUC program. The department is providing a total of $100 million in administrative funding targeted specifically at addressing fraud and identity theft. The use of the funds here says states are permitted to use this targeted funding for staff or contract services to conduct fraud investigations. When we were talking about your total hours in that first exhibit, did that include fraud investigation?
Yeah, that absolutely would. And I wasn't thinking of it at the time, but it was somewhere around August as well that we started working with ID.me and really getting into the more fraud prevention side. As well as you all know, the rapid response team got brought in. So there would be, that would definitely be another attribute of the spike. And yes, for anyone working fraud for the Employment Security Division would 100% be included in that.
And they're, according to this, it seems that they're 100% federally funded. Is that correct?
The Employment Security Division is 100% federally funded.
Okay, I don't have any other questions.
Thank you, Mr. Whitney. Anything else for this witness?
Just one quick question. Mr. Marhevka, you said the Employment Security Division was 100% federally funded?
With the exclusion of the Commission on Post-Secondary Education. They do have a small bit of funding that comes from the general fund, but the major budget accounts in the Employment Security Division, the workforce side and the UI side, all are federally funded.
Now, do you happen to know when after the state entered into the CARES Act, did the state have to provide any money first before it was reimbursed by the federal government? Do you happen to know if that was the case or not?
I don't know that for sure how the funding worked. That would be something our financial management division took care of.
Thank you, Mr. Marhevka. Sorry, I'm butchering your name. Thank you, Mr. Marhevka. I have no further questions.
Thank you. I just have one question. You said your job title before, but I think I missed it. Could you tell the court that again, please?
Yes, Your Honor. I'm a management analyst.
So generally, can you describe for the court what your job description is?
Yeah, I do everything from legislation, regulations, fiscal analysis, employee tracking, inventory, if I hadn't said that already, procurement, contracts, solicitation.
Okay. And then at or about the time the court issued its order of mandate to the state, were you made aware of it?
I was made aware of the court case, but not so much of any of the particulars about it.
All right. Do you know why we're here today?
I believe so, yes.
What's your understanding?
That the department is being sued for not paying out a claimant.
Okay, I appreciate your being here today, sir. Thank you for the work you're doing. The court thanks and excuses you and wishes you a safe and happy holiday season.
All right, thank you.
You can log off. You're certainly welcome to observe the rest of the hearing today, but of course that's up to you. All right, Mr. Gaynor, please, thank you. Mr. Whitney, please call the state's next witness.
Thank you, Your Honor. The state would call Mr. Brian Bracken.
Okay.
Your Honor, I don't have an attendee with the last name Brackett. I do have a Brian. If that individual can raise his hand so I'm sure that I'm getting the right. Thank you. I'm bringing him in now.
All right, Mr. Brackett, when you're able to do so, please turn your video on and unmute the microphone. Mr. Brackett, good afternoon. Can you hear the court?
Yes, sir.
Would you please spell your last name?
It's actually Bracken, B-R-A-C-K-E-N.
Okay, Mr. Bracken, thank you. Ms. Clerk, are you able to please change the way Mr. Bracken has identified himself?
Yes, Your Honor, I'm doing that now.
All right, thank you. All right, and then once you do that, if you would please administer the oath of witness to Mr. Bracken.
Please raise your right hand. Do you solemnly swear or affirm the testimony you're about to give in this case shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Thank you, Mr. Bracken. You may put your hand down. Mr. Whitney, you may proceed.
Thank you, Your Honor. Mr. Bracken, where are you? I'm sorry. Are you employed right now?
Currently, I work on contract for Detr. I'm performing adjudication work on contract. I'm performing in regular unemployment insurance on adjudication.
Okay. And how long have you been doing the contract work with Detr?
Well, on this particular contract, it started when I retired for a second time on September 11th. So I've been doing this contract since that time. Previous to that, I was under contract as a deputy administrator overseeing PUA claim operations.
Now, previous to the time when you were the deputy administrator, were you employed by Detr?
Yes, sir.
Okay. And are you able to tell us how long you were employed by Detr?
Approximately 25 years.
And was your position with the Employment Security Division during that time?
That's correct.
And what,
I retired initially August of 2019.
and when you retired, can you please tell us what position you held at that time?
I was working at that time as a business process analyst 3, which is a managerial business process analyst. Prior to that, I was an unemployment insurance program chief for the support services office. Also held various titles as appeals chief for unemployment insurance and operations manager.
Now, after you came back from retirement, can you just describe for us your main job duties and responsibilities?
Initially in March, around March 15th or 16th, I was contacted by the administrator and asked if I was willing to come out of retirement and work for Detr under contract and help manage claim operations in the unemployment insurance call center in Carson City, or just regular unemployment insurance initially.
And did that change?
Yes, around the first week of May of this year, that changed. I was contacted by then Administrator and asked if I could pick up oversight of PUA operations as it was languishing a bit and needed to be stood up within the next week or two. We wanted it stood up by mid-May of 2020.
Now, are you aware of the Amethyst Payne case involving Detr that's in Washoe County?
You know, I'm not aware of the specific details other than what I've reviewed, for this in preparation for the hearing today. And based on testimony that I've heard, I have some familiarity based on that. I was not personally involved with it previously. I could answer some general questions about it, but.
Now, were you aware then, were you aware then of the court's order of mandate from July 22nd?
Yes, sir, I was familiar with it. I was aware of it.
Okay. Then, was it possible for Detr to fully comply with the court's order of mandate by July 28th of 2020?
That's kind of a complex. Was it technically possible? Probably. It would take some work working with the vendor, and it would take an administrative decision just to go ahead and give authority to blanket release every PUA claim that was previously held. I did not maintain that authority to do that, sir.
You mentioned blanket release of PUA claim. What does that mean?
What that means is that we would have to work with the vendor of the program of the application, which was GSOL, Geographical Solutions Incorporated, GSI, and provide them, after we did some vetting and queries and whatnot to determine that population, to say that, look, we're just simply going to remove every stop and hold on these claims and release them for payment of benefits and ignore U.S. Department of Labor guidance regarding integrity of the program and improper payment, and just say, look, let's just pay all these people.
Hold on. Mr. Bracken, I appreciate your candor. And obviously you have a significant many years of experience. But, you know, it offends the court a little bit the way you characterized compliance with the court order would lead to that level of process. I mean, let's get real here. The court was very specific in consistent with United Supreme Court guiding and binding jurisprudence that the court extrapolated to the facts here. And the court was not ordering and has never ordered people to be paid who did not deserve to be paid. The court did not order or is not ordering people who have clear and convincing evidence of fraud embedded in their application. The court did not order or would not order knowing violation of any federal guidance. So let's make sure we're using the right terms here. The court was very specific. The order of mandate said if payments had begun, now let's make sure we understand that. If payments had begun, they could not be stopped unless and until one of these four reasons triggered payments to be stopped. The court didn't order payments to begin. The court didn't order payments to be made to people who were fraudulently attempting to obtain benefits. The court didn't order the department to blanket pay anybody. That was not the court's order. And the court, frankly, would just remind both sides here that the court narrowly tailored its order to a couple different buckets of people that the court found federal law required payments to be made. As to the many other requests by the plaintiffs, the court at that time declined to order the state to move forward, and then later ultimately declined fully and finally to decline to order that. So we're all clear here. The court narrowly tailored the order to be consistent with guiding United States Supreme Court precedents. That precedence is more binding and persuasive on this court than is Department of Labor letters or opinions. We're talking about the United States Supreme Court case in Java. That was the genesis of the court's order. It was narrowly tailored. And the question today is if the state of Nevada has failed without legal excuse to comply or at least substantially comply with the court's order. So that's why we're here. And I would just remind everybody to bear that in mind. Mr. Whitney, next question, please.
Thank you, Your Honor. So would the Employment Security Division have been able to identify the different groups of people, groups of claimants that fell within the court's order of mandate by July 28th, 2020?
You know, I can't say with certainty we would have been able to do it by July 28th because obviously it wasn't completed, but we were working towards that after the order from the court. With all due respect, Judge, Your Honor, I did not intend to disrespect anyone within the court or what your ruling was. I was simply answering the question of counsel. And Detr did have the opinion, based on our review and analysis, that there was clear and convincing high rate of fraudulent activity across the PUA program. So I just want to be frank with you, sir. No disrespect meant.
Thank you. Please proceed, Mr. Whitney.
Thank you, Your Honor. So are you able to tell us how much staff you had working with you between July 22nd and July 28th working on these PUA claims?
Directly at my disposal, you know, approximately at that time. And of course I had, you know, I could make requests for staff. Those had to be approved by the administrator to work with the PUA program. I had approximately maybe 16 to 20 full-time individuals working across PUA. That would be PUA adjudication and PUA investigations that were able to review these claims once we identified our population through queries that were requested based on the court's order, these individuals that payments were stopped. And then we would have to then drill down and determine whether or not there was any fraudulent hallmarks or activities on those claims. And claims were stopped for various reasons, Your Honor. They were stopped for investigative process holds. They were stopped based on answers that claimants provided on their weekly certifications regarding receipt of a pension or some other form of payment. They were stopped based on jobs or cross matches that were run by the agency for detecting other UI eligibility, and based on our guidelines from the U.S. Department of Labor that we couldn't pay those individuals if they had eligibility for other programs, whether it be in the state of Nevada or other states, and with all due respect and understanding of your order. So, you know, Detr maintains a fiduciary responsibility to maintain the integrity of the program and to ensure that we're not issuing improper payments and we're subject to sanctions, by the U.S. Department of Labor, and holding of funding if we're not in compliance. We pay individuals that we know are filing improperly.
Mr. Bracken, you just mentioned sanctions by DOL and withholding of funding if individuals are paid improperly. When you say paid improperly, could you be more specific? What does that mean?
That could be an individual that was a fraudulent claimant that we paid, that we knowingly, you know, we had information that it was fraudulent and we disregarded that and paid it anyways. It could be that we knowingly had information that that person was eligible for a regular Nevada unemployment claim, or, for example, regular unemployment claims in the state of California, and we went ahead and paid it anyways under the PUA program, knowing it not to be correct. And DOL conducts their reviews, you know, on a quarterly basis of program integrity. And, you know, as my previous experience as the program chief for unemployment insurance support services, Detr has been under corrective action plans and determined to be previously an at-risk state for violations or not to be in compliance with Department of Labor guidance. And that part of those sanctions as a result of that can lead to withholding of funding or reimbursement for program payments that Detr makes improperly. Yes, it can lead to that.
Are there other sanctions other than withholding a payment that Detr can face for improper payment?
Oh, we could be held to report to the DOL quarterly on a range of issues or elements that we were found not to be in compliance with across the program, and we would have to provide that response. And they would provide us a spreadsheet and list all the places where Detr was not in compliance, and Detr would have to provide that response. It's referred to as an SQSP process, and provide that response to the U.S. Department of Labor Regional Office and with a copy to the main office in Washington, D.C. to state why we were not in compliance, and to also cite our how we were going to rectify that and to be in compliance in the future. So yeah, we've been under those in the past, and we are subject to those if we're found to be not in compliance.
Now, when you said improper payment, would improper payment be considered payments that are in violation of the UPOLs? Correct.
DOL would find that, you know, you were in violation or you didn't adhere to the standards of the guidance, and therefore that, you know, they're going to issue whatever that sanction may be, and that's up to their discretion based on the administrator director of the U.S. Department of Labor, and then we would have to adhere to any sort of penalties that they would issue.
Now, you had mentioned, if I heard you correctly, you had about approximately 16 to 20 staff members working for you in the time period between approximately July 22nd to July 28th.
Yeah, I mean, and we're talking several months back. I can't recall specifically. It was about that number. I had a PUA team that fluctuated, that worked on just PUA adjudication. They were also adjudicators that were experienced in the UI application. So they were kind of a hybrid, or they could cross both programs. And that was part of our review in order to know whether or not somebody qualified for POO or regular UI. They could do all of that. And then we utilized the ESD investigative office staff that was managed by Mr. Shane Ricketts. And the investigative staff would participate in these reviews as well, because of the fact that there were investigative process holds or IP holds for various reasons based on hallmarks on either their IP address, their physical address, or other attributes attached to that claim that the Integrity Office had identified as potentially fraudulent. And so we were working in cooperation with that group and utilizing their staff.
And so with a staff of that small a staff, I'm not sure if I heard your response correctly. If I heard your response when I asked you, would your staff in that time period between July 22nd and July 28th, with your staff of people that you had, would you even have been able to identify the different groups of claimants that fell within the course order mandate in that 6-day period or 7-day period?
You know, and to be frank, sir, no, we would not. There was no way we'd be able to do that. It takes, you know, a couple of business days to formulate the queries, and then once we've determined the type of query that we need to request, had to work with our provider for the application, GSI, in order for them to facilitate that. We also worked with our ESD internal research and analysis office and Mr. Schmidt to perform queries for us as well. But those took a matter of, you know, maybe 2 to 3 days, or, you know, dependent upon what sort of cooperation or availability was there for resources with either RNA staff or GSI. And then once we received those queries, I would have to direct my management staff to distribute those queries for review amongst that 16 to 20 staff members. And at that time, we were reviewing or able to review approximately 500 to 700 claims per day, sometimes more, sometimes less. It depended on whether or not there was conflicting priorities. We're also trying to stand up the appeals application at that point too. And so I had a small group of people with a lot of job requirements or duties that were expected to be performed. And so we certainly did the best we could. There was no willful disregard of any court order. I can say that with certainty. I was never told to disregard any court order, and I never took it upon myself to blatantly or directly or purposely disregard a court order.
Thank you, Mr. Bracken. Those are all the questions I have for you. Thank you.
Thank you. Examination by plaintiffs.
Good afternoon, Mr. Bracken. Can you please tell me who at Detr determines the parameters or the definition of clear and convincing evidence of fraud?
Well, I mean, that would be based on administrative level staff in conjunction, meeting and conference with our integrity office. And certainly there were a lot of hallmarks present with these PUA claims that appeared to be potentially fraudulent. I know that Ms. Allender worked for me under my direction, as she testified previously today. And she would be responsible for conducting reviews of PUA claims along with other staff that were assigned. And we were running at the rate of a good, most days, 9 out of 10 PUA claims that we reviewed had elements that have been identified as fraudulent based on their email address, their address, location, or physical address, based on telephone numbers and other attributes that were identified from other states and from our vendor that were also hitting other states.
I don't want to cut you off, but my question was pretty simple, and that who determines what clear and convincing evidence of fraud was, and I believe you said that was at administrative level. I think you also testified. I have that here. You testified that you were looking at 700 per day fraud determinations, but
No.
you just said you had 9 out of 10 had an element of fraud. So you had 700. You looked at 700 per day. I didn't understand.
I didn't state that, or maybe my testimony was misunderstood. I testified that our PUA team that were assigned to these query lists of the identified claimants were able to review 500 to 700 claims per day. Now, during those days, were there many claims that we released for payment based on review of the claim to ensure that they had uploaded their identification documents, which we had sent out on messaging to claimants. If they met all the elements of being a legitimate claim, we released those as one-offs as they came across those. The adjudication staff would release those claims for payment.
Do you have a percentage of that 500 to 700 which were released?
No, I do not.
Do you know how many people had start-stops that were issued fraud determinations?
I'm sorry, what was the question, ma'am?
Sure. Do you have a number of people that had start-stops that were issued fraud determinations?
I do not know of any individuals that were issued specific fraud determinations prior to my leaving my oversight position with Detr. I left there on September 11th, so I really have no knowledge of PUA operations since September 11th. I just want that stated on the record.
Okay. And in your experience while you're at Detr, you said 500 to 700 per day. Do you know how many of those people were afforded an opportunity to be heard?
Well, what happened with those, ma'am, is our adjudicators and investigative staff were reviewing those, and through documents or through communications in the PUA portal, and they were able to communicate with those claimants. So let's say, for instance, they came across a claim where they had provided their identification documents appeared to be legitimate. They had met the eligibility requirements that we've set forth, and so they would simply release the claim. Now, in reviewing that claim, if that adjudicator found that there were missing documents, they hadn't complied, for whatever reason, they didn't previously receive the blast message, then excuse me.
Everything okay?
Technical issue on my side, Your Honor. I apologize. Something popped up on the screen. I just wanted to make sure it didn't interfere with the court hearing. Getting back to what I was stating, our adjudicators would be in contact with the individuals that they were reviewing through the portal and say, hey, hi, look, I'm reviewing your claim. I see that you didn't upload, XYZ, ABC. Could you please provide that documentation? I'm going to give you 48 business hours, which is a US DOL standard for providing, reasonable contact or reasonable time for an individual to respond to a claim request. And so they would notify them through the portal and say, please provide that information so we can make a determination on your claim. So that was done on those.
Okay, so are those people that had a denial, or it was just a claim being reviewed?
Claims were being reviewed. If there was a denial for determination that was justified for any particular reason under unemployment insurance law or based on the guidance from the USDOL, staff was instructed to issue those determinations, ma'am. When they found someone that was not in compliance and warranted a determination. So they were directed to do that. Can I also continue to state that they were directed to clean up the claim for what, if let's say this has been discussed previously with the court. I know that, we had people that had regular UI eligibility, we had people with PUA eligibility. We got to pay them in the proper program. that staff was trained in a manner that which when they were reviewing those, that person had regular UI eligibility. They were instructed and directed to take what necessary action there was needed to clean up that claim and place them on the proper UI claim and contact them and tell them, look, we're moving you to regular UI. This is what you need to do. So they were given that direction.
Mr. Bracken, I'm going to pull us back here. We're specifically talking today about people who had start stops. You've thrown out a number of 500 to 700 per day. I don't think that's start stop people. I think that's the whole universe of UI and PUA. Am I correct in that?
No, ma'am, that's not. No, that is start. Those are, we conducted queries. We gathered that population of individuals based on the criteria set forth by the court. We were given these lists with thousands of PUA claimants, and then they would be distributed out to staff and say, look, work these lists, and these were PUA claimants that were stopped.
So there was 500 to 700 per day of people that had PUA claims that had start stops.
That were being reviewed, previously stopped, okay?
And then they were reviewed.
Reason.
Okay.
And then we were reviewing those to see if we could issue payment.
But you're unable to tell the court how many people had start stops that were issued fraud determinations. Is that correct?
There were no, well, I stated on the record, there were no fraud determinations issued at that point, ma'am.
And you don't from
Well,
September.
hold on. I want to make sure I understand fully, because Mr. Bracken, I mean, you've indicated there were indicia. There was concern, there was evidence. At least that's the gist of what I'm getting. But and so do I have that right so far? There were some tells that might lead to a fraud determination that you and your staff were seeing fairly commonly on a daily basis. Is that fair?
Well, let me clarify that. Yeah, that's fair. That there were hallmarks or tells, as you stated, Your Honor, that indicated that there was potential, a high potential for fraudulent activity in the program and with the claims that we were looking at. Yes.
All right. All right. Now, Ms. Jones is trying to narrow that down to people who received a fraud determination letter, email, correspondence, communication consistent with Department of Labor guidelines or other state or federal law. Ms. Jones, do I have it right that that's the area of questions you're going in right now?
Yes, Your Honor.
All right. So the witness has testified, Mr. Bracken has testified that to his recollection, there were none of those. There were, however, a considerable percentage of hallmarks that were of concern to those reviewing the benefit requests. All right. That's what the court's taking away from that. All right.
With the court's allowance, Your Honor, I want to clarify that.
Go ahead.
As far as a stated fraud determination, sir, which has different language and different reference to law, were any of those issued per se? No, sir. Based up until the time that I departed the agency in my position as deputy administrator of the PUA program. Were there determinations issued to those individuals because they didn't meet eligibility requirements based on we couldn't validate their identity, or they didn't comply with our eligibility requirements that we had asked them to comply with, sir? Yes, those determinations were issued, but a specific fraud determination, sir, had not been issued at that point.
All right. So then with relevance to this hearing, the bucket of people that you've just described that were issued determinations that there were concerns or issues or problems. The unique subset of all claimants that the court's order spoke to are those groups of people for whom payments began and then they stopped. And because those people in the court's estimation, again, the court's understanding of guiding jurisprudence from high above is that you're not allowed to stop the payments absent one of the criteria the court identified in its order of mandate. We're not talking about starting payments initially if the department had concern. We're not talking about people who clearly were attempting to defraud the state of Nevada. We're talking about those that receive payments because the United States Supreme Court has determined that those people have different rights than people that had not had payments begin. So Ms. Jones' questions about was there a fraud determination, because the takeaway for the court is if such determinations were sent and received, those people then have the right to protest or engage or attempt to explain away the concerns that the state was had paused the payments. But absent that, then depending on who you believe, the court's order should have required payments to continue, notwithstanding the hallmarks or the tells or the concern, unless the concern rose to a heightened level, clear and convincing evidence, which most of us know, and those that are not legally trained should know by virtue of their counsel, means more than just 50%. It needs to be considerably more than that to stop the payments. So you and Ms. Jones can spar around the language, but for the court, Mr. Bracken, I guess what I would like to know is, did anyone who had to your knowledge, did anyone who had payments begun have their payments stopped because Detr was concerned with hallmarks of fraud, but that fraud did not arise to the level of much more likely than not? That's really what I would like to know. Do you have an opinion on that?
Well, my opinion is, sir, we're really, as Ms. Jones referenced in prior testimony and UPLs, which I'm well aware of, for unemployment insurance, is that a real determination of fraud, to make that determination can't be until we've completed an investigation and make a determination whether it was willful, whether it was inadvertent, whatnot. There has to be an investigation that takes place. Certainly, did Detr feel there was clear and convincing of evidence of fraud across the program? Yes, sir, without question. I'm going to go back in time a little bit. There were, individuals that were receiving unemployment PUA benefits, and then we implicated a security measure in cooperation with the GSI. It was called a two-factor authentication. This may have come up previously in hearing testimony and other sessions, in which there was an issue where claimants, when we implemented that two-factor authentication, they had been receiving benefits. They had to do something. They had to receive some sort of a text code or email code, and then provide that information in order to continue filing their claim. It was two-pronged. There was a problem with the application itself that we got fixed shortly thereafter. And it was also claimants that couldn't authenticate for one reason or another based on that message that was sent to them either through email or their phone number on record. And so those held claims that were previously being paid, sir. And those created investigative process holds on there, which I didn't have oversight of that, the investigative process holds, but that was done by the investigative office. So what I tried to explain earlier in my testimony, Your Honor, is that there were various reasons why these individuals that were being paid PUA benefits were stopped, subsequently stopped. And then, there was review processes that needed to take place and say, why were they stopped? Can we release it or fix it, and comply with the order and continue payment?
Okay.
Does that make sense, Your Honor?
It does. Thank you. So, Ms. Jones, what's the beef the plaintiffs have with that approach? Because, just some modest concern with some of the descriptors used to apply for benefits, that's not what Mr. Bracken's testifying to. He's testifying that there was some concern, and then there was an attempt, for example, to email or text someone and have them have to, respond that it's really them, and they can, so if they've attempted to get people to confirm that they are who they say they are, and done a couple different things and still aren't receiving assurance, why would the plaintiff's counsel here have some concern that they're violating that portion of the court's order of mandate? Seems to the court that might arise to a preliminary evidence of clear and convincing.
Sure.
Why do you think differently, Ms. Jones?
If Your Honor will allow me to bring back up on the screen exhibit number 8, UIPL
Yes.
0116.
Please.
Your Honor, can you see plaintiff's exhibit
Yes.
number 8?
Yes.
Mr. Whitney?
Yes, thank you.
Okay, I would like to go to page 6. You were talking about a blast or an email or something like that. That's how you contacted people. Is that correct?
The blast messaging was done and was also embedded in the application. That's correct.
Okay, so under the UIPL, when you're making a determination for fraud, it is incumbent upon a state to make further contact with the individual, inform him or her of the conflict, and allow an opportunity for rebuttal. Because such factual conflicts require the state agency to make a determination of credibility and intent, determinations of fraud must be made by agency staff. The determination may not be made by an automated system. And so that's where plaintiffs take issue with this email blast or having people do ID me or something else like that. And if they fail to do so, and there could be legitimate reasons, they don't have their phone anymore. They can't pay for it. Their email shut down.
Well, hold on. This is closing argument. So the question to the witness is, how does he reconcile what his experience was when he was there through September 11th was with what this guidance suggests should be done? Were they consistent? Were they inconsistent? And if inconsistent, how come? I guess that would be the question.
Thank you, Your Honor. Yes.
Ma'am, Ms. Jones, what's the specific question you would like me to answer?
How did your explanation of providing an automated ID me or response or something like that escalate claimants who had issues with IP or something like that to a clear and convincing badges or evidence of fraud such that their payments should be stopped?
Well, we only have so many tools at our disposal and actual physical resources, workers to review. So I'm sure you do business with a bank, credit card company, a car loan provider that has a two-factor authentication. I know I do personally. That sends me a code. If I don't respond or don't authenticate based on that code, I'm not allowed in the system. I'm not identified as that owner or user of that particular account. So we were utilizing that type of functionality to assist with this mass number of individuals that we had to deal with, unprecedented, that which Detr has never seen the likes of, and a staff that was overwhelmed and overrun. This has all been said before. And we had to revert to technology in order to assist us in identifying individuals or seeing if that individual is actually who they say they are based on our best availability of resource, and then move forward. Now, if individual stops were put on a claim based on our inability to identify or validate someone, obviously those would need to be scheduled or handled by a fraud investigator or our staff member at a later time to review, adjudicate, for lack of a better terminology. So based on sheer numbers, ma'am, not to say that Detr isn't going to do those investigations or review those claims, but there's a finite amount of people that we have at our disposal to do those investigations. And you're talking about hundreds of thousands of individuals. With all due respect to the court, that does take a bit of time to do that. And, even though we've hired, Detr's hired individuals, extra workers and allowance for overtime, there's a backlog of work. I'm working UI claims now, and there's still a backlog of UI claims. So the backlog is there. We're doing our best that we can to work through it. That's basically all that I can state. Were those investigations going to take place, ma'am? Yes. When they were going to take place, I cannot testify to that. I did not oversee the investigative office.
So the hundreds of thousands of people that have failed to receive benefits just have to wait.
Well, that's argument. So, Ms. Jones.
I have no further questions.
All right, thank you. Mr. Whitney, any further questions of Mr. Bracken?
Thank you, Your Honor. Yes, just a few more. Thank you. Mr. Bracken, are you familiar with, Ms. Jones has been asking you about UPOL 01-16. Are you familiar with that UPOL outside of this court hearing?
I'm familiar with all UPOLs that were issued, sir, in regards to the PUA application. That's a yes.
The language, the determination may not be made by an automated system. What does the determination, what does that mean to you when that particular sentence? Does that mean that you cannot send out a blast concerning a person's identification?
Oh, I mean, those blasts, sir, were not determinations. Those were communications to PUA claimants to tell them what the eligibility requirements were and what they needed to do to comply with that review. That in and of itself, sir, those blasts were not a determination. Now, before any sort of mass determinations may have been issued by the agency, those were done after reviews were conducted based on information on those claims, and it was determined that those individuals didn't meet whatever the requirements were for that particular issue related to either PUA or unemployment, and were issued determinations on that. So did the vendor have the ability to say, hey, look, we reviewed 2,000 claims. These individuals we reviewed, they either they haven't complied with the requirement or whatever it was, issue the determination and send them all out. Those were done only after a review was conducted, and those individuals were contacted or given the opportunity to provide information back to us that was being required or asked of them. And then if they didn't comply, then there was a job run to issue determinations in mass. Does that answer your question, sir?
Yeah, pretty much. Thank you. You'd also, I'm hoping I heard your testimony correctly. You mentioned hallmarks of fraud, I believe. Is that correct?
Yes, sir. I don't really want to get into the specifics of those hallmarks. I mean, there were some that were related to what their email address ended in or how they formulated their.
Well, we don't want to telegraph to the bad guys how they can beat the system by identifying all the ways we caught them in fraudulent activity, and the court's not encouraging that. Right. I continually want to circle back here, because whether we call it hallmark, indicia, a tell, a strong suspicion, the court has to determine if it arises to a heightened standard of clear and convincing, which is a lot of hallmarks, a lot of indicia, or else, according to the court order, after a lot of thought and review of the law, those people need to be paid until and unless a determination is more properly made, or they have an opportunity to appeal and dispute. So that's really where we're going. But Mr. Whitney, I didn't mean to cut you off there, but that's what the court's takeaway is from what Mr. Bracken has testified to already.
Thank you, Your Honor. Just one more quick question to Mr. Bracken. Mr. Bracken, you testified that you estimated that your team was reviewing between 500 and 700 pool claims where payment had been stopped. Is that correct, per day between July 22nd and July 28th?
Yeah, that's correct, sir. That's what I testified to.
Are you able to remember how many total pool claims that you and your team began to review? What that number was?
You know, sir, I do not. I can tell you that we looked at thousands of claims per week, and Your Honor, that that we've provided testimony to the court that Detr has released in mass bunches of individuals that were held for payment that we validated and released payment on it in the thousands. I know we didn't fully comply with the order, sir. I understand that, but we were working to the best of our ability, sir, to be in compliance, and we were working to facilitate payment of benefits. But I can't give you a specific number, Mr. Whitney. Thousands.
Thank you, Mr. Bracken. Those are all the questions I have for you.
Thank you, Ms. Jones. Anything else?
No, Your Honor.
Mr. Bracken, thank you for your time and your testimony. To you and your family, a safe and healthy holiday. You can drop off the call. And well, actually, before you do, let me just ask you one last question, please. Were you watching the hearing up to the point in time that you were called, or did we get you on just right when it was your turn?
Oh no, I was on earlier today. I've watched previous hearings, hit and miss.
Right. So you know as much about this whole case as any one of us on this call.
I pretty much do.
All right, good. Well, you heard witnesses for the plaintiff, Heather Boyd, Stephen Kolznick, and then Greg Daugherty. And then you heard me ask some tough questions of Ms. Allender, and you already heard me thank her for her work and what a difficult job she's got right now. And you probably had as well through September 11. But would you agree with the court that, hearing what the situation is of Ms. Boyd, Mr. Kolznick, and Mr. Daugherty, they ought to have been paid or captured by now under the court's order? Is that fair, or do you maintain that based on what happened with their cases, the Detr was in its right not to have paid them fully by now?
Yeah, we're with all due respect, sir, we're going to agree to disagree on that. I think there, initially on Ms. Boyd, regarding Ms. Boyd, I think there were tells or hallmarks of possibly misrepresentation or fraudulent responses for claim filing. Certainly that had to be investigated. Certainly she was due her opportunity to provide information upon request and refute that belief. And I acknowledge that. Based on our inability to get to all of these people, that wasn't done for whatever reason. Certainly it's not something that we feel good about. Regarding the next individual who had, I can't recall his name now.
Kolznick, yeah, the umpire.
Right, correct. He had, my understanding is that, sir, he had eligibility for an alternate base period claim effective April 5th. That was communicated to him. It was communicated in the determination that he needed to contact the agency Detr to file that claim. He testified that he attempted to do that. He didn't complete the claim. That's why it fell off and went away. I just wanted to put that on the record. That claim was not completed by him, sir. That wasn't officially completed. So that's why claims go away within a certain amount of time if they don't do what they're requested to do. He was requested to contact the agency. Certainly an individual that's desirous of receiving unemployment insurance benefits should continue to make reasonable attempts to contact the agency. We do know, Your Honor, that there were thousands and thousands of claimants that got in each week to talk to a call center representative regarding their unemployment insurance claim. That's fact. That information has probably been stipulated or can be provided to the court. So do you have to continue to do some due diligence to get in and talk to somebody? Yes. Is it difficult? Yes. Were we overwhelmed? Yes, sir. But he was communicated to file that regular UI claim, which we were mandated by the Department of Labor to pay him under that program. Regarding the last individual, my understanding of that claim is, sir, is that he had regular UI eligibility in the state of California. He had wages reported from an employer in the state of California. We have seen evidence, sir, of multiple claimants in the PUA program that are not only filing Nevada PUA and receiving PUA benefits, they're receiving regular UI benefits in various other states and receiving PUA benefits in various other states at the same time. Obviously, that's
fraud. That's fraud.
That's fraud. So I'm not saying that in this individual's case, but I know that he was told in his determination, sir, that he needed to contact California to file a California unemployment insurance claim. So I mean, that's my understanding of these claims, sir. Other than that, I don't have any other detail to those, but we were doing our best to be in compliance, not only with your orders, sir, the mandate of the court, but also to be in compliance with our other master, in a sense, the U.S. Department of Labor. It's a
I appreciate your response and the candor, and you're right. We're probably going to have to agree to disagree, at least on part of what you just said. And I understand there's in the minds of the state here, there's a tug of war or a tension between the court's order of mandate and Department of Labor guidance. Of course, the court took that into account in advance of issuing its order and took into account its understanding of federal law, both legislative and judicial. So fair enough. But I appreciate you answering the court's question. All right, before you drop off, Mr. Whitney, based on the court's last question and the witness's response, do you have any additional questions you'd like to ask him?
No, thank you, Your Honor.
Ms. Jones.
No, thank you, Your Honor.
All right, thank you very much. Sir, again, a happy holiday and safe to you and your family. You can drop off the call. Mr. Whitney, if you would please call the state's next witness.
Thank you, Your Honor. We would call Mr. David Schmidt as the state's next witness.
Okay.
Your Honor, Mr. Schmidt has joined as a panelist.
Thank you very much, Mr. Schmidt. Good afternoon. Can you hear the court?
Yes, sir.
All right, nice to see you again. Ms. Clerk, if you would please administer the oath of witness to Mr. Schmidt.
Please raise your right hand. Do you solemnly swear or affirm the testimony you're about to give in this case shall be the truth, the whole truth, and nothing but the truth, so help you God?
I couldn't quite hear you, Mr. Schmidt. Did you say I do?
Yes.
All right, thank you very much. Mr. Whitney, you may proceed.
Thank you, Your Honor. Mr. Schmidt, would you please state and spell your last name for the record?
My last name is Schmidt, S-C-H-M-I-D-T.
And Mr. Schmidt, where are you employed?
I am employed in the Research and Analysis Bureau of Detr.
How long have you been employed with the Research and Analysis Bureau?
I've been with Detr for a total of 15 years, in my current position for about 3 years, and with the Research and Analysis Bureau for about 14 years total.
Now, what are your main job duties and responsibilities?
So as the Chief Economist of the Research and Analysis Bureau, I'm the head of the Research and Analysis Bureau, which is a separate division within Detr from the Employment Security Division. Also, from mid-March to June 4th, I worked within ESD as acting Deputy Administrator for UI. Within my current position, I manage the Research and Analysis Bureau, and we provide data analysis and support for other divisions within Detr, including reporting and data validation for the Unemployment Insurance Program. I also work in cooperation with U.S. Bureau of Labor Statistics to produce and publish labor market information, including unemployment and employment data, and work in cooperation with the Department of Labor to produce data reports, analysis, and projections related to Nevada's workforce.
Are you aware of the Amethyst Payne court case in Washoe County?
Yes, sir.
Excuse me one second, Mr. Ott. Did Mr. Ott drop off?
I don't see him, Your Honor. I will check the attendee.
Okay, we're just gonna, everyone please stay where you are, and we're just gonna wait a moment for Mr. Ott to get back on.
He's rejoining now.
Thank you.
Thank you, Your Honor.
Yeah, was it just a technology thing, or were you tired of listening to what was happening here?
Even if I was tired, I wouldn't admit it. No, there was a technology issue. I exited at some point in Minister Brackett's testimony, got back in, and I was just about to email Mr. Gaynor to get promoted when you noticed my absence. So thank you, Your Honor.
All right, very good. Mr. Schmidt was giving us the background of his professional experience with the state of Nevada. Mr. Schmidt, I didn't mean to cut you off. I'm not exactly sure where the last question was. Mr. Whitney, what were we finding out about Mr. Schmidt?
Your Honor, we were just finding out if he was aware of this court case.
Yes. Well, the court recalls seeing and hearing from Mr. Schmidt in prior hearings. All right. You may continue, Mr. Whitney.
Thank you, Your Honor. And Mr. Schmidt, you're familiar with the court's July 22nd order of mandate in this case, correct?
Yes, I am.
Chief Ott, could you please put up exhibit number 17?
That will take me a second. I have to reopen that drop folder that crashed, but I'll get it in a second. 17, you said?
Please, yeah.
Has there been is 17 admitted? Is there an objection, or am I good to share, Your Honor?
Is there any objection from plaintiffs to exhibit 17?
None.
It's admitted and you may publish.
Thank you, Your Honor.
Mr. Schmidt, did you create exhibit 17?
Yes, I did earlier this week.
Now, can you please tell us, just looking at what does page 1 of the exhibit represent?
This report takes a look at all PUA claims to roughly November 23rd. That have received payment at some point, then had payment stop, and that where that stop was due to denial on a specific issue. In this case, it would be the status code was a disqualified week, which means there was a determination on a particular issue. So it's everyone who had received payment and then did not receive at least 1 week of benefits due to a denied issue.
Well, let me make sure I'm understanding. So the numbers at the right should add up to 100%. Is that correct?
Yes. In some previous versions of a similar attempt to talk about these sort of issues that we have, I went through and did every issue on every claim. And so the totals added up to more than 100%. For this particular report, in an attempt to classify it and make it a little bit more understandable, I went through and there, you see the footnote at the bottom of this page, and that says the order in which I stopped counting. So if I ran into an issue code of 750, I counted it in the 750 group and then did not count it in any subsequent groups. And then 746, 261, 753, and 751. And so this represents the first of that list of issues that had a denial on a claim that had payment stop where payment had previously begun.
All right. So, and before Mr. Whitney asks you another question, I want to just follow up. So, for example, that very first line item, 750 people, code issue 750, with almost 10,000 people representing 44 2/3% of the whole group. started receiving payments, and then it was stopped because the Unemployment Security Division learned or believed or discovered that the person was eligible for regular unemployment insurance or benefits from another state. Is that fair?
Yes, Your Honor.
Now, again, I don't want to sort of argue philosophically, but somebody had to give a directive at Detr not to pay these people, even though the court's the court's order of mandate didn't directly capture that bucket of people. It didn't say, don't pay these people once you've started if they have UI eligibility still in Nevada. It didn't say, don't pay these people if you have UI or any other employment benefits available in another state. It didn't say that. My order did not say that. Again, this is the unique group of people that had payments begin, not the people who were applying and hadn't yet received benefits, but people who received a benefit and then had it stopped. And I've heard from several people that the thinking was that the Department of Labor guidance required that failure to abide that would jeopardize the state's funding, that might subject the state to sanctions or punishment, or worst case scenario, have to disgorge money that it had already received from the federal government. But yet, this court's order took that into account before, and that's why the court's order was tailored the way it was. So somebody at the state had to have made the decision, either unilaterally or collaboratively, not to pay these people. Mr. Schmidt, were you in any meeting, discussion, email chain, other than with counsel, where that was brought up and somebody in your presence decided not to pay those people? And if so, who was it?
I believe that authority would rest with the Employment Security Division administrator. I know that there was discussion with one of the administrators on that point and whether payment should issue for these people.
Okay, were you in that meeting or on the call or the Zoom call?
I know that it came up. I don't remember exactly when or where.
Okay, who was the administrator at the time?
At the time, it was Administrator Goff.
And what's your memory of what the discussion was? Again, other than in the presence of a deputy attorney general or other counsel that was representing the state?
As close as I could come would be that in paying those people would be in violation of the Department of Labor's guidance, and that we needed to follow that. But I can't really get into the specifics. It's been a while. I'm sorry.
All right, fair enough. Thank you. Mr. Whitney, you may proceed. Thank you, Mr. Schmidt.
Thank you, Your Honor. If you turn to the second and third page of Exhibit 17, can you please tell us what do those two pages represent or show?
Yes, pages 2 and 3 both are very similar, except these deal with people who had payments start and then payments stop, but it was not due to an issue that had a denial code on it. Rather, it's an unresolved or open issue. And so a lot of the same codes will pop up. Sometimes an issue will be flagged as one issue, but resolved as a different type of issue. So there's a larger group here.
Mr. Schmidt? Your Honor, for some reason, Mr. Schmitz, I don't know if it's sounding somewhat garbled to me. I don't know if it's my equipment or if everybody else is.
Well, I've been tracking on the separate OneDrive drop that I received, so I can see it's just fine. But and I can see on the shared screen, I can see page 2. Although it would be nice if you could make it a little bit bigger.
Your Honor, actually, no. I was saying that this Mr. Schmidt's testimony, it's becoming somewhat garbled. I was wondering if that was just.
Oh, beg your pardon. Not to me. I could hear him just fine. But maybe if people that have their microphone on like I do, if I mute it, it might help to make him heard a little bit better by all.
And I will sit a little closer to the microphone and turn down my own speakers as well, just in case. So this is similar to the first page, except these are issues that were unresolved and still open, as opposed to issues that had a denial on them. Because an issue may get resolved as a different issue than where it's initially established, this is a longer list, but that is the key difference. And so these two lists, as far as I can tell, should be mutually exclusive. So someone that's on the unpaid due to denial for a particular week won't also be counted for that week as someone with an open issue. And except in the case where a denial is only covering a limited number of weeks, it should be generally mutually exclusive across all claimants. And so I think that adding together the two reports gives you a larger picture of issues that are preventing payment to people who had been previously paid.
Okay, Mr. Whitney, again, I'm going to exercise the court's prerogative here. I have a few more questions for Mr. Schmidt. Mr. Schmidt, can we go back and please, Mr. Whitney, excuse me, Mr. Ott, would you go back to the first page of Exhibit 17 again? Thank you. All right, so Mr. Schmidt, I asked you about the 9,841 people that the Unemployment Security Division believed had eligibility in other programs, even though they started to be paid. The next bucket looks to the court like these are ones where there was some strong belief that fraud activity was ongoing. Is that fair, a fair characterization?
I think that's representative of how this issue typically gets used, though someone from the program might have a little bit different flavor to it.
All right, fair enough. Then how about the third bucket, the one with 3,916 people? The headline of does not meet eligibility requirements specified in UIPL 1620. And so, for example, the unemployment status is not affected by the pandemic. They were unemployed before the pandemic, et cetera, et cetera. Those 4 bullet points. And then even underneath those, some related issues, unable to verify identity, things like that.
Yeah, so this does have a number of different reasons why this code would be used to flag the denial. As you indicated, there are a number of different ways, and this is a list of explanations that I got from the program, so I can't go into too much detail. But I do know that some examples would be someone who provided in their claim that, for example, they became unemployed prior to the start of the pandemic, or they were unemployed for a reason that was
okay. I understand that, and so let's focus on those. Let's suppose the Unemployment Security Division learned or believed that the person's employment status was not affected by COVID-19. So if somebody initially applied for benefits and the determination was made that their employment status was unaffected by the pandemic, they wouldn't be eligible for benefits. But what about those people that had benefits begin and then later Detr determined that the employment status was not affected by COVID-19? Are you suggesting that somewhere in the 3,916 people are several people who fall into that category? Because again, referencing back to the court's order of mandate, that wasn't one of the criteria that the state could utilize to stop payments, right?
That is a possibility, but because this is such a broad group, I cannot say with certainty how many people are in one reason or another reason. How many of them are in that particular...
Well, it's under the PUA eligibility header on the left, unlike above it, where it says investigation case special project, which to the court is code for this looks like it could be fraud.
That would be true. However, I believe looking at, look at my own copy here.
Well, PUA eligibility...
in the way that I reported this,
yes.
Because I flagged someone in this group prior to the 261 group, I did 750, then 746, then 261. It's possible, even though there's more 261s overall, that someone who had both a 746 and a 261 denial would be counted in the 746 group and not the 261 group. So the 261 could be larger and the 746 smaller. That is an artifact of the way that I compiled these particular numbers. It would certainly be possible to do so differently. I would just have to tweak the code a little.
Well, okay, so thank you. But again, and you know, what I'm trying to get a sense is, does the state, does the administrator, Kefrata, do the other senior administrators, are they in line with the concept that if there's even a single person, not 3,916, but just one, who was receiving benefits and later had it stopped because the employment status was determined not to have been affected by COVID-19, that they should have had them restart because the court ordered it? That's what I want to try to understand. Do you understand differently, Mr. Schmidt?
That seems correct to me, though I would, add the caveat that I'm not a part of the Employment Security Division, and so I don't know the specific implementation of how these have been used, but I think your explanation sounds consistent with your order as I understand it.
All right, fair enough. Mr. Whitney, please continue.
Thank you, Your Honor. So as of approximately late November, when you generated the Exhibit 17 with the data you had, how many people, can you tell us how many people then would have been covered by the court's order?
So the maximum potential number of people, I just have to pull up my notes on this. I think the maximum number of people who had received payment at some point was 131,207 PUA claims so far. Of those, 33,777, the total of the 11,741 and the 20,000 something number, 22,000 something number for the denial list. Adding together, that's, I think, the total number of unique applications that have been unpaid at least 1 week after July 10th, which is when I started counting this. So 33,777 unique applications, a total of a little under 270,000 individual weeks of benefits due to either an open issue or a denial on their claim. I could also include for those people, the total number who had excess earnings or had no claim filed. I had 26,117 unique applications and 84,816 individual weeks of benefits that had previously been paid and were unpaid due to excess earnings, and a total of 86,172 unique applications and 1,122,293 individual weeks of benefits from July 11th through November 14th. Due to having no weekly claim on file for that week. And I did go back a week for that to avoid overcounting because my data is only a couple of days after November 21st, and I didn't want to inflate that for people who had just not happened to file for the most recent week of benefits yet.
All right, well, what's the bottom number? I mean, because as we all know, if the applicant didn't file for weekly benefits, they're not captured by the court's order. If they had earnings in excess of what would otherwise qualify them for benefits, they're not captured by the court's order. If the state believes that it has some very, very strong hallmarks of fraud or tells, then they're not captured by the court's order. And finally, if they've been afforded an opportunity to be heard because the fraud was directed, the concern was directed to them and they had an opportunity to respond and be heard or otherwise have an appeal set and heard, they're not captured by the court's order. But the rest of the people, arguably are captured by the court's order. So, Mr. Schmidt, is that otherwise captured by the court's order, the 33,000, or is it some subset of that?
I believe the 33,777 would be the group that has to be looked at. What I can't say just by looking at the individual issue codes, as I think you got a flavor of here, is whether that issue code represents having clear and convincing evidence of fraud. That not looking at the individual claims, I wouldn't want to make that judgment call. I have been involved in trying to help query groups of people, like those that had not submitted documents, but that call, being a separate division of Detr, is not one that I would want to make, but I would believe that it is a subset of that 33,777 applications.
Well, even if
they had clear and convincing evidence of fraud or had had an opportunity to be heard or not.
Okay, thank you. Even if it's all 8,164 of the people in issue code 261, and even if we were to add all the people in 746 issue code of 3,916, because there appears to the court to be some overlap with the investigation case special project, that puts us up to 12,000. That still leaves 21,000 people. And so it's of concern.
Your Honor, if I may.
Go ahead.
To those two numbers you just cited, I would also look at the unresolved issue lists, because those same issue codes, the 261, the 746 is pretty small on that one, but 261 in particular, they do appear in multiple places, and so I would include that as you're looking at that.
Well, now, okay, so thank you for pointing that out. So then the number grows fairly significantly. Then of the 33,000 that are unpaid, grows arguably to 20,000 people out of the 33. That still leaves 13,000 people that, again, depending on your view of the court's order and the requirements of the law in light of the tension, which the court's not conceding that its order violates or even gets close to the line directing the state of Nevada to do anything inconsistent with the Department of Labor guidance. That would be the farthest thing from the court's mind, and the court would have no intention of doing that for myriad reasons. That would jeopardize hundreds of thousands of people that are being paid without issue. So having said that, even if the court were convinced that there are strong indicia, clear and convincing indicia of fraud or hallmarks of fraud, that still leaves more than 10,000 people that, from where the court's sitting, should have been captured by the court's order that may not have been at this point. If I'm understanding this correctly. All right, Mr. Whitney, please continue.
Thank you, Your Honor. I want to kind of shift gears a little bit.
And I want to remind everyone, I do have a hard stop at 5 o'clock today. So we're going to be done with this hearing. So let's make sure we save time for argument, at least between 4:30 and 5, and we get through all the witnesses no later than 4:30, and that's with a 15-minute break coming up about 3 o'clock.
Thank you, Your Honor. Didn't kind of forget the time sometimes. Shift gears a little bit, Mr. Schmidt, and there was a mention by the court, actually, I think he mentioned it, some of the people that had worked for Detr in the past. Is Administrator Goss still employed by Detr?
No.
I'm sorry, was that a no?
Correct, no.
Do you know when she stopped working for Detr?
I believe it was around Labor Day weekend, but I don't have a specific date.
And how about how about Dennis Perea? Is he still employed by Detr?
No.
Do you know approximately when he left work for Detr?
I believe that was around mid-July.
And how about Heather Korbolik? Is she still employed by Detr?
No.
Do you know approximately when she stopped working for Detr?
That was mid to late June.
In your opinion, is Detr doing everything it can to comply with the court's order of mandate while still trying to follow US DOL guidance?
With that last caveat, I would say yes. I think that there is a difference of opinion within the Employment Security Division about the provisions of the PUA program regarding program eligibility and other programs in particular. But I know that they are working hard trying to get through as many claims as possible, and the sheer volume of PUA claims that, as well as regular unemployment insurance claims, to get all of that processed and to try to get benefits to people, to get them into the proper programs, and to get benefits out where necessary. I know I've been at work trying to provide queries, and Mr. Bracken alluded to this, but trying to pull data on the number of claims that had been paid and then were unpaid, which I've also heard here called a start-stop. I tend to say been paid, unpaid, but I was looking back through my files and I had one from July 28th trying to say, where are we right now? Who are all of the claims that are left that are in this group? So that I could get over to the Employment Security Division so they could work on it. And whether it's running queries, trying to find groups of claimants, overall aggregate totals, that's the side of it that I've been on since coming back to this position full time on June 4th, trying to help support with the data as much as possible their efforts to get benefits to everyone who deserves them and keep benefits from going to people who don't. But that's my perspective on their efforts.
Thank you, Mr. Schmidt. I believe those are all the questions I have, Your Honor.
Thank you, Ms. Jones.
Thank you, Mr. Schmidt. Do you have any knowledge as to whether the current Detr administration ratified Ms. Gau's positions about payment?
I do not. I have not been involved in those conversations since that time.
The judge does a very good job of breaking down the numbers. I was wondering if you could provide a number of people in that 33,777 who have an in-progress claim and are unable to appeal.
That I don't know. The appeals data is one that I haven't dug into very much yet. As far as in progress or active issues, that would probably align to at least some degree with the page 2 and 3 of the exhibit, those who are unpaid at least 1 week due to an unresolved issue. However, what may or may not be causing issues with filing an appeal, I can't talk about that.
And since that exhibit went away, can you tell me what, so you had page, could you tell me about how many people they were?
The total people who were stopped due to an unresolved issue was 11,741 claims.
Okay, thank you. No further questions.
All right, thank you very much. Mr. Schmidt, thank you for your time. The court excuses you from the remainder of this hearing. Of course, you're free to watch the rest of it. And to you and your family, a happy, healthy holiday season. Mr. Whitney, please call the state's next witness.
Thank you, Your Honor. We would call Mr. Shane Ricketts.
Okay. We are going to break in about 10 or 15 minutes, regardless of where we are with Mr. Ricketts. All right, Mr. Ricketts, when you can hear the court, if you would please turn on your camera and your microphone. Good afternoon, sir. Can you hear the court?
I can. Can you guys hear me?
I can. Do me a favor. Once you get a good area where we have a strong signal, do what you just did and put your smartphone down. All right. Thank you. Mr. Ricketts, I'm going to ask you to please raise your right hand, address my court clerk, and take the oath of witness.
Please raise your right hand. Do you solemnly swear or affirm the testimony you're about to give in this case shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you, Mr. Ricketts. Please proceed, Mr. Whitney.
Thank you, Your Honor. Mr. Ricketts, can you please state and then spell your last name for the record?
Yeah, my name is Shane, last name Ricketts, Ricketts.
And Mr. Ricketts, where are you employed?
State of Nevada Employment Security Division, Detr.
How long have you been employed there?
Currently 9 months.
What is your current position with the Employment Security Division?
I'm the manager of the Benefit Payment Control Unit, or the Integrity Unit.
Now, prior to your current 9 months with Detr, did you work with Detr before then, or?
Yeah, so I was previously employed for 7.5 years, up until March 2017.
What capacity was that employment in? I'm sorry, what was your job then?
Yeah, so during that time, I worked at Detr, and I worked for 2 years as an adjudicator, 2 years as a fraud investigator. 1 year I was a program specialist, and for the last 2 years, I was a business process analyst for the Benefit Payment Control Unit.
Now, in your current position, what are your main job duties and responsibilities?
I manage the unit that ensures the proper payment of the UI and PUA benefits, and also to detect and stop fraudulent claims and to create and collect overpayments according to the laws set forth by the U.S. Department of Labor.
Are you aware of the Miss Amethyst Payne's court case with Detr in Washoe County?
I am.
Mr. Ricketts, are you back?
Yes, I'm here.
We lost you for a minute. Go ahead, Mr.
Oh, okay.
Oh, sorry. And now, are you also somewhat familiar with the order of mandate in that case?
Yes, I am.
Now, have you seen Exhibit 17 before, State's Exhibit 17 that was created by Mr. Schmidt?
Yes, sir.
Mr. Ricketts, we're getting an error message that the network bandwidth that you're connecting in from is low. Is there a place where you are now that you think you might get better reception?
Is that any better?
It is right now, although it still says it's a little low. Why don't we do a sound test? Would you mind counting to 10, Mr. Ricketts?
1, 2, 3,
okay,
4.
we're good. We're good. Thank you.
Okay,
right,
no problem.
Counsel, do you think I made the matters worse, or did I help?
Your Honor, thank you. It's kind of staticky. I don't think it helped any.
Yeah, actually, Mr. Ricketts, I think I did more harm than good. Maybe you should go back to the place you were before. Okay, let's press forward until we can't communicate. Can you hear the court, Mr. Ricketts? Actually, no.
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 Yeah.
Is there a desktop or laptop that
Yes, sir.
you could log on to that has Zoom capabilities?
No, this is the only device I have.
Can you get closer to the router? Or possibly log off and log back on?
Okay, I can try that.
Okay, we can see you. All right. Thank you very much. Mr. Whitney, please proceed.
Thank you, Your Honor. Now, are you able to tell us what IP Investigation Case Special Project BPC means?
Yeah, sure. Those are stops put on claims due to displaying known fraudulent hallmarks.
And can you tell us Was Detr pursuant to USDL guidance, were they supposed to pay on those claims?
Well, you're asking him for a legal conclusion, and he's not a lawyer, nor has he been designated an expert. I can tell you, you can ask him what his understanding is. You can ask him how he's been instructed, but that's not something that he has the ability to answer the court. That's really a legal conclusion.
Thank you, Your Honor.
Also, Ms. Clerk, I see that somebody named James G. has their hand raised. Do you see that?
I do, Your Honor.
All right. Well, right now, James G., if you're called to testify as a witness in this matter, or the court needs to hear from you, we will bring you on board. But right now, let me just hear from Mr. Ricketts. Mr. Ricketts. All right. Go ahead, Mr. Whitney, if you could please ask a different question.
Thank you, Your Honor. So why did Detr not, if you're looking at the first page of Exhibit 17, can you tell us why Detr did not begin to pay on these claims again, the Detr's for investigation case special project?
Yeah, because those fell within the allowable reasons to stop pay on claims from the court order mandate by displaying characteristics of clear and convincing fraud.
And so, just so we're clear, Mr. Ricketts, from Exhibit 17, it looks to the court like that's the second bucket. What you're testifying to are the investigation case special project bucket. The one above, though, that I thought the question referred to was other program eligibility. But, I'm going to state what I think is the obvious. The way you've been instructed to proceed is that if the individual is eligible for other UI or from Nevada or other states or similar programs, they're ineligible at this time for PUA benefits. Am I understanding correctly the way you've been instructed?
Yes, that's correct.
All right. So I guess one question I have is, and I asked this earlier to Mr. Schmidt, like who actually told you that? Who directed you to do that, other than an attorney that's representing the state of Nevada? Was it a senior administrator? If so, who and when, please?
Yeah, I don't know a specific person. I know it was a collective decision made by administration that was passed down to my unit.
How was it passed down to your unit?
It really wasn't, I don't know. I mean, I don't have a specific email or didn't get a phone call or anything like that, but it was just known that was the process.
Okay, thank you. Mr. Whitney, please proceed.
Thank you, Your Honor. How about SAR BPC? What does that mean?
So those are stops put on claims from June 15 forward due to an influx of fraudulent activity, and which we required claimants to upload identity documentation to establish their identity.
And were those, why did, for those specific claims, why did Detr begin to pay those and then stop paying? For the claims that Detr did start to pay that fell into that category, why did Detr start paying them and then stop paying them?
Because the claimants didn't upload the required documentation as instructed, and at the time with the high influx of fraudulent claims, it indicated that it was a fraudulent filing.
Did Detr consider the fraudulent filing to the extent, going to the extent of clear and convincing evidence with the SAR BPC?
Yes, on the ones that received a disqualification.
Can you tell us what two-factor authentication bad phone means?
Sure. This is an anti-fraud stop built into the PUA system, and it requires additional authentication upon login to the claim. The user logs in and then they're prompted and sent a code to the cellular phone number that they have provided. And if the code is sent and then rejected, the system puts this issue on a claim due to the phone number provided not being valid.
So did Detr also, so then what specifically were these claims stopped for, the two-factor authentication, because the person didn't respond with the correct code, or?
No, they did not provide a valid phone number. So whenever the system sent out the authentication message, the phone number was no good.
So then was the phone number being no good, did Detr consider that evidence of fraud?
Yes, and also coupled with the other hallmarks on the claims, as well as the claimants were also provided another opportunity to unlock their claim if they did get caught up in this two-factor authentication bad phone. So there are multiple ways the claimants could have cleared this up and resolved the issue themselves.
Now, was it your understanding with respect to the investigation case special project, SAR-BPC, the two-factor authentication, is it your understanding that Detr was not supposed to pay on those claims?
Yeah, because there are signs of clear-cut fraud.
There's another category for staff review. Are you able to tell us what that means?
Yeah, give me 1 second.
Well, the way it's identified in the exhibit, Mr. Ricketts, is staff review code 749, issue generated when system detects potential UI eligibility at quarter change. So is it what it suggests, that payments were stopped because somebody now might be eligible for UI?
Yeah, correct. It means that the claimant was eligible for PUA, but subsequently earned sufficient wages at quarter change to qualify for the traditional UI program.
Okay, you are breaking up just a little bit, but I got most of that. Okay, Mr. Whitney, I think I've got most of what you wanted me to hear from Mr. Ricketts. Again, keeping in mind at 4:30, I'm going to hear argument. We are taking a 15-minute break shortly. That leaves us about another hour to finish Mr. Ricketts and to hear from any other witness the state wants the court to hear from.
Thank you, Your Honor. I'll probably be wrapping up fairly soon with Mr. Ricketts, I think.
Okay, go right ahead.
Oh, thank you. Are you aware of, Mr. Ricketts, are you aware of UPL 1620?
Yes, sir.
And does that UPL require the state to take reasonable precautions to detect and deter fraud?
Yes, sir. It specifically says the states are required to take reasonable customary precautions to deter and detect fraud.
What does
IP identity theft mean?
So this means that somebody's personal identifying information used to file a claim was done by someone other than the true owner of the personal identifying information.
Would Detr consider any claimants that fell into that category as having hallmarks of fraud? I'm sorry, any claims within that category of having hallmarks of fraud?
Yes, definitely. And NRS 612.445 says specifically that as well, that filing a claim for benefits using social security number, name, or the personal identifying information of another is fraud.
Yeah, I mean, it's not just civilly wrong, it's a crime, as
Exactly.
the court understands it, so. But that's, Mr. Whitney, as you saw, that's only one person, so that's not where, the decision of the court here is not gonna fall on either side of that one. The two biggest issues of the 33,000 people, give or take, the two biggest reasons are that there is hallmarks of fraud, and I know the plaintiffs believe that that is not enough, a hallmark versus clear and convincing, or they're concerned that the state hasn't given the person an opportunity to respond to the state's concerns based on the hallmark. So that's 10,000 people right there of the 33. And then the other 10,000, the other big group, are those that the state is not paying because they believe the person is now or has recently become eligible for other benefits. That's where the rubber hits the road, primarily for purposes of the hearing today. Those are the two largest buckets, unless I'm misunderstanding the evidence, but I don't think the court is. So. So, Mr. Whitney, please, let's wrap up Mr. Ricketts so we can move on.
Your Honor, I think I've asked all the questions I would like to ask of Mr. Ricketts.
You followed the court's cue very well. Ms. Jones, examination of Mr. Ricketts.
I'll be quick, Your Honor. Mr. Ricketts, you said that you were a fraud investigator for 2 years. What years were you? Like 2002 to 2004?
No, I would say it was, well, I guess 5 years. So yeah, roughly around 2010, 11.
So that was pre-CARES Act, pre-COVID. What was the percentage of fraud that you saw in the UI system pre-COVID?
It was, prior to me coming back in the years that I wasn't with the state, it was very low. Prior to that, during the, I guess, the economic crash, it bumped up pretty high to around 50% at one point, I would say was the high.
50% of the people that applied were fraudulent?
Correct. At one point, not throughout the whole.
So, and is that they were determined fraudulent after a hearing, or just they had indices of fraud?
It was clear and convincing.
That wasn't my question. Were they given an opportunity to be heard, and 50% of the people that were given an opportunity to be heard were 50% fraudulent? Is that what you're saying?
I would say not over the entire time frame. I was an investigator, but that was the high. And those people were basically claims that were filed and victims of identity theft. And so they're, if somebody stole an identity and you try to reach out to hear them, they're not going to respond.
Okay. What percentage of IP investigations result in the fraud determination?
There is no fraud determination.
So you don't actually make a determination. You just say, oh, there's these indices, and then it goes on to a different department?
No, we detect suspicious activities that gives us the clear and concise evidence that we need to determine that it's a fraudulent claim. And then a lot of the times those are denied with the 746 determination because right now our rules say that in order to classify a determination as fraud, you have to speak with the claimant.
So the numbers that are provided in Exhibit 17, none of these people have actually been spoken to. Is that correct?
It just depends. I wouldn't know without looking on a case-by-case basis. There are different types of fraud.
Okay. Why doesn't Detr issue checks? In your experience as an adjudicator and a fraud investigator, why don't you just issue a check and then if a person goes and cashes it, it's on the bank?
I believe due to cost reasons.
Due to cost reasons. Is that what
Correct.
you said?
Yeah.
Doesn't it seem to you, as in your personal opinion as an adjudicator and fraud investigator, that that'd be a pretty fine way to keep people from getting fraudulent UI benefits?
Well, that's argumentative because let's talk about what's really happening here.
Okay.
Here's what I'm understanding. Of the roughly 8,200 people whose payments began but have stopped because of concerns that there are hallmarks of fraud, approaching or at the level of clear and convincing evidence. Not just some, not just many, not just most, but virtually all have not had essentially a personal interview or direct personal interaction with somebody at the Employment Security Division. It's just not how it's working right now. It's not feasible. There might be a couple or a handful or some outliers, but what I'm getting, Mr. Ricketts, both from your testimony and from others, that's just not what's happening right now because there's no formal determination which would otherwise require that type of in-person interaction or direct person interaction. So, but if I'm wrong, please straighten the court out. But if I'm right, so you can confirm the court's understanding.
You're correct, Your Honor.
All right. So, Ms. Jones, when you summarize here in an hour, you can argue to the court what that means for purposes of this motion, but let's not argue with Mr. Ricketts whether it's a good or a bad idea, how things are going. So, or whether checks are preferable to direct deposit or, prepaid cards or anything like that.
Thank you, Your Honor.
Welcome.
I have no further questions.
All right. Mr. Ricketts, with the court's thanks, you can exit this hearing. Thank you for your testimony. Thank you for your work you're doing. On behalf of the state, to you and your family, a safe and healthy holiday. Counsel will be in recess until 3:30. Please have Mr. Whitney, the state's next witness, lined up, and the next one after him or her. How many more witnesses do you have, Mr. Whitney?
Your Honor, Mr. Ricketts was our last witness.
Mr. Whitney was your last witness?
Mr. Ricketts was, yes.
Excuse me, Mr. Ricketts was the last witness. All right. You don't want the court to hear from the director?
Your Honor, she was not listed as a witness on our witness list.
All right. Well, I mean, if you don't want me to, or she's not ready to go,
she's actually listed as witness number 5.
Oh. Well, here's the thing, Mr. Whitney. You don't have to tell the court right now. I was just thought the court might hear from her, but if not. You can finalize that decision over the break in collaboration with her and Mr. Ott. We'll be in recess until 3:30. Thank you, everyone.
Thank you.
Okay, let's go back on the record, everyone. Okay, just give me a moment. All right, Mr. Whitney, have you decided to rest the evidence portion, and shall we proceed to argument at this time?
Your Honor, actually, we've decided we won't call Director Cafferata. We were wondering though, if the court says it's too late, then I understand. But actually, there were about 3 more questions I would like to ask Mr. Ricketts. I wonder if it's too late to do that, or.
Okay, because it's a little hard for the court to hear you sometimes. Could you do me a favor, ask me that question one more time?
Yes, Your Honor, I'm sorry. We won't be calling Director Cafferata, but I don't know if it's too late for this. There were about 3 more questions I realized I would have liked to ask Mr. Shane Ricketts. I don't know if it's too late or not.
It's not too late. I did sort of try to move things along. I want to give everyone a full opportunity to ask questions of witnesses that you believe are relevant to the court's determination. So if he's available, let's bring him back.
Thank you, Your Honor.
You're welcome,
Your Honor,
Mr. Gain. Yes.
Plaintiffs would also like to call Director Cafferata for a few questions.
Well, is she on your witness list?
She's on, we'd like to call her as an adverse witness.
Well, is she on the state's witness
Yes,
list?
she is.
All right, well then I will let you call her after Mr. Ricketts is brought back. Ms. DeGaynor, please bring Mr. Ricketts back in.
Your Honor, Mr. Ricketts is now a panelist. Looks like he's
all
ready
right.
to
Thank
go.
you. All right, Mr. Ricketts, you're back. Please don't accuse me of cruel and unusual punishment.
Not at all.
Mr. Ricketts, do you understand you're still under oath?
Yes, sir, I do.
All right, Mr. Whitney, please proceed.
Thank you, Your Honor. Mr. Ricketts, counsel in substance had questioned you about with respect to some of the people that the Detr had thought there was indicia of clear and concise indicia to determine there was a fraudulent claim, that virtually none of those people had been interviewed. Were there attempts, and I hope I'm characterizing that right, did Detr attempt to contact these people to speak with them personally?
Yes, and you know, as mentioned earlier in previous testimony, we did send them a message to their message box in the PUA platform, as well as we sent out the blast. Also, we would have, if we saw that they did not get that message, then we would have called and left them a 48-hour message.
There was also a question about checks. And I know the issuing of checks by Detr. And I believe you'd answered, you thought that one of the reasons was cost. Do you know of any other reasons that checks may not be issued by Detr?
It would be, it would be a lot of work, and another thing, it would delay payments even further. And so I believe that the direct deposit and the debit cards are the most efficient way to issue payments.
Thank you, Mr. Ricketts.
Sure.
I'm sorry, those are all the questions I have. Thank you.
Thank you very much. Ms. Jones.
None, Your Honor.
All right, thank you. All right, Mr. Ricketts, you can drop off. We will not recall you again. Thank you very much, sir. All right.
Great, thank you.
You're welcome. All right, so Mr. Whitney, no further witnesses at this time. Is that accurate?
Your Honor, that is accurate. The Detr will not be calling any more further witnesses this time. We would also just briefly object to having Director Cafferata called as a witness. She was not listed on plaintiff's witness list. She was listed.
She doesn't have to be. If you list her, the court understands she can be called by the plaintiffs in rebuttal to evidence that the state has presented here. So I'm going to allow it. Now, she's not under subpoena. She's here as the client representative. I can't compel her to testify if she refuses to. but this matter would be continued, and I would allow the plaintiffs to effectuate a subpoena on her, and then have her testify anyway. So that's the way I'm going to approach it. They have a right. You listed her on their witness list, so they have a right to expect that you might be called as a witness.
Potential witness list, Your Honor, actually. I don't know if we ever, I don't think we actually called it an actual. I think we've always titled it potential witness.
Well, I mean, each side filed, let's not split hairs here. Each side filed their list of witnesses, list of potential witnesses, list of expected witnesses to give the other side a heads up of who would be called to testify in this matter. And she was on yours. So, you know, I exercising the court's discretion to have a full and fair hearing to allow limited examination and rebuttal from Ms. Caffaretta. Now, if you say, Your Honor, that would be abject unfairness. We need time to prepare. But you know, I would generally not agree with that. I would frown on that. I would like to hear from her and get this hearing over, have the court make a decision. But I'll give you a moment off the record, Mr. Whitney, Mr. Ott, and Ms. Caffaretta to discuss this outside the presence of this hearing. Come back on in about 10 minutes and tell me your position, if you'd like that, Mr. Whitney.
Please, that'd be great. Thank you.
All right, we will be in recess until 3:50. And then again, Ms. Jones, you can identify on the record why you believe you have a right to call her at a hearing like this. So we'll be on back at approximately 3:50. We'll be in recess until that time.
Thank you.
Thank you.
Okay, I'm about to get started. Counsel, please start your video.
All right, welcome back, everyone. We're on the record. We took a short recess. Went back just to review NRS 50 on witnesses. As we all know, generally, NRS 50.165 sub 1 requires witnesses validly subpoenaed to appear for court. But sub 2, of course, says a person present in court or before a judicial officer may be required to testify in the same manner as if the person were in attendance upon a subpoena issued by such court or officer. So, you know, the court has authority to order Ms. Cafretta to respond to questions. Of course, it wasn't, she would not be called by the plaintiff in their case in chief. It would be limited to rebuttal. But of course, the court has discretion if it finds there's fundamental unfairness under the circumstances to either decline to allow examination or to continue this to a later time, likely next week or tomorrow morning to finish this hearing. Anyway, that's the court's thought process. Mr. Whitney or Mr. Ott, what would be your position on behalf of the state?
Your Honor, we are prepared to have Director Cafferata called as a rebuttal witness by plaintiffs.
You're going to have to talk up just a little bit. My ears don't work that well.
Sorry, Your Honor.
That's all right.
We are, Judge Cafferata is available to proceed right now as a witness.
Very good. Thank you very much. All right. So before I have her sworn in, Ms. Jones, anything else you'd like to put on the record?
No, thank you, Your Honor.
All right. And again, the testimony will be limited to rebuttal, which is areas that were brought up by the state in its case in chief. And without further ado, Ms. Cafretta, if you would please unmute yourself and address my court clerk, raise your right hand and be sworn.
Do you solemnly swear or affirm the testimony you're about to give in this case shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Good afternoon, Ms. Cafretta. Can you hear the court all right?
I can.
All right, thank you very much. Ms. Jones, you may proceed.
Thank you. I appreciate you being willing to testify. I only have a few questions. We've heard today throughout testimony from various Detr employees that the directives regarding the start-stop payment people came from the administration. Do you know who they mean when they say from the administration?
I'm so used to testifying in front of legislative committees. I want to identify myself. Sorry about that. As you know, I started with Detr on August 6th. So I do not have firsthand knowledge of who made those decisions or what they mean by that.
Were you aware of former Director Gah's decision not to pay the start-stop people?
Again, the Administrator Gah was the ESD administrator at the time of the court order. And the decisions that were made, I think, have been accurately characterized, at least what the staff have testified to is my understanding of the decision that was made. And the administrator has the legal decision-making authority in this particular case. So that was how it was characterized to me, is what they have said.
So are you ratifying Administrator Gah's decision?
Yeah, I'm going to object at this point. This is kind of moving beyond rebuttal, it seems like.
Well, I don't think it's goes beyond, because the court asked and each of the witnesses responded with respect to, who decided to withhold payments in light of their view of what the court's order required. And so questions along this line are permissible and don't go beyond the scope of permissible rebuttal. You know, ratify, though, is a little bit of a legal term. I guess, Ms. Cafferata, what I want to know is, when you took over as administrator, did you have the opportunity to look at decisions that were made before you by Administrator Gah and the right to correct, challenge, revise, edit, or modify?
Your Honor, so I guess I would describe it this way. In the state law, the ESD administrator has certain legal authority over the employment security program. The director of Detr, or at the time I was the acting director, does not have that legal authority. The legal authority rests with the administrator. So it is not in my job description to revise or review or revisit decisions of the administrator, because she has the legal authority. She has the legal, the ramifications of the legal decisions that she makes.
Fair enough. Who's the administrator now?
We have a brand new administrator. We've been in a little bit of an interesting situation because Kimberly Gah is no longer the administrator. Her last day was actually October 9th, I believe. We had a contract acting ESD administrator who couldn't have the legal authority because he was acting in a contract position, and under state law, contractors can't have certain statutory authority. Linda Parvin is the new ESD administrator. I believe she's been the ESD administrator for 3 weeks. So what I would, Your Honor, what I would add that I don't think we have had the chance to sort of really explain is that I was involved in many, many conversations about how can Detr comply with your order. And staff would come to me with recommendations and programs and ideas for ways we could go through the PUA claimants, given the limitations of what the program did with our vendor, which, as you know, we built in modules. And we always pursued every program, every search. We assigned groups of claimants to specific teams, the welfare workers, our best adjudicators, and went through the list in every way we possibly could to find the folks who might have had a payment start and then stop and get their cases resolved or get them into payment status. And I was involved in all of those decisions, and always was directing the staff to do everything we could to comply with your order.
Thank you. I may have some more questions. Ms. Jones, you may proceed.
Your Honor, that's really all I had for her. Trying to find out where the buck stops.
Thank you, Ms. Cafferata. Did you have any discussions directly with Ms. Gah when she was administrator, or in any group session in which Ms. Gah was acting administrator, other than in the presence of counsel, where she relayed to you her view of how to interpret the court's order on to reinitiate payments to those 4 categories of people that are identified in the order of mandate?
We had several discussions about complying with the court order.
All right. Did any of those discussions center on you've heard me use the word today, the tension between the court's order on the one hand and the guidance from the Department of Labor and the way the state appears to be construing that, to the effect that if somebody has eligible benefits under state of Nevada or other states' programs for unemployment or similar, then they're not eligible at that time for PUA. Were you involved in any discussions with Ms. Ga about that, or in group discussions in which she was a participant?
Yes, I believe we discussed the challenges of complying with the order and following DOL guidance many times. And as I indicated, tried to come up with every possible approach we could to meeting both tests.
Okay, but why was it so hard? In other words, why not just follow the court's order and pay those people that had, again, the court order did not direct the state to begin to pay somebody who the state believed was otherwise ineligible. It didn't direct the state to pay people who had available UI, an UI account that might apply, or could receive benefits out of state for UI benefits. These are people for whom payments began, and that's a narrow subset. And the court already reviewed in advance of its order in July, it already reviewed the governing law thoroughly, which admittedly is nuanced, is evolving, is complex, particularly to translate that into pandemic unemployment assistance program and payments, which heretofore didn't exist, in light of some of the structural limitations that the Employment Security Division was facing, and the well-known fact that Nevada, in particular Southern Nevada, is essentially ground zero for the economic effect of the pandemic in the United States. But the court considered all that. And at the end of the day, the court's order was pretty clear. In fact, the court's order was more than pretty clear. The court's order, as I intended it, was completely clear. It didn't say to not pay if the guidance from the Department of Labor was viewed contradictory. It didn't say to not pay if there were efforts used to trying to find a way, an algorithm, an approach that would allow both goals to be served. It didn't have those type of limitations. In the court's mind was clear, unambiguous, and meant to be followed. And one of the reasons that this hearing did not occur earlier since the deadline expired, I believe, was the sense by the plaintiffs that good faith efforts to comply were ongoing. In fact, it's not lost on the court that even the special master, Mr. Guanasso, in the second of his major pieces of work, opined at the end that the state was substantially complying at that time with the court's order, although he noted several ways that it could improve the approach. But at the end of the day, his conclusion, of course not binding yet informative to the court, was that Detr was in substantial compliance. And that likely bought some time for the state to avoid this type of a hearing. Yet here we are. And so it's a bit distressing to the court to see that on Exhibit 17 in particular, there are 9,841 people that had their payments begin and then stop with the state's rationale that those individuals may be eligible for regular UI, PEUC, or SEB in any state. In fact, we heard from Ms. Boyd, Mr. Kolznick, and Mr. Daugherty, excuse me, and that doesn't apply to Ms. Boyd, but as to the other two gentlemen, it seems to the court that at best, there might be concerns by the state that they would slot into that group. Anyway, with all that as background, Ms. Caffaretta, in any of the meetings you had with the administrator or any discussions with her or in her presence, why at the end of the day did that view trump the court order to the best of your understanding? Unless you think it didn't trump it, unless you think it's still fluid.
Your Honor, I would answer with two things. One is the maybe three things. The cases that we have heard today, I believe, reasonable people might disagree, but we have fairly clear guidance that if you, within one application, have contradictory statements or misrepresentations, or in the case of PUA, you must have a COVID reason for your unemployment, and you have to certify that every week. If you don't do that, but you try and apply, that's clear and convincing evidence of fraud. Fraud determinations are a whole separate process. I think we've sort of made that clear. So I would argue that, first of all, we felt that the people who got a payment and then stopped getting payments fell into one of the buckets. I would also say that the other thing that we haven't talked about is several of the UPLs, as we call them, UIPLs, that have came out subsequent to your order. We have had more UIPLs this year than probably in the 20 years prior to this year. And that is because
let's make sure for people watching at home, let's sorry to interrupt. Let's make sure for everyone watching this hearing, we know what your definition of UPL is. What is that definition? Or
unemployment insurance policy
letter.
Okay, thank you.
What's the last word, Ms. Jones?
Letter.
And I'm gonna turn off my fan really fast.
Actually, Your Honor, I think it's the P stands for, and Attorney Jones, I think the P stands for program.
This is
okay, but in any event, there's been more guidance that's been received, is what you're suggesting, right?
There's been more guidance from the Department of Labor on a very regular basis, and in several circumstances, and I would have to ask my attorneys to give you the citations. However, in several cases, the Department of Labor has very clearly said that if someone is in the PUA program and they have other program eligibility, most of the time regular unemployment benefits, either in Nevada or another state, we are to stop their payment and move them to regular unemployment. Specifically, the case that certainly when the order was issued, I know we were all hoping would be able to resolve all of these cases long before the next quarter change. But the guidance from the Department of Labor is exceedingly clear that we have to reevaluate all these claims at a quarter change to see if they have eligibility in another program. And so I think your order is quite clear. And we continued to get guidance from the Department of Labor that was also quite clear. And so my sort of decision-making compass was, how do we best work through these programs, do our work in a way that meets the spirit of what you were trying to accomplish, which is get people the payments that they are eligible for. And if you look at Mr. Daugherty's case, if we had paid him in PUA in Nevada, he would have ended up with a $17,000 overpayment because he had clear eligibility in another state. And at this point, without Congress acting to extend the benefits in regular UI actually last longer than the benefits in PUA, which will end the week of December 26th. And so that has always been sort of my guiding principle, is to balance these two and the best we can get these people the payments that they deserve in a way that will not also harm them.
Okay, just to make sure that anyone listening to this didn't just fall out of their chair when you indicated the payments would end, the last week of December. The claims will continue to be processed well into 2021, and people that otherwise were eligible for benefits they'll be paid in arrears, paid what they're owed up to that point in time. That doesn't mean that they won't hear anything from the from the Employment Security Division after that. That just means the money allocated by Congress runs out, but it still will be available to them next year if benefits were owed for this year. Is that fair?
Yes, that's correct.
All right, good.
I don't know where you get that from, Your Honor. Who knows what they're going to do up there? Mr.
Well, hasn't the, well, let's, I mean, I don't want to.
He's doing a clawback right now. The Secretary of the Treasury is doing a clawback. He wants that money back in the Treasury. He
Okay,
doesn't
well,
want to go out.
I don't want to get the train too far afield, and that was the court's fault for bringing that issue up. But the way the court understands it is the money doesn't all have to be paid for PUA. The claims have to be in process. All right, but we're not here to decide that. We're here to decide whether the state has complied with the court's order, and if not, what the corrective action is. Hold on. This is not, it's not open mic just yet. Ms. Cafretta, I appreciate the response to the court's questions and concerns. I don't have any additional questions at this time, but before I thank and excuse you from the testifying, let me ask Mr. Whitney, do you have any questions of Ms. Cafretta?
Thank you, Your Honor. I do not.
Thank you. Ms. Jones, any questions in light of the court's questions and Ms. Cafretta's responses?
I don't have any questions, but I will defer to Mr. Thurman.
No questions.
All right, thank you very much, Ms. Cafretta. Thank you. And I hope you stay on the call and the hearing and observe the remainder of the hearing. All right, that will conclude the evidence at this point. At this time, I ask each side to summarize where they are, what they're asking the court to do, what you believe the evidence showed, and why the court should proceed in the manner you're suggesting. Let's start with the party that has the burden of convincing the court that the state has violated the court's order, that being plaintiff, either Mr. Thurman or Ms. Jones. You may proceed.
What? All right, let me take a stab at it. You've identified it pretty much in your questioning. There are 22,000 people approximately who were in that group, that protected group, covered by your order. And despite what Ms. Cafretta says, there is no clear statement that you're supposed to stop. Every single UIPL says we defer to Java, don't forget Java, don't forget Java, but then it goes on. And it doesn't say stop, it says they're not entitled to benefits. And that's different than stopping. Second of all, because that's initial claims. Second of all, as Your Honor heard, they're supposedly processing 700 claims a day. Well, there are only 22,000 people here. At 700 claims a day, that's 50 days, 40 days. We're 9 months later, or 6 months later from when your order was, 5 months later from when your order was. They aren't processing anything. They're not sending out any notices. They're pinging phones, and I don't know how many people there didn't respond. But you know, they're not processing it with the idea of paying people. They're processing it with the idea of, we're going to cull through this bunch of thieves, 50% or more, and we're going to take a few good ones out and pay them randomly. That's not what the process is about. That's not what your order said. This is a question not only of PUA versus UI. This is a question of separation of powers. This court issued an order. This court issued a directive. And if nothing else, they should have come in and said, you know, Your Honor, we're going to take an immediate appeal. We want a temporary stay. You're so far off that we're going to lose our benefits, or we're going to lose this stuff. Unlike Oregon, who, by the way, pays in the middle, and they didn't lose anything. Unlike the Department of Labor just came out with a report saying that most states underpay the minimum just to get it off their books first, and then they go back and adjudicate the difference. But instead, they just decide, we're not going to pay your order. We're going to try to blend your order into the bunch of other stuff that's all over the place, from pre-COVID to post-COVID. They didn't follow your order. And that's separation of powers. It goes back to Mulray versus Madison, frankly. This court issues an order. If they don't like it, they can either disobey it and take a contempt, or they can come in and ask for modification and take an appeal. And they didn't do that. And they didn't do that maybe because of the changeover, maybe because they keep looking at this thing the wrong way. We've been arguing that. We're going to argue it again in the Supreme Court as somehow not an entitlement, but some gift that they have to dole out instead of the other way around. But we know 22,000 people were given their benefits, so there's no question that at least somebody made an initial determination they were eligible. And that's what JABA was. That's the heartland of JABA. They were given benefits, and then they were taken away. You can't do that. That's Goldberg versus Kelly. That's all the administrative law cases from the 1970s on forward. It's administratively inconvenient, right? And there is a percentage of people who will never be able to pay it back. And if you look at the Jenkins case out of the Seventh Circuit, they said, well, people who are convicted or people who are being held in custody, arrested for crimes against their employer, which obviously is grounds for disqualification of unemployment benefits, can't be blanketed, not paid until the courts decide whether or not they're guilty. And same thing here. You cannot have these prophylactic, you're guilty till proven innocent, broad brush rules. They just ignored your order. It's that simple. And you know, the $1,000 is going to put a whole lot of bread on the table. I would like to see the $1,000 per person. And there's nothing in the statute that says you can't do it. And I couldn't find a case one way or the other. Ms. Jones is much more conservative than I am. But that's not even the point either. The point is, pay these people and pay as many of them as you can. And DOL is not going to come and yank your license away because you followed the district court order. And if DOL has a problem with it, let DOL take the appeal. It's not happening. It's just a bunch of fraud in the horizon. You know, I mean, some of their denial letters say you're being suspected of. What is this, McCarthyism? Being suspected of. Clear and convincing evidence is a lot more than indicia of fraud. Clear and convincing evidence is somebody either has, irrebuttable or almost a highly unlikely that it's not. And what do they have? Oh, someone's phone has a 415 area code. Oh, gee. Someone else has a VPN and he's pinging out of South Africa. We know scientifically that IP addresses are not an accurate indication of where people are located. And it doesn't matter where they're located when they apply. It only matters where they were located when they stopped working. So, I mean, all these excuses, all these reasons is that same old. They didn't take your order seriously. They didn't change their behavior. And what we got is Ms. Keffer saying, well, I didn't exactly ratify it, but yeah, I agreed with it. Well, that's ratification. And if they really want to change things, then blame it on you, blame it on the courts, but change them. And I think that's the point of this whole contempt. It's not about the $1,000. It's about getting through to DITA that you're serious. And the courts are serious. And this country works on a balance of powers, a separation of powers and a balance of powers. And you trump them all the time until you're appealed. And that's the closing. It's not about the $1,000. It's about the principle of the thing. And 22,000 people is a lot of principles.
All right, thank you. Let me, before I hear from the state, let me clarify two things. One is you have filed two separate motions for orders of contempt. Now, it seems to the court you're pursuing the second one. Am I wrong?
No,
Or am I right?
You're correct.
All right. Second, you've asked the court to take judicial notice of an amicus brief filed with the Nevada Supreme Court by Nevada Legal Services. Now, in what way would the court take judicial notice? I mean,
Right.
I can take notice of other court filings or other public records, but it's not a factual assertion, and it's not a legal point of law. It's argument. So how do I take judicial notice of that?
Except for the incidence of fraud that they report as 6.5% at the maximum, which is less than 10% when the Secretary of Labor testified that he expected at the time this program was passed.
But they rely on information unique to them. The court has no barometer as to the accuracy. It's not subject to challenge or cross-examination.
Okay, so how many instances of conviction or fraud have they come in here with? How many of the 22,000 people got a determination, much less a conviction? How many people even had a hearing? None. Okay. You can't have fraud without at least, it's been 5 months or 4 months since you issued the order. At least you should have a hearing. There's no written letter saying, oh, by the way, we think you have fraud here, clear and convincing. There's nothing. It's just like, oh, okay, I think there's an indication of fraud. We'll put that aside. You're not going to get paid for a year. These people are starving. I can't do that to them. This is in the Cuomo case in New York. This is subsistence. This is per se irreparable harm.
All right. Before the court would take judicial notice, the state would have an opportunity to be heard. However, the court declines to take judicial notice of the filing of the Nevada Legal Services, so I don't need to hear from the state. Now, did I skim it just to see what it was and how it might relate? I did, but because I will not consider it, it will not be used by the court for purposes of this hearing. I need not hear from the state at this time. All right. Who will argue for the state and against a order finding the state in contempt, Mr. Whitney or Mr. Ott?
Your Honor, I will be handling.
All right. Thank you. Please proceed.
Thank you, Your Honor. I'll try and be brief. I'm sure the court was aware of Special Master Guanasso, the independent party, back in August with his final special master report, did find that Detr was in substantial compliance, page 111 of his report. I'm sure the court remembers that. Your Honor, we submit that Detr is in substantial compliance with your court order. We've heard from Director Cafferata that there's and the court's picked up and noticed too and pointed out there is a tension between the court's order and what the U.S. Department of Labor requires. The court has said that you don't intend for the state not to violate any guidance of U.S. DOL. And but Your Honor, there UPL 1620, the way Detr reads it, and also it's backed up by the fact that when there's a quarter change, there's a check for eligibility for PUA applicants to see if they're become eligible for another program. The evidence is there that if someone become a PUA applicant that's being paid PUA, I'm sorry, PUA claimant being paid PUA, if they become eligible for another program, say for example at a quarter change, then the PUA benefits are stopped. That is guidance from the UPL. So there's that tension there between trying to comply with the guidance which the state, ESD as on behalf of the state said it would agree to follow back when the agreement for PUA funding was signed back in late March. There was a discussion about the second largest category behind people that were not paid. I'm sorry, the people that had eligibility in the three other programs. The discussion about those people, and we heard Mr. Ricketts testify about indicia of fraud there. And the notice that's actually sent out to people. One thing that I like to point out is he did point out that these people, at least Detr made an attempt to contact them. Now, maybe many of these people weren't spoken to, but it's really a two-way street. There's information that's sent out to these people for Detr to try and contact them to get more information. And if you are somebody committing fraud, then you're not going to respond to that. So that these denials seem to, if Detr attempts to contact them, then there's these indicias of fraud. Denying them seems to make sense rather than paying somebody that don't know perhaps their identity, if this is even a real person. We've heard testimony from Mr. Bracken discussing the shape Detr was in back in late July in that time period. And it seems clear that there just really wasn't any feasible way that Detr could, short of violating the U.S. Department of Labor clear regulations about just paying everybody. I believe that was my understanding of the blanket statement that Mr. Bracken had mentioned. It seems clear that there, with such a short staff, a small staff handling and processing these claims, this was not something that was going to happen within the 1 week that the court gave Detr to get into compliance. Mr. Bracken couldn't remember this total universe of claims at that time, but 16 people, and they were processing 500 to 700 claims per day. Just was not going to cut it. We heard from Mr. Schmidt about the fact that many of these people that were in charge of Detr, in the time, just before the time of the court's order of mandate, they've been gone for quite a while now. We've heard testimony from Director Cafferata that Administrator Gah apparently was the last person named in the complaint. She's been gone since almost 2 months now. Deputy Director Perea, Mr. Smith testified, I can't remember the date, sometime around the time of the court's order of mandate, maybe before, maybe a little bit after. And then Director Korbulik was gone before then. So it asked the court to consider, the fairness of imposing contempt, finding of contempt on people that, frankly, haven't been in charge of the Employment Security Division for some time now. And also from what Director Cafferata said, the amount of authority that the administrator does have versus the, at that time, Deputy Director Perea and Director Korbulik. We've seen the 3 witnesses that were brought forward by plaintiff, and it's clear that they felt like they should be paid, and it sounds like their testimony, there's some feelings there that that they weren't clear about why they weren't being paid. But we've also heard the explanation from Ms. Allender. We have somebody that is self-certifying on their claim that their employment has in substance been affected by the COVID-19 pandemic. Yet one of the people had certified that she hadn't worked since April 2019, well before the pandemic. The 2 other gentlemen, the 2 other claimants that testified Again, it appears that they initially had eligibility in PUA and then became eligible in UI. And that again is, Detr is asserting and submitting that pursuant to U.S. dual guidance, the PUA program, which is a new program, I'm sure the court recognizes. Guidance says that those payments are to stop if somebody becomes eligible for another benefits program, UI, state extended benefits. And just really briefly, Your Honor, again, this was something that wasn't brought up too much today, but it was in, we did put it in our response brief. I can't remember honestly what it's titled. I'm sorry, I'm a little bit tired right now, but again, that the writ needed to be personally served in this case, and it was not personally served. Notice, I'm sure the court recognizes it's not the same as personal service, and electronic service is not personal service. So based on all the circumstances, Your Honor, we'd ask that you deny plaintiff's motion for contempt. And thank you.
Thank you. All right, Mr. Thierman, a brief reply, and then the court will issue a decision. And if you'd like, address, among other things, the state's position that there were service issues here that the court ought to take into consideration. Mr. Thierman, go right ahead.
I said, I don't know if there was service issue. I don't know when this statute was passed, there wasn't electronic service. But they all had notice of it, and they all had an opportunity to correct it. And the fact is that I don't even know where you would find, am I going to go to Mrs. Caffaretto's house? I don't want to go to her house. I don't want to serve her in the middle of the night. That's not what we're here for. We're here for getting people paid. And, you know, if you don't have this tool, I don't know what tool you have to force them to do what they're supposed to do. Ms. Allender says that she thought they handled it poorly, that there was no true fraud, and they should tell people. I mean, you get a letter from Detr saying you're not eligible for PUA, contact Detr for UI. You got the letter from Detr. I mean, talk about confusing, but that's not even the issue. The issue is, did they follow the order? They didn't. Detr was served. Detr knows. It's their attorneys were served. They know. Detr is an organization. Detr needs to fix it. I'm not saying Ms. Caffaretto's cart isn't the right place, but someone's got to reorder Detr's priorities. They have to pay these people because you ordered it. And again, nobody sent anybody a letter. They said, oh, we tried to call them. I mean, I don't know how many times you hear that excuse, right? Oh, I tried to call them. Didn't even leave a message. Nobody followed up with a letter. No one said, hey, unless you get back to us in 48 hours, you know, the U.S. Postal Service still works. Unless you get back to us in 48 hours, we're going to have a hearing immediately without you. I mean, and they send them the wrong information on the hearing, by the way. Under PUA, it's 60 days to appeal, 30 days they have to issue a decision. And that's in 20 CFR 610A, first sentence. And so they're sending out misinformation, and then people who are lay people are supposed to guess. They're the ones who have the burden of showing that once benefits begin, that they have a reason to stop. And you can't put in the trigger mechanism, that is filing an appeal, if they don't give you a written notice or something to appeal from. And they don't give you a written notice. And the appeal button after July 28th worked half the time and not half, it doesn't work for some people because they're in process. I mean, you saw the screenshots. In process means you can't appeal. So they didn't say to them, oh, you're being denied because of fraud. You're in process. Well, they can't appeal it. You can't do anything about it. They just don't pay. That's not what this court's order said. And like I said, if they were doing 700 a day, in 10 days, it would have been 7,000. In 100 days, it would have been 70,000. There are only 22,000 people in this group. So they should have been done in about, 30 or 40 50 days, whatever the math turns out. Instead, it's 4 months later. Nobody's been adjudicated anything. No one's gotten any notice. No one's got anything. And now we're just backpedaling to try to justify it. And again, nothing, they haven't shown you a UILP or UIPL that says don't pay under these circumstances, even if you started paying. They all say if someone's in the other program, they're not eligible for this program. And I don't understand the quarterly reassessment if nothing's changed. What are you supposed to reassess? It's quarterly reassessment if they have earnings. They don't have any earnings, they're unemployed. So I think that's why you should issue your contempt. And you know, if you want to make a civil contempt, give them 2 weeks to purge it. I don't care. Again, it's not the $1,000. It's getting them to reorder the priorities so they pay people. Thank you.
Thank you. Court's going to take about a 10-minute recess, come back online about 4:50, make its ruling. We'll be in recess until that time.
Okay, counsel, we're ready to go. Please start your videos.
Okay, we're back in session. All right, let me start preliminarily by thanking everyone for the very spirited and professional manner in which this was presented to the court today. Indeed, as has been observed in prior hearings, this is the unique case where essentially both sides to the dispute have the same goal, which is to have people who are otherwise eligible for benefits to be promptly paid so that they can have a subsistence level of economic support during the unprecedented times of the pandemic. That being said, the court finds that the state of Nevada is in contempt of its prior order of mandate. That order was filed on July 22nd. The order was specific. In the court's estimation, it was clear. Let me repeat the operative term on page 8 going into page 9. It is hereby ordered, adjudged, and decreed that once payments have started, payments cannot be withheld and must be restarted unless one of four things was occurring. A, the applicant did not file a weekly claim, or B, the applicant has earnings in excess of that which would otherwise qualify the applicant for benefits, or C, there is clear and convincing evidence of fraud by the applicant, or D, until such time as the applicant is afforded an opportunity to be heard. Now, in hindsight, the court's directive of ordering the state to commence payments on or before July 28, 2020 was unrealistic. It was too soon. Obviously, with the benefit of hindsight, the court ought not to have put such a short time frame. And if the court had to do it all over again, it would have been a much longer period of time, in the neighborhood of 30 to 45 days. So for the angst or challenge that the state faced by virtue of the short time frame involved, the court apologizes. It understands now it's much more involved. Nevertheless, here we are in December, and we still have issues. Importantly, the state has not moved this court to stay enforcement of its writ of mandate. The state has not obtained an order staying enforcement from an appellate court with authority over this one. And notwithstanding that there are cross appeals, plaintiffs arguing the court's order of mandate did not go far enough, the state arguing that the court's order of mandate went too far, the fact is the court retains ancillary jurisdiction to enforce its orders. So what is the court faced with that justifies its conclusion here? Well, it's undeniable that we have incredibly worthy efforts by the state, its employees, its senior administrators, its management team, to work hard on behalf of the people who need their benefits. The court has repeatedly commented. In fact, one of its prior orders remarked that Administrator Gaw, I believe the court used the phrase or something similar, had exemplified extraordinary effort to comply and get people their benefits. It's not lost on the court that the Employment Security Division and Detr in particular have hired new people, are training new people as quickly as they can, are bringing back people who are retired, are hiring contract workers, are trying to get the benefit of prior work history, experience, and expertise, all with the singular goal of getting people paid as promptly and lawfully as they can. And the court takes that into consideration. It's also not lost on the court that there indeed appears to be, at least in the eyes of the state, a tension between this court's order of mandate and Department of Labor guidelines. And the state has important concerns that its actions need to be measured so as not to run afoul of the federal government restrictions and directives and guidelines with respect to how to administer this program. Because, as has been brought up several times, the risk is significant if they do. The state runs the risk of having funding cut off, runs the risk of having penalties imposed, runs the risk of having possibly, as the court understands, to disgorge and return some of the money. And those are serious concerns, and the court understands and appreciates that. But those were concerns made known to the court back in the summer. And the court took great pains to make sure that its order, to the best of its ability, both complied with the law, complied with Department of Labor guidelines, but again, was consistent with jurisprudence from the United States Supreme Court, at least as this court understands and has applied it to the unique circumstances here. And that's why the court fashioned its order in the measured and limited way that it did. The court has no desire to put the state of Nevada or those receiving benefits in harm's way. The court's goal is to get the state to comply with the law and provide additional payments to those whose payments have started and now stopped. So, the court heard from examples of three people that the plaintiff asked the court to take note of: Ms. Boyd, Mr. Kolznick, and Mr. Daugherty. The court has a certain level of experience in measuring people's credibility. And it seems to the court that the farthest thing from Ms. Boyd's mind would be in any way to intentionally mislead Detr or otherwise commit a fraudulent act, much less any evidence that would get close to clear and convincing evidence. As to Mr. Kolznick, with respect to his payments stopping, it's entirely clear to the court that he has done his level best to comply with everything asked of him in order to receive payments, but he is being caught up in that big bucket of people that have not been paid because the state believes the fact that they may have eligible benefits in UI or another employment assistance program he's caught in that big net. So payments are not going forward with respect to him. But in the court's estimation, he too was a very credible witness and made the case for people like him who have similarly been caught up in that unfortunate situation. And then finally, Mr. Daugherty, his was a little more difficult for the court to understand, but it seems to the court that he credibly made a case for being owed payments, the complete amount of payments until at least the time he began work again in August, if not more recently. The court, however, is not here to adjudicate the strength of their claim. I'm not acting as a hearing officer, an appeals officer. I'm just observing that if those three are representative of the types of issues and challenges that people are facing that are caught up in the 20 or 30,000 who have not yet been paid, then the court finds that those people likely would have been entitled to payment under the court's order. The court finds that the state's witnesses, Ms. Allender, first of all, the court found her very credible and a hard worker and knowledgeable and trying very, very hard every day to do the right thing. The only issue the court has with Ms. Allender's approach is she's marching to the wrong tempo in the court's estimation, because it appears to the court that she's under the impression that the court order did not require payments to be released to certain groups of people that the court finds it should have been. Mr. Marhevka as well, the court found credible and appreciates his hard work now on the administrative side, not on the processing side. Mr. Bracken obviously has a wealth of information and knowledge and experience. It's to his credit that he's come back to help out the state, not apparently once, but twice when he is otherwise to be retired. He helped stand up the PUA operations apparently in May, and he has now come back and is acting as an adjudicator under a contract under the UI system. Again, though, his worldview of what the state's role is and the level of effort and action to comply with the court's order is unfortunately inconsistent with this court's view of the law. But the court commends Mr. Bracken for his hard work. Mr. Schmidt, the court has heard from before and found him then and continues to find him extremely credible, extremely honest, a tremendous asset in the Research and Analysis Bureau, and is personally and judicially glad that he is on the team for the state of Nevada, because he brings a wealth of information, knowledge, and commitment. It's clear to the court. Mr. Ricketts, I'm going to not hold it against him that he was addressing the court in a hearing like this from his smartphone, and commend him for doing his best to find a place that he could connect without too much technology interference. Mr. Ricketts, though, also has quite a bit of his institutional background, information, and knowledge, and the court appreciates his efforts on behalf of the state, and his candor is undeniable. And then, of course, we have the director, Ms. Caffaretta, who has come in fairly recently, along with Ms. Buckley, and is attempting her level best to improve the situation. And as she educated the court, it's really not her call at this time with respect to some higher level policy decisions with respect to how to approach the court's order in light of Department of Labor guidance. But nevertheless, here's where we are. The court finds that notwithstanding the special master's prior conclusion, several months ago, that the state was in substantial compliance, the court is left with the inescapable conclusion under Nevada Revised Statute 34, that the state 34-290 subsection 2 that there has been a violation of the court's writ of mandate. Now, the question is how? Is it the 8,000 or 9,000 people whose benefits are being held up because of indicia, markers, or hallmarks of fraud? The court's order was clear that it needed to be more than just a sniff of fraud. It needed to be more than just a sense, an inkling, and some indicia. It needed to be more than that. And the court, through this course of the hearing today, was on the fence with respect to the state's view and approach. But the more I learned of what is happening and what has been going on, the court is convinced that the state has complied with that portion of the court's order. The court specifically finds at this time the state is not in contempt. The court, however, diverges from the state's approach is with respect to people whose claims have not been paid based on the state's belief that there are available UI benefits or other employment-related benefits from within or without of Nevada. Now, I want to make something clear. The court order did not then, nor is the court today, directing the state to pay people who have UI benefits available. Court's not doing that. Court did not do that this summer. What the court did in the summer was, if you started to pay them, you cannot stop without them getting a hearing, without them having an opportunity to protest, without them having an opportunity to be heard. The court did not then and is not now enforcing that order based on its view of how things should be. It did not then, nor is it now making this determination because it believes that's the correct, right approach on how benefits should be paid under the Pandemic Unassistance Program. It has to do with the court's review, analysis, consideration, and determination of what United States Supreme Court precedent, as applied to the unique facts and circumstances of this case at this time during the pandemic, requires. Once started, payments may not be stopped. The court believes that the 9,000, give or take, people who were caught up in that net, including some people we heard from today, should have been paid. If not by July 28th, then promptly thereafter. So the court finds the state in contempt for that reason and that reason only. The court imposes a $1,000 fine on the state of Nevada. The fine shall be paid no later than 30 days from today, unless there's a stay or a court order. I am doubling down on the court's prior order of mandate. I'm directing the state today to pay those people that I've just identified no later than 3 weeks from today. That being, not lost on the court what day that is, December 24th. Payments need to resume by that date, unless there's a court order extending that period of time, unless there's a court order staying enforcement, unless there's an appellate court order that directs that this court cannot enforce that order. But until and unless such an order results, I'm giving the state 3 more weeks. Now, if I find, and I'm going to set a hearing for the following week, December 31st at 9 in the morning, a week after the deadline. If the court finds at that time there has been a willful failure without excuse to abide the court's order to pay that group of people or resume paying them no later than December 24th, then the court will consider additional sanctions, punishment, or enforcement mechanisms for its order. Look, this court takes no pleasure whatsoever in admonishing the state, particularly when I have time and again commented on the extraordinary effort the people of the state are taking to help those in need, especially during the challenging times, which we all read the news are getting more challenging because of the grip the pandemic has as we all await, hopefully, an effective vaccine. But it's been 4 to 5 months. These people need to be paid. The court believes its order is not in conflict with the Department of Justice guidelines. The court does not intend to put the state of Nevada in financial harm's way. The court wants to get people paid promptly. So those people the court has just identified need to start being paid again no later than 3 weeks from today. The court sets a status hearing on this matter for December 31st, 9 o'clock in the morning. That will be the order of the court. Let me start with the movement, Ms. Jones, and then I'll hear from Mr. Thierman. Is there anything the court may have overlooked at this time?
Nothing from me, Your Honor. Thank you.
Mr. Thierman. And you're on mute, so please unmute if you're going to address the court.
I have nothing further except who do they make the check out to? You, the court?
The check will be made to the clerk of the court unless the court directs them otherwise.
Thank you.
You're welcome. Mr. Ott, well, let me start with Mr. Whitney. Mr. Whitney, any further questions or comments?
The only thing that concerns me, Your Honor, is how soon the $1,000 is to be paid. I don't mean to be funny, and Mr. Ott probably more knowledgeable about this because he's been kind of looking at it. The court probably remembers that. I'm just thinking we might have to go to
45. All right. Mr. Ott, is there any issue if the court changes its directive and has the state make the payment within 45 days of today?
I would have to look at the Board of Examiners and the Interim Finance Committee schedule. I would be fine with the court making that order. If 45 days is insufficient, we could file subsequent notice to the court and let them know a subsequent time.
Thank you. It'll be 45 days from today or the nearest court day. Other than that, Mr. Whitney, anything else from the state?
No, Your Honor. Thank you.
Thank you. Mr. Ott, anything else you'd like to bring to the court's attention at this time?
One thing, Your Honor, and I don't mean to open a can of worms, so please slap me down if you feel should be addressed in a subsequent motion. But when you were listing out your ruling, you mentioned that your ruling was not intended to pay people in 2 different systems. But you also said people must continue to get paid. But there could be a situation where Detr identifies someone who's actually receiving benefits in another state or in another system. That's not technically covered under the court order currently. But and I don't know whether the court even has the ability to amend its order because it is up on review to the Supreme Court. But well, I feel like I need to address that.
Well, I don't think I have the ability to amend the order. Here's what I can tell you. Mr. Thierman and Ms. Jones have argued repeatedly, particularly in early stages of this case, that people need to either get paid under the PUA system or the UI system. And, pay if there's money in UI, they need to get paid there. And if there's not, they need to get paid with PUA. But at this point, the court's order is simply that people need to get paid under the PUA system if they've begun and were stopped. Now, if you're saying, well, what do we do if if they're already receiving money under UI? Or what do we do and the answer to that is, I'm not going to take that up right now. If you have evidence that that's occurring, and the court should consider how to approach that. But right now, I'm not sure the court order on the writ of mandate, the order of mandate is the type of thing that is amendable, but I would look into it if the facts bear that out, and I'll see what the court's jurisdiction is at that time.
Thank you, Your Honor. If it's necessary, we'll address in subsequent motion work.
Okay, but do it fast because
if they really do have a check going 2 places, I wouldn't consider that. I wouldn't bring the contempt. We'll put it that way.
One more, say that again, Mr.
I
Thurman?
said, if they really have a check from another or proof of actual payment from another program, I would not bring a contempt. I would not bring that as a contemptible act.
In other words, if they're getting paid there, that's good enough.
I only want them to get paid once. That's the whole point of this. But once and only once.
All right. Well, Mr. Ott, I mean, we're not going to spend more time on that right now. I understand the concern. If that issue ripens and you want to bring it to the court's attention, please do so. We can even do it on short notice. So we can talk about it on we can talk about it on December 31st at 9 o'clock in the morning, if that has ripened into a dispute. But you've just heard Mr. Thurman identify, at least preliminarily, that if you come back on the 31st and it appears that people are being paid as ordered by the court, other than those that are receiving UI benefits, because that was the essence of what the plaintiffs sought here, then the plaintiffs will likely not ask the court to find the state is in continuing violation of the court order. All right. With that will conclude this hearing. I want to thank everybody and ask you and your families a safe holiday. The court will be in recess. I'll see everyone next December 31st at 9 a.m. Thank you very much, everyone.
Thank you.